Thanks, Amma.
Karnataka? Personal information. But KGA cannot come before us. We cannot take up KGA matter.
My lords,
We will have to move it.
my lords,
We are going in sequence. Please don't interrupt in between. Huh? The respond number 2 is seized and locked. Who is respond number 2? They have seized what property? Why? You should know. We are mentioning you get a chance to make all this. Use the opportunity.
As they are going to file an FIR against us.
Hmm.
And according to that, we are already filed an
Hmm.
against that, again, so in fair notice, they have
Serve a copy tomorrow. Tomorrow. In. Hmm. Your application has been rejected for what reason? But how do we stay tomorrow? Huh. Fresh matter or pending matter? Tomorrow. Don't come in the. What is there? It will come. Yes. For several years. They've been arising for several years. What is the urgency if they're arising? It will come. What is the urgency, Mr. Prince? Yes. Yes, madam.
my lords, small submission. My lords have granted interim order on 6th, my lords, and order to pay process by 7th, that is yesterday. We could not pay due to oversight, my lords, and we have paid it today, my lords.
Tomorrow.
Grateful, my lords.
Dated matter not listed.
Not in fresh matter, I moved a memo yesterday. I brought the directive to be listed today.
Has any compliance to be made?
Nothing, man. It's complete with everything.
Then it would have been listed. There must be some compliance tomorrow.
There is the problem. There's no lookout notice, there is nothing against me.
Where do you want to travel tomorrow?
Dubai, my lord, my wife is not keeping well, my lord. She's on
Tomorrow it will come. Yes. GBA. We are not sitting on LB. It will be LB roster. ಬಂದೇ ಇಲ್ವಾ ಕೋರ್ಟ್ ಮುಂದೆ ನೋಡಿ ಲಿಸ್ಟ್ ಮಾಡಿ
ಇಲ್ಲ ಎಲ್ ಬಿ JM LB ಕೂಡ 6
ಇಲ್ಲ ಅದು ಏನು not been investigated. You know they are not investigated. Day after tomorrow. Yes. All pending matters, irrespective of what you file, will come in seniority. Yes.
Entry's order has been passed against my bank account by the police. Without there being a complaint or an FIR that has been registered.
Tomorrow.
Tomorrow.
Yes, madam. Fresh matter will come in 3 days.
Lordships. It pertains to GMRES, your lordships. Private property na damage ಮಾಡಿದ್ದಾರೆ. White topping work ನಡೀತಾ ಇದೆ. Private property na damage ಮಾಡಿ ಮತ್ತೆ ಇನ್ನೊಂದು ಜಾಗದ ಎದುರುಗಡೆ ಸ್ಟ್ರೀಟ್ ಪೋಲ್ ಹಾಕ್ತಿದ್ದಾರೆ.
ಮತ್ತೆ ಇವಾಗ GB ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
ಇಲ್ಲ GMRES.
Post before the appropriate bench tomorrow. ಏನು? ಅಷ್ಟೇನು ಬರುತ್ತೆ ಕೊಡಿ. It will come in the regular course, madam. If it had been extensively heard, it would have come as further hearing. It's not extensively heard. Just because we ask you 2 questions doesn't mean it is heard. It will come in. It will come in the. Fresh matter is tomorrow.
Serial number 31, my lords.
Yes.
Serial number 31, my lords.
Yes.
Even 31, I'm seeking for a short my lords.
You are appearing for whom?
I am for the petitioner, my lords.
You are for the respondent.
A week's time may be granted, my lords.
Any adjournment will be after 29 July.
A date may be fixed, my lords.
No date before 29 July.
senior citizen.
Then if you are opposing, we won't adjourn. But any adjournment will be after 29 July. At the request of counsel for the petitioner, released on 29 July, interim order is earlier granted, is extended till next date of hearing. It's made clear that no further adjournment would be granted. If arguments are not advanced on that date, petition would be liable to be dismissed for non-prosecution.
Grateful, my lord.
Serial number 29, my lord.
Yes.
My lord, some adjudicating authority has passed a certain order, my lord. We will be placing that on record next week, maybe.
You are for?
Respondent, my lord.
Yeah, we informed the petitioner and the other counsels.
Yes, my lord.
My lord,
Which
I
response?
appear for response, my lord, in this matter. You have
Appear
been
for the
informed, my lord.
respondent number 1 to 6, my lord.
At the request of counsel for respondent number 1 to 6, released on 30th of July.
1 to 6 is RBI, my lord. They appear for 7 to 9, my
Sorry,
lord.
my lord.
7 to 9.
7 to 9.
7 to 9.
Please.
Page number 6, serial number 35 to 41. Page number 7.
42 Miller. 42. Serial number.
ಕರ್ದೇ ಇಲ್ಲ ಅಷ್ಟರೊಳಗೆ ಶ್ರೀಧರ್.
Number 7, serial
Have
number
you
42 to 46.
We informed the respondents?
Yes, ma'am.
42 at the request of counsel for the petitioner, released on 30th. That counsel for the petitioner submits that one of the petitioner has expired. He seeks for and is granted 3 weeks' time to file necessary application to bring the legal representatives on record. Released on 3rd August.
Page number 8, serial number 47 to 53.
Yes. Shri Prasad BS has entered appearance for respondent number 1. Delete the name of Ms. MS Nagamani as that appearing for respondent number 1. Counsel for respondent number 1 seeks fund is granted 2 weeks time to file your statement of objections. Okay? Senior citizen matter. 2 weeks time, relist on 29 July, interim order earlier granted is extended till next date of hearing. Yes? Any adjournment will be 29th. It's submitted that there's a bereavement in the family of the counsel for the petitioner. Relist on 13th July. Try your luck. Already 120 matters are there.
Page number 9, serial number 54 to 60. Yes, sir. Page number 10, serial number 61 to 65. Page number 11, serial number 66 and 67. Page number 12, serial number 68 to 71. Page number 13, serial number 72 to 74. Page number 14, serial number 75 to 80.
75. At the request of counsel for the petitioner, released on 30th July.
Page number 15, serial number 81 and 82.
81, madam. It
Yes,
was
Mr.
to come for preliminary hearing by mistake. It has come in big group. I request it to be taken at 2:30 or at 1:30. madam.
Whatever it's come, we'll take it in that sequence,
The
Mr. Patil.
difficulty was the other day when matter was in the preliminary hearing list. Other side said copy was not served. Actually, it was served in their office, in the central government office.
We'll see if 81 reaches. If we make one change, everybody asks for that change. And do that.
Urgency is there is an order of eviction under the public premises.
We'll see if it reaches.
105.
105 memo for withdrawal reads as under, dismissed as withdrawn.
My lords, with your kind leave, my lord.
Yes, Madhukar?
My lord, serial number 102, my lords. Where 2 weeks adjournment, my lords, have a short inconvenience, my lord.
102.
Yes, my lords.
102 IA 1 of 26 is allowed at the request of counsel for the petitioner, released on 30th July.
Serial number 9.
Interim order may be extended, my lord.
Interim order earlier granted is extended.
Serial number 90, my lord. I for R1. Some inconvenience, my lord. Arguing counsel is not available today. Any date may
Have
be.
you informed everybody?
Yes, my lord.
Who is appearing for R1 now?
Swarup Anand. We have filed memo for
R.
appearance.
Swarup Anand has entered appearance for respondent number 1. Delete the name of Shri Madhukar M. Deshpande as that appearing for respondent number 1. Notice not ordered on R2. Who is R2 in this one?
R1, we have filed them.
R2, who is R2? Released on 30th July.
May I make a submission, my lords?
Just a moment, please. 87? Says Mr. Prasanna Kumar is appearing for CBI. Mr. Unikrishnan is also standing counsel for CBI. ED, Mr. Sole respondent. A memo of retirement has been filed by Shri Prasanna Kumar, granted counsel for the respondent. The memo is accepted. He is permitted to retire from the matter. Shri Unikrishnan, another standing counsel for the Enforcement Directorate, is directed to accept notice for the respondent. Registry is direct delete the name of Shri Shauri HR, Jaikar Shetty, Prasanna Kumar as that appearing for respondent. Counsel for the petitioner to furnish 2 sets of the petition along with annexures on Shri Unikrishnan, released on 30th July. Yes, Mr. Ramana?
Serial number 84, any convenient date may be given, my lords.
84.
84.
IA 1 of 24 is allowed, released on 30th July.
Much obliged.
The request of. Have you informed the respondent?
No, only government is the other side, my lords.
No, Manjunath HD ND is there. His name is shown. No adjournment, Mr. Ramana.
My lord,
Yes.
Manjunath ND, my lord, please.
Any objection for adjournment?
No, my lord. Any convenient date may be given.
I 1 of 24 is allowed. Released on 30th.
Much obliged.
Obliged.
List number 1, fresh matter, serial number 1, Venkatesh Sarbati.
Not followed. And AGA for respond number 1, issue emergent notice to respond number 2, returned by 22nd July,
21st.
21st July.
Serial number 2,
Yes, Ramesh?
B and N mallards is.
Hmm.
Mallards, now the order passed by the Deputy Commissioner granting mallards, other fair price depots mallards except Bamsandra. Mallards, Bamsandra is only in view of the pendency of the writ petition before this honorable court. Bamsandra fair price shop was not allotted to the petitioner society mallards. Now mallards, that order has been passed. Mallards, and subsequent to the order passed by this honorable court, Deputy Commissioner has ordered for other three fair price shopments, excluding this. But since the pendency of this writ petition, this Bamsandra has been allotted.
Which pendency of which writ petition?
Writ petition, they kindly refer to annexure N mallards,
L.
annexure L to 143 mallards.
143.
Yes, mallards, because in annexure N, they quote that mallards, since due to the
143, the order has been passed, that is
yes,
disclosed.
mallards. For that, mallards, this order was passed on mallards, the writ petition order 9/8/2021. Mallards, however, mallards, the order passed allotting the Bamsandra fair price shop in favor of the 6th respondent was on 9/7/2021. Mallards, kindly refer to the last paragraph, mallards. In view of the pendency of this writ petition, mallards, fair price shop was allotted to
last paragraph, what?
Mallards, page 156, annexure N.
156.
Yes, ma'am. Last 2 lines, mallards. ಹಿನ್ನಕ್ಕೆ ಇದಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಕರಣ ಸಂಖ್ಯೆ WPM 13447 of 2020 ರಲ್ಲಿ ದಾಖಲಾಗಿರುವುದಾಗಿದ್ದು, ಪ್ರಕರಣವು ಇತ್ಯರ್ಥವಾಗದೇ ಇರುವುದರಿಂದ ಹೊಸ ನ್ಯಾಯಬೆಲೆ ಅಂಗಡಿ ಪ್ರಾಧಿಕಾರವು ಈಗಾಗಲೇ ಈ ಮಂಜೂರು ಹಂತದಲ್ಲಿ ಮಂಜೂರು ಮಾಡಲು ಅರ್ಹರಿರುವುದಿಲ್ಲ. Now
So you are challenging annexure N
and B, mallards.
There 2021.
Yes, my lord.
What has happened after that?
Subsequent
Annexure L
order.
is page 143 is annexure L, my lord.
Yes.
Subsequent to this order, my lord.
There is an order
Subsequent to this order, my lord, annexure M is passed, my lord. That is, my lord, they have been granted, authorization was given to 3 shops, my lord.
Correct.
However, for 1 shop, my lord, if my lords may kindly see, they say that, my lord, para 1 they
Pendency
say,
of 13447.
there is an FIR, there is a
FIR.
Allade nimma last paragraph, my lord, in page 156, they say that allade nimma samsthe ಕಾರ್ಯದರ್ಶಿ ಮಾರಾಟ ಸಹಾಯಕ ವಿರುದ್ಧ ಈ ಹಿಂದೆ ಕ್ರಿಮಿನಲ್ ಮೊಕದ್ದಮೆ FIR ಸಂಖ್ಯೆ so and so ಅಲ್ಲಿ ದಾಖಲಾಗಿದ್ದು, ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ನಿಮಗೆ ಈಗಾಗಲೇ ಮಂಜೂರಾದರೆ 3 ನ್ಯಾಯಬೆಲೆ ಅಂಗಡಿ ಹೆನ್ನಗೆರೆ, ಕಾಚನಾಯಕನಹಳ್ಳಿ ಮತ್ತು ಹಿನ್ನಕ್ಕಿ ಇದಕ್ಕೆ ಸಂಬಂಧಿಸಿದೆ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಪ್ರಕರಣ ಸಂಖ್ಯೆ so and so ರಲ್ಲಿ ದಾಖಲಾಗಿದ್ದು, ಪ್ರಕರಣವು ಇತ್ಯರ್ಥವಾಗದೇ ಇರುವುದರಿಂದ ಹೊಸ ನ್ಯಾಯಬೆಲೆ ಅಂಗಡಿ ಪ್ರಾಧಿಕಾರವು ನಿಮಗೆ ಈ ಹಂತದಲ್ಲಿ ಮಂಜೂರು ಮಾಡಲು ಅರ್ಹ ಇರುವುದಿಲ್ಲ.
You already have 3 shops.
Yes, my lord.
How many shops do you want?
My lords, actually, my lords, this Bamsandra will come within the view of.
How many shops do you want, Mr. Ramesh? These are largies.
My lords, earlier.
We have asked them to look into this. One society can have only 1 fair price shop. 1 person can have only 1
earlier,
fair
my
price
lords,
shop.
there were 5 price shops to this society. My lords, now, my lords, kindly refer to annexure, my lords, my lords.
Madam, please
My lord,
give
yes,
that
my
full
lord.
statement. We had asked you in another matter. This also we'll ask you.
Please, my lord.
How many fair price shop each society or each individual has in the state?
Please, my lord.
This cannot be that a person has 3 shops.
Please, my lord.
1 shop? Yes, it's
Yes,
a state largies. The other people also who have to be given. Not only you want 4 shops now.
And why, my lord?
My lords, earlier, my lords, there was 5 fair price shops in this society, my lord. Now only on the ground that there was a criminal proceedings initiated against one of the official, my lords, that was cancelled.
Even otherwise, you can't have more than 1 shop. How does it? What rule provides you to have more than 1 shop?
Lords, they are distributing from last 50 years, my lords.
The mistake has happened, then doesn't mean the mistake continues.
And why
There
respond?
are other people also who are waiting.
Lords, the fair price shop will be given to the society.
For individuals, you have made it hereditary.
Yes.
For society, you have made it perpetual. This is even worse for society getting multiple perpetual.
Yes, my lord, I'll speak to
And
secretary.
AGA accepts notice for respond number 125.
Please.
Issue emergent notice to respond number 6, returnable by 30th July. The submission of learned counsel for the petitioner is that the petitioner had earlier 5 fair price depots over which authorization had been given to the petitioner. Subsequently, on account of criminal proceedings, 2 of the
Against the employees, my lords, not against the society.
criminal proceeding against the employees of the society, 2 authorizations were revoked. And on account of the pendency in WP number 13447 of 2020, the authorization was not issued to the petitioner. Submission of Shri B. Ramesh, learned counsel for the petitioner, is that WP number 13447 of 2020 has been disposed on 9th August 2021, and there is no impediment for the grant of the 4th.
Subsequently, my lords, there is an order by the Deputy Commissioner, my lords, after the order passed by this honorable court, remanding the matter to the DC, my lord.
For the grant of the 4th and 5th authorization to the petitioner. This is rather a strange case where one society has 5 authorizations.
Yes.
Learned AGA is directed to secure instruction, make a submission as to on what basis 5 authorizations could be given to one society.
Yes.
More so when authorization is a largesse of the state, which needs to be equally distributed among all eligible and entitled persons. She is also directed to place on record the list of societies and individuals
Yes.
in the state of Karnataka
Please.
with the number of authorization issued to them if it is more than one.
Please. And my
One
lord,
Kodabedi, more than one.
yes, annexure P, my lord, that is the authorization granted to the R6, my lord,
R6.
and they have given
They're not
reasons
disturbing.
why it was given to them. Please,
This PDS, as we are saying, we have told you in all these matters.
please, my lord. They have to come up with something.
You have to formulate a proper policy.
Please, my lord.
You're not formulating any policy giving rise to all these kind of things.
I have put a word to secretary, my lord. I'll again follow up.
Then we see 3 authorization given to one person.
Lords, it is nothing but, my lords, this is a only one village, my lords, where, my lords, it is,
There's nobody else in the village, Mr. Ramesh.
no, my lords. My lords, they are not eligible for that, my lords.
Yes. Next.
Serial number
Much
3,
of it.
Pratik Chandramouli.
Yes, madam.
Appearing for the petitioner. We're here to challenge the order passed by respondent number 2 into
Recovery.
Salary recovery.
There's no interim relief. And AGA accepts notice for respond number 1. National Seeds Corporation.
HR Ananta Krishnamurthy.
The HR Ananta Krishnamurthy is directed to accept notice for respond number 2, counsel for the petition to furnish 2 sets of the petition along with an annexures on the said counsel, released on 6th August.
Serial number 4, SV Giridhar.
Yes, Mr. Girdhar.
Lords, my suit for specific performance was filed in the year 1985 in respect of an agreement to sell of 1983 for a consideration of 2,80,000. Lord, suit was decreed only in 2002. RFA 807 of 2002 was pending.
Yes.
Ultimately, I could file the execution only in 2022. Court sale deed was executed in my favor of 6th of April 2026.
Judgment Kodi.
But I have made it part and parcel of the petition, my lords. Annexure H, page 150.
150. We'll allow this, Mr. And AG accepts notice for respond number 1 to 3. Petitioner is before this court seeking for the following reliefs. The petitioner's father had entered into an agreement of sale dated 8/9/1983 in respect of premises bearing number 2/148, 524,603 and present number 529, situate at Old Taluk Kacheri Road, Bangalore 560053. the vendor not having come forward to execute necessary sale deed, the petitioner had instituted a suit for, the petitioner's father had instituted a suit for specific performance in OS number 1513 of 1985 before the City Civil and Session Judge CCH-17. The said suit came to be decreed on
15th of March 2002, my lords, paragraph 5, I have given the details.
15th March 2002, after it being hotly contested by the respondents, by the vendor. Subsequently,
RFA 807 of 2002 was filed before this court, my lords.
where is that?
That details, my lords, is missed out, my lords, so therefore I made a note of it, my lords.
Have you produced the RFA then?
No, my lords, the RFA came to be dismissed for non-prosecution. We were not aware.
We need that details. You need to give us the details.
May I just file it with the memo, my lords? The
You
final
have
order,
it with you now?
not on a hard copy, my lords. Sorry. I'll file it with the memo.
Basic
2
things if
minutes.
you give us.
807 of 2002, my lords.
RFA 807 of 2002, which came to be dismissed for
8th
non-prosecution
of
on
December 2010, my lords.
8th of December 2010. And you waited 12 years to file execution.
My lords, my father was unwell. My father expired in 2021. 9th of February 2021, LR's filed
Claimed
execution.
that the petitioner father was unwell for a long time and expired in the year 2021. Thereafter, the petitioners, as his legal representatives, had filed execution petition number 1159 of 2022 for executing the decree in OS number 1513 of 1985, dated 15/3/2002. The execution proceeding, in the execution proceedings, commissioner was appointed.
No, my lords. Court, yes, my lords. So the Shiristar was appointed as the court commissioner.
The
Annexure
Shiristar-
E, my lords.
The
Page
Shiristar was
133.
appointed as the court commissioner who executed a sale deed in favor of the petitioner on 6/4/26. When the said sale deed was presented for registration, respondent number 3 had raised an objection of undervaluation, contending that the valuation as on the date of presentation of the document is required to be provided and stamp duty paid on that amount and not on the amount contained in the deed of sale premised on the agreement of sale dated deed of sale executed by the commissioner and not premised on the agreement of sale dated 8/9/1983. This court has considered the said issue while its order dated 4th August 25 in writ petition number 49527 of 2026 and has come to a conclusion that when a suit for specific performance has been filed, which is contested, and thereafter in execution proceedings, a sale deed is executed in favor of the petitioner, in favor of the purchaser, the market value cannot, the increase in the market value as on the date of presentation of the sale deed cannot be mulcted on the purchaser inasmuch as the purchaser was not responsible for the delay in the registration. It is on account of the vendor not registering the sale deed that the litigation ensued, resulting in a sale deed being executed during the execution proceedings. Now, the considered opinion that the said decision would apply on all fours in the present matter, and as such, this court passes the following order. Writ petition is allowed. A certiorari is issued. The order dated 2/6/26 passed by a third respondent, annexure A, is quashed. Respondent number 3 is directed to register the sale deed in favor of the sale deed so presented as per the sale consideration mentioned by collecting the stamp duty and registration
That is
fee.
paid, my lords.
By collecting the stamp duty and registration fee as per the contents of the agreement of sale dated 8/9/1983, if not already paid. the registration process to be completed within a period of 3 weeks from the date of receipt of a copy of this order.
Great. File this with the memo.
File it with
I
the
will.
memo, daily order, memo filed by the petitioner enclosing the order
Judgment
passed
in RF
RF
807 of 2002.
is taken on record.
Serial number 5, Manjunath ND.
Mr. Manjunath, an interim relief, good.
Number ತೋರಿಸಿದ್ರಾ?
Pass over. Let him come because he's asking for interim relief.
Appearing for the petitioner, my lord. Sorry.
Yes, Mr.
My lord,
Manjunath.
please, my lord, sorry to appear through the VC, my lord. I'm very much sorry. My lord, the petitioner has challenged annexure J, my lord, page number 136, my lord. The
130?
Bharat 136, my lord, the annexure J is an endorsement issued by the Bharat Petroleum Corporation Limited, my lord, by asking the petitioner to, my lord, the lessor to confirming, so to make a sublease as a confirming party, my lord. Though in the application, as in the brochure, as in the LOI, no such the condition has been stipulated. My lord, after completion of all formalities, after getting NOC from the concerned departments, so when at the time of issuing the dealership, my lord, the BPCL respondent number 2
You are
asking
doing a
this kind,
you are doing a sublease.
please, my
They
lord.
are only asking you for the landlord to sign it as a confirming party.
My lord, as per annexure G, my lord, respondent number 2 landlord has already issued a consent letter to the respondent number 1, my lord. Kindly see annexure G, my lord. 134, my lord, page number 134. He has already addressed a letter to the, and he has visited the office and he has given the consent to the respondent number 1, my lord. He will be confirming, he will be signed the sublead as a confirming body, my lord. 134, my lord, annexure G.
On what term requires him to be a confirming party? Completely financed. But what term? Do you have a term in your notification saying that he has to be a confirming party? Internal, it should be in the notification. Then don't cancel it till then. Then don't cancel, don't allot it till then to anybody else. Sri N.J. Kumar accepts notice for respond number 1. Who is respond number 2?
My lord is the landlord, my lord, lesser, my lord.
Why have you made him a party? Issue emergent notice to respond number 2 written by 3rd August. Respondent number 1 is restrained from cancelling the selection of the petitioner and or allotting the concerned retail outlet to anyone else till the next date period. We won't be able to have it next week, so you get it properly and file it.
My lord, any date may be fixed, my lord.
Yes, 3rd August.
Serial number 6, A. Madhusudan Rao.
For the petitioner, petitioners are allottees of sites under the Ashraya scheme, my lords. They have been giving representations to the respondents. However, till date, they have not been put in physical possession of the sites, my lords. There was an earlier round of writ petition litigation before this.
Hakkupatra has been issued.
My lords, a Hakkupatra has been issued, my lords. I produced the Hakkupatras of all the parties between annexures A to.
And AGA for respond number 1, 2, 3, 4. Taluk Panchayat Elanka.
MS Devraju.
MS Devraj for 5, 6. Rajiv Gandhi Housing Corporation.
I'll serve it upon Ms. Sumana.
Sumana Baliga for respond number 7. Counsel for the petitioner to furnish 2 sets of the petition along with annexes on all the aforesaid counsels. Released on 28th July.
There are other batch of writ petitions.
When is it?
It is posted before the other bench on July 24th. Adenagide, the classification has changed. That's why it's come before your lordships.
Connect with
WP 8266 of 2020.
8266 idu GM Baralva idu.
Again, that was classified as local body, my lords. Here it is classified as GMRE.
There is no local. connect with so-and-so
Much obliged.
and post before the appropriate bench.
Much obliged.
Serial number 7.
Yes, Mr. Bhatt.
Page number 12.
Yes.
I have paid 42 lakhs for allotment of the site, KIDB site. Allotment letter has been issued in the year of 2022. And thereafterwards, my lord, that we have visited several times, and the representation also given. That site itself is not developed. And my lord, therefore we have sought either allot this by developing the same or alternative or code in KLD.
This is a perennial problem.
Phase 1 and 2 is fully operational in that particular
Have you now uploaded all these things on the website? Find out if this industrial area is also uploaded. People get allotted, then after 4 or 5 years, they are still running around behind you. The commissioner KIDB yarappa.
Ali secretary one anta, which is issued by
Notice for
secretary.
respond number 1 and 2. The submission of the petitioner is that plot number 9, Arovali third phase industrial area, Women Entrepreneurs Park, Ramnagara, which has been allotted to the petitioner, is not developed, and as such, the petitioner is unable to implement her project. His submission is also that his submission is twofold, in as much as the petitioner is willing to accept the very same plot on immediate development being carried out by the KIDB, and or for an alternate plot to be allotted in lieu of this plot. H.N. Vasudev seeks for and is granted 2 weeks' time to obtain instruction and make a submission, released on 28th July.
Yes. Copy I will furnish. Yes.
Serial number 8. Madhukar MD.
Yes, Mr. Madhukar.
Refusal of passport facility to petitioner, my lord. I'm only on one ground, my lord. My lord, on 18/5/2026, explanation was sought from me, my lord, to provide the explanation with respect of discontinuation of passport facility. On the same day, the order has been passed. I request my lords to kindly take the Annex Sharif page number 36, my lord.
36.
Yes, my lord. Annex Sharif page number 36. That is the explanation sought by email, my lord. Kindly take, my lord, reference number, show cause notice, then date, my lord, 18/5/2026. Then, my lord, the serial number C, that is the pendency of the criminal cases. With respect of that, they sought explanation. Now, kindly take, my lord, Annexure A, my lord, the Annexure impugned order. On the same day, they have passed the order. 18/5/2026, they sought the explanation. On the same day.
You've seen it happening on this side.
My lord, I am in the unlearning process now.
No,
I am in the unlearning process.
Other side. Memo of instructions. You given him a copy?
My lord, my submission is that, my lord.
There's serious allegation, Mr. Madhukar.
I will make my submission.
There's a warrant out for you for arrest. Yes.
My submission is that, my lord. Kindly take annexure A, page number 13, my lord.
Yes.
My lord, one line of order. They cannot substantiate their stand by submitting a memo of instruction of 3 pages. Mohinder Gill judgment of the Supreme Court, my lord. Their order has to be, it should stand on its own footing, on its own. And now this explanation, whether
Clearly
it is...
said it, that one line covers everything. They're being very brief in what they're saying.
My
headquarters Sangamir for reissuance of a passport for a period of 7 years, suppressing the fact that a passport was invalid and was already cancelled, disposed by this office. They mentioned that.
My lord, that is the reason why my submission is
cancellation is all the stories they've given here.
Yes,
the basis
cancellation.
But cancellation has been mentioned in annexure A.
Yes, my lord. That is what, without providing an opportunity to explain. Well, where the 18th May, my lord, they have sought explanation on the same day. And now I have to give the explanation.
Now they have cancelled your passport that you are aware of.
Yes, my lord.
After cancellation, you are asking for reissuance without challenging the cancellation.
No, I have challenged
the cancellation.
I have challenged it. It is pending before the High Court of Rajasthan, but I was not given an opportunity to explain.
Then how do we ask for renewal here when your challenge of cancellation is pending in
Yes, my lord.
Jaipur?
In such an event, my lord, as per the government rules, my lord, they are supposed to await for the proceedings. One more thing here is that, my lord, the suppression is with respect of one factor, which already trial court said that there is no suppression. And against that, revisional court passed an order. And matter is pending before the High Court of Rajasthan.
Your cancellation aspect is pending before the High Court of
Yes,
Rajasthan.
my lord, High Court of Rajasthan.
Then you should go to the High Court of Rajasthan for renewal also. Why
But
you
now
come
what
here?
happens is that they have to keep this particular proceedings pending till the disposal of the High Court of Rajasthan proceedings. And now this particular refusal order will come in the way with respect of all other proceedings. My only respectful submission.
Once your cancellation is done, where is the question of renewal? Until High Court of Rajasthan passes an order setting aside the cancellation, there is no question of renewal.
No, there are two ways of looking into it. One is, what is the suppression here is that with respect of an order passed by the Honorable Additional Chief Metropolitan Magistrate, Jaipur Metropolitan First Headquarters, Sangne.
Yes.
That is one thing. That has been pending before the High Court of Rajasthan, my lord. That has become the basis for me to discontinue the passport facility. That particular proceedings is with respect of suppression of fact before the lower court. That cannot be the basis for discontinuation of services.
What discontinuation services? Your passport is only not there.
No,
Where is the
my
question of
passport
service?
is there, my lord. What has happened is that, my lord, I will try to explain. I was residing with my husband at one particular place. Now, when I was residing that particular place, I had applied for this passport. That passport has reached that particular place when I have left my husband. That particular passport was not reached to me. And I was under the impression that the passport has never been issued. And however, I had applied for another passport. When that particular passport was received by me, then, my lord, he made a submission saying that I have suppressed the earlier passport. And for that reason, there is a discontinuation of service. And that particular order has been challenged. And that is what it is pending.
So
I should give an opportunity should be given to me to give explanation.
Please raise all this before the High Court of Rajasthan.
No, my lord, I can't, my lord. The reason is that, my lord, I have to challenge this particular order. If I won't challenge this particular order, I cannot succeed in the Rajasthan High Court also. I should be given an opportunity. And at least an opportunity should be given to me to give the explanation. And this particular memo of instruction, I should be in a position to answer, not before this honorable court. And passport is a serious one, my lord. Restricting my movement.
Serious.
Yes,
and you got 2 passports. That is even more serious.
I was not aware of that fact because he did not provide me. And he is taking advantage of that. And Supreme Court, even in a convicted cases also, my lord, the recent judgment of the Supreme Court, my lord, in a convicted cases also, the passport has to be issued
Mr. Madhukar,
by taking an undertaking.
It is what you are saying is absolutely right.
Correct.
So long as it's only right to travel when the passport is to be reissued. Here is a question of cancelled passport.
No.
That
There is
until the High Court of Rajasthan passes any order, the question of considering this would not arise.
my submission is that, my lord, an opportunity should be given to me.
What
And at least
opportunity? First, you get the order.
No, without, my lord, unless this order, because there is a violation of principles of natural justice.
First, you succeed in Rajasthan, then they can.
No, my lord, I am not on the
until.
basis of the Rajasthan, my lord. I am only on one point. At the first instance only, I made submission that no opportunity has been given to me.
Yes.
18th explanation was sought. On the same day, I have been, the order has been passed. I am not on the merits of the matter or anything. An opportunity should be given to me.
That as a ground. Yeah, you give him an opportunity of hearing. 18th, you issue this notice. That he absolutely has a ground because correct. You give him an opportunity of hearing and then pass orders. You can pass this detailed order, but 18.5 you send an email and 18.5 you pass the same order. That he has a ground.
My lord, one more aspect, my lord.
But we can't say what you have to do.
No, one more thing, my lord. Kindly see, my lord, to which particular address it has been sent. No details has been provided to which address it has been sent. Then, my lord, it is followed by another email, my lord. In that particular email, they communicate me saying that I have not sent a reply also. That is also again on 18th May 2026. Next page, my lord, page number 14.
S. Rajshekhar accepts notice for respondent number 1 and 2. Petitioner is before this court seeking for the following reliefs. Though there are various grounds which have been raised for the purpose of consideration of this matter, only one ground would be sufficient. Inasmuch as the show cause notice in terms of Annexure F came to be issued by the respondent on 18/5/26, and the impugned order at Annexure A, being the order of refusal, was also made on 18/5/26 without affording an opportunity of hearing to the petitioner or affording an opportunity to the petitioner to submit his explanation. Ex facie, there is a violation of the principles of natural justice. In that view of the matter, this court passes the following order. Writ petition is partly allowed. A certiorari is issued. Annexure A, the order dated 18/5/26 at Annexure A is set aside. Respondent number petitioner is permitted to file his objections and or say in respect of the show cause notice at Annexure F. When will you file it?
Within 15 days, my lord, from today.
Within 15 days from today, that is on or before 22nd July 2026. Once the said objections are filed, respondent number 2 is directed to consider the same and pass necessary orders in accordance with law.
Macho.
It won't help you.
Yes.
Until you get that order from Rajasthan.
Serial number 9.
Yes, madam.
LOC matter, my lord.
LOC.
LOC. Set aside LOC. My prayer is that, my lord. He was on bail during a crime stage, my lord, and he was in search of a job. He got a job in Oman, Sultanate of Oman. Then he traveled there.
Pannambur police station. Where is Pannambur?
Pannambur.
Ell baratte?
Mangalore, on the way to Mangalore. It's between
So you not mentioned any district or anything.
DK district.
Yav district?
DK.
Dakshina Kannada. Yes.
He was on bail.
Hmm.
Subsequently, he got a job abroad and he traveled. And then meanwhile, investigation was done. Case was committed. Now it is SC. So to secure the accused, the court issued warrant. And in pursuance of warrant, the police issued LOC. And on his arrival for vacation, he was coming to India. On his arrival at Calicut airport, he is arrested and he is in custody now. And his passport is taken by the police. They have taken the passport and they kept it with them without filing PF to the court.
What is your relief that you are not to restrict petitioner from leaving the country to allow him to travel to
Yes,
Oman?
now he has to travel back also. If it is lifted, now once now he is in custody, on the LOC he is arrested. Now he has to
You are
go
not
back
challenging the LOC here. You are only asking permission to leave the country.
Yes, leave the country and come back whenever it is required. Whenever it is required by the court, he will be present, my lord.
You've been arrested and you're in custody.
Yes.
So how do we direct you to leave without that being decided?
I have filed bail application separately.
But they get that bail.
No, my lord. Now, when this is there, if it is not lifted, he will not be allowed to go back also.
You are not even challenging the LOC in this petition.
LOC is not on record in the court. It is only they have submitted on LOC. We have arrested. The court issued warrant. In pursuance of that, they issued clamped LOC. It is always that way.
File your objection. Who issued LOC in which matter?
Page number 24 is very clear, my lord. Trial court bail order.
And in that it is mentioned. I'll cooperate, my lord.
Condition number 3.
You have not cooperated, madam. You have violated.
Violated.
Instead of cooperating,
That is
you violated.
observation of the court, my lord.
Yes.
Violated in the sense I got a job, I went abroad. Meanwhile,
Very good. Without permission.
Meanwhile, this case is committed and summons was issued. Summons was not
You have
served because he
violated
was
the bail condition. They have issued the LOC. You will have to move that court seeking for lifting the LOC, not before
The
this
court,
court.
my lord, there is an order of this honorable court where it has mentioned that it is directed that no trial court has any authority to
Kodi, judgment Kodi.
that is not Prasanna
And a
sir. Right
violation.
now I don't have, my lord.
If you don't have right now,
I'll submit in the afternoon.
yes, pass over.
Yes, my lord.
This is on account of a violation of the bail condition.
That is a
Pass over.
that is because the NBW.
You place whatever
That
you want.
was because of LOC.
You place your judgment on record.
Yes,
Then
my
we'll
lord.
come.
Yes, my lord.
Serial number 10. Jabran Ahmad.
Yes.
For the petitioner in this matter, my lords, the petitioner is a manufacturer of pharma drugs. Whereas during COVID, my lords, we got a tender in our favor, and through the tender, we got a purchase order for supplying of hand sanitizers. For purchase order for crores and 2 lakhs, my lord. Subsequent to that, my lords, we have supplied and we have distributed the hand sanitizers to the list of places where they have asked us to deliver it. On delivery, my lords, drug inspector.
Initiating recovery proceedings.
Yes.
Whatever defense you have, you can raise it in the recovery proceedings, not
My
for
lords,
a
lords, there are
relief saying
rules.
not to initiate.
Lords, I have not initiated. Lords, as of the moment, my lords, I have been made my representations. Each and every notices which they have sent to me, I have made every representations. But none of
Please
the
see your relief.
Yes.
Your relief is direct respond to drop all consequential impugned recovery proceedings.
Yes.
Pursuant to their legal notice. How is that relief maintainable?
My lords, the issue here is, my lords, if they would have collected the samples and that samples.
That is your defense.
That is the defense.
You raise your defense.
lordship has rightly pointed out. That is my difference. Lords, recovery proceedings based on, my lords, on that aspect, where they are issuing recovery notice.
Can we stop anybody from filing anything? Can we stop you from filing this?
No, my lords. It's
We
a
can only
prohibition.
deal
It's a
with your
it's a
son after you
prohibition.
file. So you
Lords,
file your objections and they'll have to.
yes, we have filed our objections. In spite of that, this legal recovery notice has been taken care, that have been issued.
They'll have to pass orders. They'll pass orders on that.
That is, my lords,
Learned AGA accepts notice for respond number
one submission, my lords.
Yes.
One submission. If your lordship may permit me, just 2 minutes, my
Yearly.
lords, I'll explain it to
Yes.
your lordship. That's in respect of the prayer, my lords. There is, we have they have initiated for recovery, and we have sought for halting of the recovery. One aspect, my lords, your lordship may permit, just to read section 23 of drugs and cosmetics on merits. On merits.
Yes.
Subsection 4.
Yes.
The inspector shall restore one portion of the sample so divided or one container, as the case may be, to the person from whom he takes it, and shall, my lords, I stress the word shall, retain the remainder and dispose of the same as follows. My lords, there are 3 different procedures has been given. One portion or container, he shall forthwith send to the government analysis. It has been done. Subsequently, my lord, second condition is that The second, he shall produce to the court. As of now, no proceedings has been initiated. Thirdly, my lords, it is a very requisite matter. The third, where taken, he shall send to the person, if any, whose name, address, and other particulars have been disclosed under section 18A, which is of manufacturer. I haven't even given a sample of what they've collected and where they've collected. Without even, my lords, providing me the sample,
All
my lords.
factual aspects which we cannot deal with now.
Lords,
You are giving
if
your
they are in a
reply,
recovery
they'll have to
proceedings, let it there be an abeyance. Till then, well, meanwhile, your lordship may grant certain time period. Meanwhile, I'll go with the regular proceedings.
Learned AGA accepts notice for respond number 1.
Sumana Baliga.
Karnataka State Medical.
Sumana Baliga.
Sumana Baliga for respond number 2.
One.
Petitioner is before this court seeking for the following reliefs. The
Not
grievance of the petitioner is that a notice having been issued by the respond number 2 for recovery of certain amounts, there is a possibility of recovery proceedings being initiated by respond number 2. And in that background, the aforesaid reliefs have been sought for a direction to the respondent to drop recovery proceedings. The submission learned counsel for the petitioner is that there is a violation of subsection 4 of section 23 of the Drugs and Cosmetics Act 1940 insofar as the sampling is concerned, and as such no recovery proceedings could be initiated. Any violation as alleged by the petitioner or otherwise is a defense in the recovery proceedings if at all initiated by respond number 2. The same cannot be considered in a writ petition to issue a certified mandamus to directing to quash the legal notice and directing the respondent not to take any action, reserving liberty to the petitioner to agitate all his defenses in the proceedings if at all initiated by a respondent. The petition stands disposed.
And submission maybe.
You're from Chennai.
Yes. That's the judgment of this honorable court, my lords. For the same supplier of mine, there is a stay order, my lords.
It may be that all those are your defenses.
Yes.
Not for us to give a certified mandamus to quash a legal notice. That we cannot.
That is the only request, my lords.
IA 1 of 26 is disposed.
Serial number
Oblige,
11.
my lords.
Sachin BS.
Yes, Sachin.
Unilateral cancellation of birth certificate. Annexure A, Tahsildar.
Unilateral cancellation of
birth certificate which was issued earlier. Pursuant to the complaint given by respondent number 2.
Yes.
Annexure A, page 16 is the order. First, birth certificate was earlier issued at page number 97 on 24/6/2022. 97 was the birth certificate which was issued in my favor, indicating the date of birth on as 10/3/1963.
Page number 90?
97. I'm sorry.
97.
Yes.
Yes.
My lords, Annexure A. Now the same Tahsildar has cancelled the birth certificate, which is under challenge.
There is a certificate issued in 2022 for date of birth of 1963.
Yes.
Yes.
Annexure A, page 16. If my lords look into Annexure A, page 16, Ulleka Vandu.
Yes.
There is a reference which is where the complaint was given by respondent number 2, society, cooperative society. My employer. He gives a complaint, my lords. So Tahsildar acts upon it and cancels it.
He has not been given an opportunity. You'll have to give her an opportunity. If somebody files a complaint, you can't.
Very well.
And AG accepts notice for respondent number 1. Respondent number 2 will have to issue notice. Issue emergent notice to respondent number 2. Returnable by 4th August. If we stay, it comes back alive. That is also a problem.
Please, ma'am.
If we grant the interim order also, there is a problem granting. If we stay this, the birth certificate will come alive.
Yes, sir. But my lords, this order was taken advantage in another proceedings. And my lords, I was terminated from this service. And this document was produced on record In a
Now,
dispute
now
filed
we
by
stay,
the-
you are going to use the stay there. So take out and summons on respond number 2. Petitioner is also permitted to take out emergent notice to respond number 2. Petitioner is also permitted to take out hand summons to respond number 2, returnable by 28th July.
Great.
Serial number 12, Prasanna BR.
Yes, Mr. Prasanna.
Page number 25. But the 2 bank accounts of the petitioner has been seized by the police on the
Within the state.
within the state.
And AGA for respond number 1, State Bank of India,
State Bank of India, Vignesh Shetty,
Vignesh Shetty, City Union Bank,
Prakash Hegde,
Prakash Hegde for respond number 3. The councils for respond number 2 and 3. And AGA as also the council for respond number 2 and 3 are directed to place on record any order issued in respect of the bank account of the petitioner, either debit freezing the said account and or marking lien on the amounts in the said account. Relist on ಯಾವತ್ತಿದೆ ಅದೆಲ್ಲ
State tomorrow.
tomorrow ಒಳಗಾಗಲ್ಲ. Relist on 23rd July. Serve copies on them.
13, Vasudeva Naidu.
Yes, Mr. Naidu. Yesterday, the other matter we could not dictate.
Similar matter to
Similar.
yesterday.
This also.
Similar matter.
Yesterday's matter or different matter?
No, exactly on the same line.
One matter your lordship had left in
We could not dictate because.
68 today.
So, okay, we'll see that. What is this about?
The LOA is at page 45, my lordships.
45.
45, Annexure E. This is dated 9th March 2026, my lords.
This is a contract.
Contract.
9th March, where do we get that? Yes, 9th March.
Then, my lordships, performance notice is at Annexure K at page 277.
277.
This is dated 25/3/2026, my lordships. Annexure K, my lordships.
Yes.
When the performance notice was issued, my lordships, very next day, that is very next page, my lordships, Annexure L, a tender was invited for the same work, my lordships. Without terminating this contract, 27/3/2026, for the very same work, they have issued a retender with a premeditative mind. They have decided to terminate this contract without giving opportunity itself, my lordships.
The clause 3 says we are exercising powers under 7.4 of GCC. If you don't commence your service immediately, failing which further action will be taken as provided in 7.4 for termination. And clause 4 says Railways is free to invite a bid to procure balance services.
Even without there being a termination, they have invited a tender, my lords.
They did not exercise the powers under 7.4.
Now, performance notice they have issued. They have to wait for some time. Whether they make good or not, they fail, they succeed. Without giving any opportunity, they have decided to terminate the tender and go for a tender.
What is the tender for?
My lord, same work, my lord.
Linen.
Same work,
daily
same,
basis.
Same tender.
One day is enough for this. You can't be given more than
my
one.
lordship, this linen, again, there is a provision for extension of contract. EOT provision is there in the contract.
You may have extension.
Even if there is a delay of 1 week, my lordship's work, once the work is awarded or a notice is given, even earlier contract will have an extension provision. Taking over transition period will be there. They have to hand over the things. No, all the contracts they are terminating like this. They're trying to create a monopoly by killing the competition.
This is a
By using that
this is
for 2 years banning, no?
Mr. Naidu, this is a day-to-day contract.
No, day-to-day contract. I fully agree, my lord. There is an urgency. I fully agree, my lord.
If one day you don't discharge, all the trains will come to a stop.
No, it is not linen. This is cleaning of station premises.
You said it's linen.
No, it is not linen, but
What is it? That's why we asked you, what is this contract?
similar contract, but not linen, my lord.
What is it contract about?
My lordships. Manpower-based mechanized cleaning and housekeeping service along with pest and rodent control, garbage collection, segregation and disposal for a period of 1 year at YPR railway station. This is not linen supply. Cleaning of railway station premises.
The entire Yeshwanthpur station.
Then?
No, I fully agree, my lordships. I don't have any dispute regarding the essential services.
Delay.
No, my humble submission before this honorable court is, even when a performance notice was issued.
Have you terminated the contract?
Yes,
Mr.
yes,
Kamath?
my lord.
Yes, yes.
Yes, they
Where
have
is that?
terminated.
Yeah,
That is at
That
annexure.
is what is impugned.
C, my lordships. Annexure C.
Annexure C, page.
Page?
Annexure C at page 33.
$33.
12.5, my lordships.
There is
Till
no
they
page.
finalized the tender, they kept wait. They
Yes,
were waiting. 27, they have issued a notice for tender for the very same work. 25/3, they have issued a performance notice. 27, they have issued a tender notice. After finalizing the tender, they have terminated this tender, or they have decided to finalize the tender in favor of others. They have terminated this tender. Inviting tender when the contract is in subsistence is a bad in law, my lordships. And there is no show cause notice for banning the business.
Yes, Mr. Kamath.
After the main station, Yeshwanthpur is one of the important stations.
Yes.
And this contract was for manpower-based mechanized cleaning and housekeeping. In the contract, there are a couple of clauses which your lordships may have a quick look at. 4.14 at page 200. 200, I still 200, page 200.
200.
4.15.
Double century.
Commencement of services. The contractor shall commence the services within 15 days, unless specified otherwise, after the receipt of an order in writing to this effect from the manager or as directed by the manager. The contract was awarded on 9th of March 2026. So the 15th day lapses on 24th of March. Lordship may kindly make a note of that date, 24th March. So the services must have commenced from 24th March. And your lordships rightly observed, these are all daily thousands of commuters and travelers visit the station. So maintenance of the cleanliness of the station is of utmost importance. The other clause that I would invite your lordship's attention is 7.4 at page 239. If the contractor should, kindly have a look at F, G and H, abandons the contract or
7.4 page?
Page 239, my lord. 239. Determination of the contract owing to default of contractor. In that particularly clauses F, G and H. Abandon the contract or persistent disregard the instructions of the manager or contravene any provisions of the contract, or H, fail to adhere to the agreed program of work by a margin of 10% of the stipulated period. And then finally there is
the right to terminate.
If there is a violation,
Yes.
then I get a right to terminate.
Yes.
Determination, it means I can determine.
You can
Then-
terminate.
Yes. Then, my lord, in terms of facts, there was, please now have a look at page 273, annexure G. On 13th of March, my lord, a couple of days after the contracts was awarded, the petitioner writes to us seeking extension. He says, with due respect, we would like to inform you that the work awarded to our firm is proposed to be commenced with effect from 1/4/2026. We request your good office to kindly take the above commencement date on record We assure you of full cooperation and commitment to perform the work satisfactorily and in accordance with the instructions of the railway administration. And then there was a reply to this, which is in the next page 274. You have requested to commence the work of so and so awarded to you by 1/4/2026. In this regard, you are hereby informed that your request to commence the work from 1/4/2026 Vide letter dated 13/3 is not accepted by the competent authority. You are therefore advised to commence the services as per the agreed scope of work by 24/3/2026.
When did you receive Annexure G?
Lord, considering that we have issued the reply in 10 days, I think we must have received it in a couple of days' time. Lord, I'll find out.
10 days would have been fine.
I'm sorry?
But 10 days would have been fine, but the date of commencement is the next date, 24.
Yes, but there are a few more developments. My Lord, even this date is not significant.
Yes.
Please follow. There are a couple of other correspondences. Then, my Lord, the contractor at Annexure J, page 275, gives the reasons as to why he is not able to commence prior to 1/4. So this he writes on 24th of March. He says, with due respect, we would like to submit that we have received the letter regarding commencement of work for so-and-so contract. Fourth line. In this connection, we humbly request you your kind consideration to permit us to commence the work from 1/4 instead of 24/3. We would like to submit the delay is unavoidable due to following reason: mobilization of manpower, procurement of uniform, police verification, medical fitness certificate, arrangement of machinery, statutory compliance, site familiarization. We assure you that all necessary arrangements are being carried out on priority and we are committed to executing the work. In view of the above, next page, we kindly request your good office to grant us permission to commence the work from 1/4. Your Lordship will notice that no allegation made against the railways, that he says, I'm still working on it. Then, my Lord, we issued on the next page, your Lordships will see Annexure K.
So you said immediately?
Yes, then once again we say, no, please start immediately. And then in the meantime, we issue one more bid document. I will explain it a little later. Then there is a review of his preparedness on 1/4. And during the review, my Lord, then we issue a notice, which your Lordship will find at page 286. Annexure H. Subject: review of preparedness to start the housekeeping work at Yeshwantpur. With reference to the LOA issued to your firm for so-and-so contract, the work had to commence from 24/3. As the work was not started on the said date, performance notice was served to your firm with a reference to this office has received your willingness to start from 1/4/2026. A review of your preparedness was done by the undersigned to ascertain that all contractual obligations related to supply of labor, machines and consumable is as per the tender condition. Upon review, it was found that there are deficiencies pending and the preparedness to start the work is inadequate. Following observations were made during the review on 1/4. Critical manpower shortfall. The most severe deficiency is your human resource planning and deployment. Out of the required 111 staff members, only 80 have been accounted for based on your submitted list. This leaves a deficit of 31 personnel, approximately 28%, which is a major component of this contract. Inadequate consumable. Your stock of bulk cleaning agents and consumable is not as per the contract conditions, with a major shortfall of 150 kg of bleaching powder, 100 kg of lime powder, 660 kg of garbage bags. Inadequate machine. E-cart for the garbage collection, hydraulic ladder are not provided. Pest and rodent chemicals are not provided. Due to above deficiencies, it is understood that your preparedness for starting the work is not as per the contract. In view of this, your request for starting the work from 1/4 is not accepted. Also, you are directed to make necessary arrangement and make good the shortfall.
This was on 1/4.
This is on 1/4. We say you start your work immediately. And then after this, then kindly turn to page number
290.
There is a reply at page 290.
Yes.
Page 290. This is on 2/4. He begins with acknowledging the review. With reference to the above, we acknowledge the observation made during the preparedness review conducted on 1/4. In this regard, we submit our point-wise compliance. required manpower is being arranged, my lord,
Still
not
being
is being arranged and
You
deployed.
want us-
Help, my lord.
Shortfall of staff will be fully met and complete manpower strength as per contract conditions. My last sentence, my lord. Further, we confirm that we will be ready to commence from 6/4. Now he gives a new date with all manpower. 6/4 also would have been accepted. My lord, now, my lord, kindly have a look at 291. This is on 12/4.
Yes.
Last paragraph, my lord. In order to commence the work in all respects and in proper manner, we require some more time to mobilize the resources. In this regard, it is requested to permit to commence the work from 1/5. From, my lord, 1/4 it goes to 6/4. Now it is 1/5. Then, my lord, annexure M, page 292. The last paragraph. You are hereby once again informed that you are not permit for extension of the commencement date to, this is on 16/4. The work has to be started immediately, failing which further action will be taken as per clause 7.4 of the general conditions of contract to terminate your contract and to complete the balance work without your participation. And then he gives a reply on 12/4, in which I have already read out. He says, I will start from on the. Then, my lord, the 7-day notice is issued on 27/4. Please have a look at page 294. 294, I give 7 days notice on 27th of April. Performance notice under 7.4 was given to you on 25/3, but you failed to commence the work till date. You are hereby given 7 days notice in terms of 7.4 GCC to make good the default, failing which further action as provided under 7.4 of the GCC to terminate your contract and to complete the balance service without participation will be taken. If you fail to commence the work on the expiry of this period, a notice of termination of the above contract shall be issued to you, under which your contract shall stand rescinded and the services under this contract will be carried out independently without your lordship. May kindly note the date here. It is 27th of April. So if I add 7 days, it goes to 3rd of March. So 3rd of May. He could have still started on 1st May. He could, if he had rectified
Which he had initially
claimed, then I would not have acted upon this 7-day notice. But still he doesn't do that. Therefore, my lord, I was constrained to terminate by annexure C at page 33. On 12th May, please see the date now. On 12th May, even 11th May, if we had done, we would have accepted. On 12th May, the notice says abnormal delay in the start of work. And then it says, dear sir, with a reference contract was awarded to you so and so. The work has not commenced. Para 2. Performance notice under 7.4 was served to you.
It's the same.
It's the same. So therefore, my lord, ample opportunities have been given. My lord, if he doesn't start the work, my lord, for 1.5 months, my lord, it's a live station. There are thousands of commuters coming.
Yes.
Therefore, my lord, sufficient opportunities given. There is no arbitrary. It's a contractual dispute. So therefore, 226 can be invoked only if there is arbitrariness. If no sufficient opportunity was given, then even in contractual matches, the settled principle is it can be invoked. Now, to answer my learned friend's question, that the tender was issued even prior to cancellation. My lord, the tender process is a long process. First, initially, there is a eligibility. We have to test the eligibility. So we open the financial package much later. So we have started the process. Should we wait until now? If I start the process on 12th May, I'll be able to complete it only in June and July. Why should the commuters suffer still then? So therefore, my lord, in good faith, we had started the process. In fact, we had called till now. We have not. That process is on. We have not completed that. Now, my lord, the challenge to the termination notice has to fail because sufficient opportunity is given. The petitioner is open to invoke the arbitration clause. There is an arbitration clause.
There is an arbitration.
Yes, my lord. The clause number 8, which your lordships will find at page 243.
Yes, there is an arbitration clause.
Page 243.
Your accepted clauses are also
No, the termination is accepted, my lord, but consequences are not accepted.
7.124 runs up.
My lord, the page 243, my lord.
Yes.
8.1 and 8.2, they deal with the dispute resolution. There is an arbitration clause.
7.124 are accepted matters.
Yes, in a manner known to law, I can question it if it is accepted.
That's all, not arbitration.
Consequences only arbitrable. My lordships, there was an election in West Bengal during March, April.
That is
No, fact is that, my lordships. See,
That you knew even before you bid for this. That is not a ground that you can take for a live
before
station.
the
And you are
contract
from
may not be
Madhya
aware.
Pradesh, you are not from Calcutta or West Bengal.
No, labor comes from Calcutta, my lordships.
That's for you to arrange.
No, my lordships. Then,
Now you want us to deal with your termination in this, or you want to
absolutely no, my
raise it in the
lordships.
civil?
No, absolutely no. I am with my lordships. I am with my.
What do you want us to
senior
do?
counsel also. Termination, I am not challenging.
Huh.
But fact is that.
Debarment,
No.
we'll ask them to issue a fresh notice.
What my humble submission is, at Annexure M, my lordships, at page 286, it is not that the contractor has not commenced the work.
That is why we are asking you, Mr.
Commenced
Knight,
the work.
you are free to address.
Yes.
Once you address the argument, we'll have to deal with it. Do you want us to deal with it in this, or do you want to raise it in a civil court?
Are you inviting
Only,
a judgment?
banning may kindly be set aside, but without
That is
there
what
being
we
notice.
asked.
My lord.
Petitioner is before this court seeking for the following reliefs. By way of a termination notice dated 12/5/26, not only was the contract executed between the petitioner and respondent dated 9th March 26 terminated, but also the petitioner was debarred for a period of 2 years from the date of issuance of the impugned termination notice dated 12/5/26. Insofar as the termination of the contract is concerned, this court normally intervenes only in respect of pre-contractual stage. After a contract is entered into, it intervenes in pre-contractual stage on the grounds of arbitrary actions, etc. Once a contract has been executed, the parties are governed by the contractual arrangement arrived at between the parties. In the present case, insofar as termination is concerned, it would be governed by the contract, detailed contract dated 9th March 26, which provides for various remedies for both the petitioner and the respondent. In that view of the matter, challenge to the termination would have to be made in terms of the contractual agreement as per the contract dated 9th March 26. As regard the debarment, the perusal of the papers indicates that though several notices have been issued in respect of performance as also termination, there is no particular notice which has been issued to the petitioner informing and or putting the petitioner to notice about the proposed debarment by the respondent. Debarment having several civil consequences, it was but required for the respondent to have issued a notice indicating the intendment of debarment as mandated by the Honorable Supreme Court in Tata Cellular versus so-and-so. No such notice having been issued, void the termination notice, a debarment could also not have been resorted to by the respondent. In that view of the matter, this court passes the following order. Writ petition is partly allowed. Liberty is reserved to the petitioner to challenge the termination before the appropriate forum in terms of the contract entered into between the petitioner and respondent. The debarment, void notice dated 12/5/26 is set aside. Liberty is reserved to the respondent to issue such notice as may be necessary, informing the petitioner of the intendment for debarment, provide an opportunity to the petitioner to reply to the same, and thereafter pass necessary orders in accordance with law.
Serial number 14.
Yes, madam.
14. Senior counsel is appearing to the VC. Senior counsel is appearing through VC.
Number 14. There's nobody.
Appealable order, my lord, before the authority.
Yes.
Please, Your Lordship. My lords, my lord, we have challenged, my lord, externment proceedings, my lord, order passed under section 55 of Police Act, my lord. My lord,
You were heard by the magistrate?
Please, Your Lordship.
You were heard by the magistrate before the order was passed?
Heard, my lord, but my lord, the entire order is passed only on the basis of police report, Your Lordship. No inquiries conducted, my lord. No
then you will have an appellate remedy under 59.
59 remedy is not an appellate remedy, my lord. It is only, my lord, that order cannot be challenged. My lord, we are enforcing here, my lord, the fundamental right of the accused, the petitioner. My lord, he has been removed, my lord, from his house and put somewhere in remote place.
He's already been removed.
Maharashtra Chatarki police station limit, Your Lordship. Already they have arrested and taken him and put there.
This is an order of 9th March 26, Mr. Pasha.
Yes, my lord. That order is 9th March, but he has been, my lord, taken to custody and kept, my lord, since more than 1 month it is.
When was he taken in custody?
Lordship, month. The date is not clear, my lord, but it is more than 1 month, Your Lordship, that we will ascertain.
If he was taken immediately, we would intervene.
No, not immediately, my lord. Not immediately, Your Lordship. Only
appeal remedy, you should have exercised that.
My lord, Your Lordship may kindly see, my lord, the cases filed which are against this accused, we have challenged, my lord, in the writ petition. For quashing we have filed. This honorable court, my lord, had directed for inquiry because false cases are initiated against him, directed inquiry against these police officers. Because of that, my lord, as a revenge, they have initiated these proceedings. And well, there was a stay order also in respect of one of the case which is initiated against this petitioner. And the writ petition is pending. Well, 2 writ petitions are pending. This police, my lord, respondent police are bent upon him to implicate one or the other case. They are not allowing him to live at all. He is not a person of violent in nature. Only NDPS cases are framed against him, stating that
NDPS is the biggest bane today. Don't say only NDPS.
Your Lordship, that whether he has caused any violent act against society or something, my lord, that there is no such allegation at all. Section 55 for externment, my lord, that his presence in the locality causes very severe danger to the society. That is the criteria. Then no one has lodged any complaint.
On your statutory appellate remedy, you could have exercised that appellate remedy. You are coming before this court after 4 months.
My lord, arrest is in, my lord, arrest is.
You go for the appellate remedy and then come back, not otherwise. You have been heard.
My lord,
yes.
But kindly day after, my lord, your lordship will come physically and submit to your lordship. I could not, my lord, I missed the chance.
Virtually, it doesn't matter, Mr. Pasha. You can
my lord, I will submit, my lord. There are many materials we have to produce. Unfortunately, it has been filed like this.
And AG accepts notice for respondent number 1 to 4. Relist. AG is right to secure instruction, make a submission. Sri Asmat Pasha, learned senior counsel, seeks for and is granted a week's time to place certain other material that he wishes to rely upon. Relist on 21st July.
Any short date, your lordship, that's my lord.
Every day we have more than 150 matters.
My lord, 13th, your lordship, 13th, my lord, Monday.
21st, please.
Serial number 15, B. Pradeep.
Limitation. Limitation disposed.
16, Aditya SK.
General parole. And AGA for respond released on 22nd.
17, Jaiprakash RB.
So Jaiprakash. Paso.
18, Anandavi.
Petitioner, madam.
challenging the writ petition with regard to the interference of the respondent police. What is the Your Honor, I started the
For recreation club.
recreation.
And AG
Bengaluru
for
Vish-
respond number 1, 2, 3. Yavuti there?
13-7. 13-7.
Relist and connect with so and so.
Connected
13-7.
19, K.R. Ramesh.
Lord, I appeal for the petitioner.
Yes, Ramesh.
Lord, in the similar writ petition, very challenge to the very same order, my Lord.
Challenging the
Because-
banking directive, RBI directive for urban cooperation.
10A.
Please, ma'am.
Please. What is the date yesterday? How many matters are there?
My lords, right now there are about 4 matters which
Give a
I'm
full list so
appearing in.
everything could be
My
connected.
lords, it's all connected.
Yesterday there were around 10, 12 matters.
Yeah, my lords, yesterday there were 4 matters which were connected and 2 fresh matters. And today there is one.
The serial number 58.
58, the batch was there, my lords.
Since the order idea kodiyadu.
Please.
ಮತ್ತೆ dictate ಮಾಡಿ.
And the number, Slip pen of approval.
Since the virus of the circular bearing so and so, prayer B. Circular. Since there's a mistake in this. Since the amendment to section 10-A stroke 2 capital A hyphen Roman 1 of the Banking Regulation Act 1949 has been challenged, issue notice to the learned Attorney General. Ms. Nayanthara BG, learned counsel accepts notice on his behalf. She also accepts notice on behalf of respondent number 1, 2, 3.
1, 2, 3, please.
Shri, who was
For
the
RBI, Manik BT.
Shri Manik BT accepts notice, is directed to accept notice for respondent number 4. Learned AGA accepts notice for respondent number 5 and 6. Issue emergent notice to respondent number 7, returnable by, what date did we give yesterday?
August, your lordship.
6th August. Counsel for the petitioner is also permitted to take out and summons in respect of respondent number 7. Respondents are restrained from taking any coercive steps against the petitioner till the next date of hearing. Connect with WP number 17388 of 2026. Much obliged. IA 1 of 26 is allowed.
Serial number 20, Venkatesh D. Dalwai.
Yes, Mr. Dalwai.
Petitioner. My lord, seeking a pass over, seniors on his legs on another court hall.
Lord's annexure A is impugned. Lord's few dates will be, my lord's lordship, 14/5.
This is for elections.
Yes,
We'll
I
file our objections in the matter, my Lord.
Seniors come.
No,
We have to respondent number 1, State Election Commission.
Mr. Po- Ultimately, they'll also have to file their objections, my Lord. Your Lordship may have it on Wednesday or Thursday, my Lord.
Okay, we'll try. State Election Commission yaru?
Vaishali Hegde.
Ms. Vaishali Hegde for respondent number 1, learned AGA for respondent number 2, Election Commission of India,
Mr. Dodwar.
Dodwad. Shri Dodwad for respondent number 3. Counsel for the petitioner to serve 2 sets of the petition along with annexures on all the aforesaid counsels. Learned counsels for respondents are granted a week's time to file their respective statement of objections, released on 15th July.
One
IA
request.
1 of 26 is allowed.
One request, if it is not otherwise, my lord, say, fresh matters.
In preliminary hearing.
Great.
21, Vinayan.
Yes, Mr. Manmohan.
Matter wherein, Lord, the petitioner, Lord, is a surfing champion, Lord. Last year he got bronze, Lord, in Asian championship, surfing championship.
Oh, this is Indian Olympic Association. Yesterday
Yes.
you mentioned.
But we have been trying to contact someone from the Indian Olympic Association, but there is nobody. In fact, yesterday, Lord, we also sent an email asking them that this matter listed yesterday 2:30, Lord, had taken up the
You are
matter.
appearing for whom? Union of India.
And fourth respondent also, my lord, we contacted this morning. They said they have someone in Chennai, and they said they'll give the contact, but they're not given. But what has happened is, my lord, I had approached, my lord, the appellate authority earlier, and the appellate authority passed an order saying that, my lord, how the entire thing has to be redone. And now, my lord, this surfing association, what they do, my lord, there are 4 members. There was no, my lord, unanimity as to what is to be done, because they want to select one particular person. They want to overlook the petitioner.
You are the bronze medalist.
I am the bronze medalist, not last year, and they want to ignore. And one of the
For
selection,
respondent number 5,
but he is the one who's now selected.
has he won any medal?
Not there are not in these kinds of events. In fact, not one of the selection members, the members in the committee, she says, I am not going to participate because this is unfair. She writes an email also.
Where is that?
But that not email not should get it. In fact, next G, if my lord should turn to
Page?
my lord, page 75. But before that, can I take my lords to page 71, my lord? The minutes of meeting on 21st of June 2026. Can I request the court to please turn to page 71? Lord, para 2.
And
the
you
committee
informed
was,
them and they have not responded.
Lord, respondent number 4 we sent an email, 4 or 5. 3 we have sent an email yesterday. 4, my lord, this morning we tried to contact them over call and ask them to give the details. So they have still not given us.
You informed them that the matter is listed today at this.
Yes, we have informed.
Place that on record. Show us that.
That will be a call, my lord, but respondent number 3, there's an email.
Show us the email also. Yarige? 21. Sports, Indian Olympic Association and Surfing Federation of India. Yes.
Please. Lord, para 2, Lord, page 71. The committee was guided to undertake a fresh consideration of objective performance data and to cast its vote accordingly, with the possibility of recommending the surf off as a further tie-breaking mechanism should the deadlock persist. Review objective data and evaluation criteria. Committee reviewed the complied performance data and discussed, among other matters, the methodology for recording podium finishes, the appropriate scope of head-to-head comparison, the treatment of percentile averaging across differing number of events, and weight to be recorded to Asian Surfing Championship 2025 results. Members expressed differing views on these methodology questions. No unanimous consensus emerged on a single interpretation. The committee agreed that the members should remain entitled to exercise independent judgment in assessing the significance of the available data, while acknowledging the Asian Surfing Championship 2025 performance as an important factor for consideration. No, this is only I who got it. In fact, I'll take note of the appeal order where they said this has to be taken into consideration. But they feel not it is conducted in Tamil Nadu, Malappuram. Therefore, I should not give importance to it. That is their understanding. It's an international event, but I am sought to be ignored because of it is conducted there. That is their view. Them not voting. Para 5. Following the deliberation, committee proceeded to vote between Ramesh Budihal and Shivaraj Babu for second confirmed position and first reserve position, with the view each voting member stating objective factors relied upon. Vote resulted in equal division of 2 votes in favor of Ramesh Budihal and 2 votes in favor of Shivaraj Babu. The committee accordingly remained deadlocked, notwithstanding reconsideration of the objective performance data. Following the voting outcome, athlete representative on the committee verbally communicated her intention to resign, citing concerns regarding the evaluation methodology adopted. It was recorded that any resignation would require formal communication to and consideration by the Surfing Federation of India before any consequential action could be taken. The remaining voting members unanimously expressed the view that in the event deadlock remained unresolved, a surf-off between Ramesh Budihal and Mr. Shivaraj Babu would constitute an appropriate, fair and objective mechanism for resolving the impasse.
What is surf-off?
No, surf-off is another competition where then they'll say
actual
competition between the two of them. The committee recorded that the conduct, format, venue, judging panel, eligibility criteria and procedural framework governing any such surf-off would fall to be determined exclusive by the Surfing Federation of India and the competent authorities. Committee resolved that this unanimous recommendation be communicated to the Surf Federation of India for appropriate consideration and further directions. Conclusion: the chair recorded the committee remained deadlocked regarding the selection of the two athlete and first reserve athlete. The athlete representative had verbally expressed her intention to resign with the guidance to be sought from Federation on the implications thereof. Committee views on a surf-off would be communicated to the Federation and the matter would proceed in accordance with the directions issued by the competent authority. But after this, Lord, this was on 21st of June 2026.
Yes.
Then, Lord, the resignation mail is at page 75, where, Lord, she points out the objective with unfair bias, all that is not there. But then please turn to page 78. Now, what they do, Lord, thereafter on 23rd June is they elect on their own and not select this fifth respondent. They say surf-off cannot be conducted because of paucity of time. Therefore, we are doing this and we are going ahead and selecting this person. But can I request, Lord, please turn to page 79.
Yes.
On 3rd June 2026, SFI's selection committee announced its initial selection for Asian Games 2026 squad. This decision was challenged by two appeals concerning solely the men's second confirmed position. An independent appeals panel set aside directed that its selection committee to be reconstituted to retabulate the men's second confirmed position. The panel further directed that in doing so, committee give due weight to the performance at the Asian Surfing Championship 2025 and take into account all international events from 1st January 2025 onwards. A reconciliation committee convened on 20th and 21st of June 2026 to reconsider the matter afresh in light of the panel's discussion. Notwithstanding a full review of the objective record, vote on the men's second confirmed position remained tied. Neither selection policy nor the appeals panel directions prescribe any further mechanism for resolving a renewed tie at the selection committee level. The IOA's deadlines for submission of the names was not capable of extension.
What is the deadline?
For deadline, not
23rd of June 26. It's already over.
Lord, 23rd of June, Lord, this decision is taken on 23rd of June itself.
Yes, now how do we, if the
But
deadline is over,
Lord, they have the power to recall, Lord, and send the names.
we can't give you any interim relief now then.
Maybe, Lord, interim relief may be difficult.
Interim relief is not possible.
But only thing is, Lord, if let them not finalize these names and not send it further.
That we cannot give you.
But on the
The
face of
deadline is
it,
over.
but on, if my Lord only permits me to show this
Already
last,
been sent. We'll have to hear them and see what can be done.
if my Lord will only permit me to read the last two sentences
Yes, please.
there, Lord, it clearly, my Lord, it's an abuse of power. Please
Yes,
see, my Lord, the
that
last.
that will require a separate action,
True, my Lord.
not as regard to selection.
But I'll be made to sit on the bench. Now, I am the one who won, Lord, bronze last year. But kindly see this kind of, Lord, attitude. Where will our sports lead?
That we'll deal with later. Unfortunately, we are unable to deal with it today
I understand, Lord.
because somebody needs to represent the country, right or wrong. And that cannot be changed today.
But the event is in September, is what I'm told. 1st of September. So there's still time, Lord.
Yes. Now we can't restrain them from doing it. You serve it on them, take out your hand summons. Once they come on record, we'll deal with them. This is not the way to treat sportspersons. Normally, we expect that somebody has won, they'll be selected. You don't need to have.
I'm sent as a substitute now.
You don't need to have these kind of things happening in sports.
Surfing Federation of India has to respond. Indian has raised it. If they come, I think.
And they're avoiding to come. From what Mr. Manmohan says, it looks like they're avoiding to come. That's not fair.
But again, today I'll send an email, Lord, to both of them.
Use your good offices and ask them to come. Because that doesn't reflect well on these associations.
What time did you call?
It's also accepts notice for respond number 1, Sports Authority of India. And there's somebody who appears. Last time somebody appeared.
T. Basuraja. T. Basuraja.
T. Basuraja for respond number 2. issue notice to respond number 3 to 5. Emergent notice to respond number 3 to 5. Counsel for the petitioner is permitted to take out hand summons on respond number 3 to 5, returnable by 21st July. Counsel for the petitioner, counsel for respond number 1 is also directed to use his good offices to inform respond number 3 and 4 of the above petition having been filed and requesting them to be represented before this court by the next date.
Not instead of hand summons, not can it be by email, because third and fourth respondent not there in
Petitioner
Delhi.
is also permitted to take out both hand summons and email. It is
In
also
Delhi
permitted
and
to take out.
Tamil Nadu.
Get it done.
Yes, yes.
Where
I don't have a
is
choice.
how difficult is it for you to? Petitioner is also permitted to take out note. The registry is directed to issue notice by email to respond number 3 and 4 at the official email ID mentioned in their website.
Please. Can it be on 15th, Lord?
15th.
Great.
IA 1 of 26 is allowed.
To be listed in preliminary hearing.
15th in preliminary hearing.
Great.
Serial number 22, Vasudeva Naidu.
Yes, Mr. Naidu.
My lord, this is, the petitioner is a landlord, leased the premises to the Union Bank of India, my lord.
It has been debit frozen on your basis and you want the money to be
No,
paid.
see, there are two separate transactions, my lord.
Yes.
I have an account there. This lease is a separate issue, account is a separate issue.
But this cannot be done in a writ petition. 457
My humble
application, you will have to
prayer,
file that.
only to defreeze the accounts.
Defreeze your account.
Defreeze my accounts. Ma'am. They have freezed my accounts. Without any relation.
Union Bank of India?
My lordships at E.
Ms. Divya Puranda is directed to
Our-
accept notice for respond number 1 to 3. Counsel for the petition to furnish 2 sets of the petition along with annexures on the said counsels. She is requested to obtain instructions and make a submission as to on what basis the account of the petitioner has been frozen and to place records in relation thereto. Released on 21st July.
Problem.
23,
Appearing for the petitioner, my lords. Appearing
Yes.
for the petitioner, my lords. And this is with regards to the account defreeze of the petitioner. This the petition has.
Speak in the mic, madam. Pull it down.
Yeah. This is with regards to the writ petition filed for defreezing the account of the petitioner, my
Defreezing.
lords. And in this case, upon the instructions of R2, that is the SHO Mumbai, the bank, that is R3, has freezed the
Mr.
account of the petitioner. So
Xavier, what is the
I,
Hmm?
4,750, my lords.
And you have frozen the entire account. Kotak mine, both of your names are here. Yes. And both of you are not filed wakalat.
ನಾನು ಅವ್ರು ಮಾಡ್ತಾರೆ ಅಂತ ನಾನು ದಟ್ ಇಸ್ ದಿ ಕನ್ಫ್ಯೂಷನ್ ನಾಳೆ ಹಾಕೊಂಡ್ರೆ ನಾನು ರಿಪ್ಲೇಸ್ ಆಲ್ ದಿಸ್
ಅಜ್ಜನ್ ಮಾಡಕ್ ಭಾರಿ ಕಷ್ಟ ಆಗತ್ತೆ ಇದು. Every day there are more than 100 matters. If you adjourn, it goes for a day.
ಅಕಾರ್ಡಿಂಗ್ ಟು ದೇ 4750.
You verify it, tell us by afternoon. Adjourn ಮಾಡಿದ್ರೆ ಮತ್ತೆ it goes for a long day. Pass over.
Information it is.
Whatever amount you received, restricted to that. Pass over.
Oh, bless you.
24, Kalyanar.
Yes. Pass over.
25, Sridhar Prabhu.
Covered by your lordship's judgment, my lord. The debit freezing of accounts, may I, my lord, persuade your lordship?
Any debit freezing. Now,
Radu,
basically,
after your
seniors-
lordship's judgment also, it's rampantly, my lord.
Yes,
sir.
madam.
Judgment.
What you filed objection.
The amount is also not specified. Your lordships will see, my lord, that 3 lakh, ಇದು ನಂದು ಅಕೌಂಟ್ ಇದು ಆದ್ಮೇಲೆ ನಂದು ಯಾವ್ದೋ ಕಂಪನ್ಸೇಷನ್ ಬಂದು ಸೇರ್ಕೊಂಡಿದೆ. ಅದನ್ನು ಇವರು 91 notice is issued under which they have no power to, my lord, freeze the account. And your lordships will see their notice, just because some.
For Indian Bank.
Yes. Annexure C, my lord, they say that.
Just a moment.
Sorry.
Don't be in a hurry.
So sorry.
Where the communication received by you?
Page 30, my lord. There.
There's no communication.
30. No, this is one email supposed to have been sent by Cyber Crime Cell, UP Police, to them. Note that complaint has been registered by the complainant in so and so, and mentioned regarding the unauthorized transactions from the account of the complainant, whose account, what account, that nothing is forthcoming. Complainant's name is forthcoming, complaint number is forthcoming. My name, Lord, how they implicate me in this whole transaction, I don't know, Lord.
That is why we are asking, madam, and you are answering everything.
I'm sorry.
You have become the bank.
I'm sorry.
What is the communication that you have received with regard to their account? And what is the amount to be frozen as per that mark lien or frozen as per that communication? You have said you have acted as per the direction received, but where is that direction? You have not produced that. These are important things, madam. If account gets frozen, they can't lead their life. Please treat this as serious. The counsel for respondent, can you get the instructions by afternoon and place it on record? In Indian Bank, Electronic City, Bangalore.
Same submissions were made. That's why, my lord, I
order sheet. Order sheet.
No interim order also.
Please get it by afternoon. What the documents are. Paso.
Grateful.
My senior is not.
Please ask him to give it to you. You can take a printout and give it to us as to wherever it is available on phone.
26, Prasanna DP.
And for the petitioner, my lord,
Yes,
inclusion of the name of the petitioner in the rowdy sheet, my lord. Here in my lord, he was the ex-employee of the Janata Cooperative Bank. In respect to this, there are cases and counter cases between the two groups, my lord. And in respect
are they pending or disposed?
Two matters were stayed, and 2 matters of 420 cases are 2 cases are pending, my lord. And once they have issued the notice as per Annexure M, my lord, I have replied that. There are plots on 6/1/2026. They have not taken and they have dropped that. There are plots. One more case is registered in the same allegation for the allegation of the 2019 allegation 2026. One more case is registered, and they have now implicated my name in rowdy sheet, my lord. There are no
you should
allegation
submit
of
a representation placing all these things on record.
I have already placed my representation.
Where is that?
I made the representation. I have stated in my petition. Well, they have not given the acclamant, my lord.
Where is that representation? Have you produced the representation?
No, my lord, I have not produced the representation. ಅಲ್ಲೇ ಬರ್ಕೊಡಿ ಅಂತ ಹೇಳ್ತಾರೆ, ಅಲ್ಲೇ ಬರೆದು ಪೂರ್ತಿ ಎಕ್ಸ್ಪ್ಲನೇಷನ್
ಕೊಡ್ರೆ ಅವ್ರು ಬರ್ದು ಕೊಟ್ರೆ ಸರಿಯಾಗಿ ಬರ್ಕೊಡಲ್ಲ, ನೀವು ಸರಿಯಾಗಿ ಬರ್ದು ಕೊಡ್ಬೇಕು.
2 cases are pending, one in Hebbad, one in Vijayanagar, my lord.
That's in
Crime number 161 of 2025 in Vijayanagar police station.
There are only 420.
420 cases.
How do you open a rowdy sheet?
We'll consider, my lord.
You submit a representation. We'll permit you to submit a representation, direct them to consider.
Yes, ma'am.
Petitioner is learned AGA accepts notice for respondent 1 and 2. Petitioner is before this court seeking for the following reliefs. The petitioner is agreed by the continuance of the rowdy sheet maintained against the petitioner. The submission of Sri Prasanna DP, learned counsel for the petitioner, is that 2 of the cases have been stayed by this court, and 2 cases are relating to an offence under section 420 of the erstwhile IPC. If that be so, it would be always available for the petitioner to submit a representation to second respondent, placing all the facts on record, and for the second respondent to consider said representation and pass necessary orders. Reserving liberty to the petitioner to submit such a representation, which shall be submitted within a period of 15 days from today, and once submitted, directing respondent number 2 to pass necessary orders within 30 days from such receipt. Petition stands disposed.
27, Manoj SN.
Petitioner is a practicing advocate. He has represented the client, my lords. He has received a sum of rupees 2,000 rupees to his account. On that count, my lords, my entire account has been frozen.
Entire account.
The account has been frozen. Even
SBI, arrow.
Vignesh Shetty.
Shri Vignesh Shetty for respond number 1. Notice to respond number 2 is deferred for now. Released on 10th. 10th Allah, Jafar? Out of state is 10th. Released on 10th July. Learned counsel for respond number 1. Counsel for the petitioner to furnish 2 sets of the petition along with annexes on the counsel for respond number 1, who is in turn directed to place on record the communication received by respond number 1 in regard to the bank account of the petitioner. Released on 10th.
Like one submission. My name has been wrongly shown as Kilran Kumar. It's a Kiran Kiran Kumar.
Registry direct correct the name of the petitioner in the cause list.
28, Somana KP.
Happy for the petitioner, my lords.
Yes.
That's the petition.
Yesterday we forgot this matter when we got up.
That's the tournament is starting today, my lords.
Yes, where is Mr. Ravi Shankar?
Lords, he is on his legs. He's engaged.
Please get him now. When is the game?
Today,
It's
my lords.
already commenced, my lords. We have already.
My lords, the fixtures for today's games are released, my lords. It is not officially communicated to me, my lords, but they say that the fixtures for today's matches are released, but not for the entire tournament. My lords, this is the manner in which Hockey Karnataka is functioning.
Please get him immediately. Otherwise we'll have to pass orders. Please get him immediately. Pass over.
Serial number 29, Adjournment. Serial number 30.
Lord may kindly peruse the order dated 25/11/2025. Your lordship has passed a detailed order, my lord.
Dated
25/11/2025.
25/11/25.
Yes, my lord. The subject matter with respect to the, my lord, tender regarding the, my lord, remove of the trees by the, my lord, Mysore paper mills. Now, my lord, the state as well as, my lord, central is, my lord, not decide, my lord, with respect to the clearance or remove the trees.
Have been incorporated in the managed plan.
My lords,
Yes, madam.
my lords, in this proceeding, my lords, on the last occasion, the central government had filed a affidavit in response to which the state government also filed its affidavit. My lords, after that, on 16/4/2026, my lords, the center has written a letter responding to the state on the management plan. After that, my lords, there's been no response by
From
them.
the state.
Please,
They
my
are
lord.
waiting for their response.
Please.
My instructions are that they have sent proposal to them, they have not responded.
No, my lords, I have the copy of the letter over here, my lords.
Both of you sort out.
I am
No, my
become
lords, I have a
sandwich, my
copy of the
Give-
letter here.
Give her a copy of it.
Very well.
my lord.
Could it be passed over?
Yes, pass over.
Please, ma'am.
31, Adjournment. 32, Vijay Kumar.
Point number 2 in this case, Lord.
Nimde.
I pressed for a week time to file my statement of objections.
Have an interim order.
And my lord, one more submission.
You are appearing for respond number 2.
2, my lord.
Hmm.
One more submission, my lord. This is a matter, my lord, pertaining to, my lord, referring the matter to the Upalakaktu to conduct an inquiry. And, my lord, the classification must be, my lord, with great respect, my lord, I am making this submission, my lord. Service matter, my lord, this is a classification.
Service matter, I
Please.
What is being challenged here, Mr. Vijay Kumar?
Challenging, my
Not,
lord, the permission, my lord, granted.
Interestment of
Interest-
inquiry to Lokayukta is under challenge, my lord, on the ground that there is violation of section 7(2) read with 9(3) of.
You yourself have put it as yes.
Yes,
Here, and why did it come
that
here?
has been classified as GM, my lord, by the office.
Registry is counsel for respond number 2 seeks for is granted 2 weeks time to file a
Please.
statement of objections. Land Council for Respond number 2 submit that the matter has been wrongly classified as GM Res. It should have been classified as service. Registry to verify and post before the appropriate bench. We can't give date.
Interim order be extended.
That we can do. Interim order earlier granted is extended till next.
Please, oblige me.
33. Vinay Kotappa.
Well, it's 33, 65.1 and 65.2 are connected.
33?
65.1 and 65.2 Mullets. 65.2 Mullet, today morning we settled it before the consumer forum. I can place the proof on record.
65.1 you have settled.
65.2, where Mr. Jadhav is the, that's 333,779 Mullets. So that we have settled today morning at 10:30. And as far as 33 is concerned, we have sent a mail to the client, the consumer. We have not got any feedback.
He's here.
We can sit across the table and work it out.
Why do you send it to the client when counsel is here?
It's now.
You have not even sent the pay, this process.
No, mail is there.
This come third time. This is coming third time in this matter. Before the register also they are not come
And
up.
as far as
what is this matter about? Why is
this is
decision was stayed by the consumer court.
This is
execution.
Yes, they have awards against us.
After National Commission, is it?
Well, one is State Commission, District Commission.
Consumer court has passed an award against that order.
In fact, Mullet passed this particular order.
This is not maintainable before this court.
They have made a state as a party, no, unnecessarily.
You are challenging an order passed by
under 72 Mullets.
Consumer court.
Under 72 Mullets.
What is 72?
Kindly have Mullet the new Consumer Protection Act 72. They were supposed to Mullet file a substantive complaint because the state forum or the district forum assumes is deemed to be a magistrate, Mullet. My contention is, Mullet, in my humble submission, covered by two decisions. One is Paramjeet's decision of this honorable court dealing with the old Consumer Act. Kindly have 72 Mullets. 71 is like.
Now it is the district commission you are agreed by. You'll have to go to the state commission, not come to the high court.
Mullets, may I just take Mullets to 72?
Don't.
Please have the first two lines.
Any of them, we read it 72.
Mullets, just read it with me. Please read it.
Yes.
Mullets, even I thought 72. Please read it with me. Not with 72.
Yes.
I'm so sorry. Whoever fails to comply with any order made by the district commission or the state commission or the national commission, as the case may be, shall be punishable with imprisonment for a term which shall not be less than 1 month, but which may extend to 3 years, which shall not be less than so and so. But 72(1) would come in once I have been convicted. Now I'm not convicted. What they have done is, my lord, they file a 71, which is like an order 21. The commission in question, whether it is district or state, converts it into a 72, which in my humble submission is not permissible in law. Instead of recording oral submissions, records affidavits by way of pre-summoning evidence, which, my lord, under section 200 is not permissible. And simply records an order that, look, because I am not paying, therefore warrants are issued against the director. I am taken in custody. In one of the matters, my lord releases me. And in one other matter, my lord formulates this particular question. If 72, my lord, is read with 3 and 4 of the CRPC, then the procedure to be followed under 72, in my humble submission, my lord, a private complaint will come. 190 read with 200. Pre-summoning evidence will be read orally. Summons will be issued by a formal summoning order, which would be governed by Pepsi Food. Then I would come and enter appearance. In the first instance, my lord, warrants are issued. I can give, my lord, that compilation also, which was handed over when this order came to be passed by my lords. I'll give you a copy, sir. There are two judgments, my lord. In fact, my lord, without going into this controversy, because my lord, in fact, I had appeared before my lord also in matters.
It is very simple, 72. Whoever fails to comply with the order of district commission, state commission, or the national commission, as the case may be, shall be punished with imprisonment for a term which shall not be less than 1 month, but which may extend to 3 years, or with fine which shall not be less than so. So, notwithstanding anything contained in the Code of Criminal Procedure, the district commission, your question of going summons.
No, my lord, kindly read with me, my lord. Notwithstanding anything
District
contained.
commission, the state commission, or the national commission, as the case may be, shall have the power of a judicial magistrate of the first class.
Yes. And
on conferment of such power, the district commission or the state commission or the national commission, as the case may be, shall be deemed to be a judicial magistrate of first class for the purpose of Code of Criminal Procedure 1973. Save as otherwise provided, the offence under subsection 1 shall be tried summarily by the district commission or the state commission or the national commission, as the case.
Now, my lord, Kamlesh Agarwal's
You want to
judgment.
comply with the order, or you don't want
No, no, I want to, my lord. My lord, in fact, my lord's view had.
to? When will you comply?
My lord, may I just say one thing? I've already settled one person.
One person is.
Not
Now we are
But in
concerned.
fact, no, no.
Now we are
Yadav,
concerned with
I've
Mr.
settled.
Rangaramu's client.
Manoj, I realize that. Manoj, may I say one thing? Allow me to sit
That
with
we'll
sir.
consider when we come to 68. And you are not even contacted him.
Manoj, we have
What is
sent
your
mails.
offer?
We have sent mails.
What is your offer?
Manoj, may I sit with my senior and then talk to him? Because I don't want to make a statement and then fall foul.
Paso.
But Manoj, may I just say one more thing, Manoj?
Yes.
Kamlesh Agarwal, Honorable Supreme Court deals with this very issue and says that because of section 3 and 4.
That's why we asked you. You want to settle the matter or you want to argue the matter?
Because we want to settle. But,
settle the matter.
Manoj, we give us some time. Manoj, because if I tell.
Give me an offer now. You can't be saying I'll take time. Then argue.
Manoj, my bona fides are tested the moment I settle one person today morning, despite a stay, my lord. In fact, Malaj had told me that some matters had come before Malaj. Malaj told me you deposit 50%.
For each matter, that person's matter is important. He is not worried about another matter being settled.
I understand.
So what is the offer that you are going to make to the respondent here? You make that offer. Let us see what they say. If they are agreeable, we'll give you time.
I'll talk to my friends. Much appreciated.
34.
Come by 2:30. May I request? Can I come by 2?
Password to that point. This also is a 24 matter. For last 2 years, you are enjoying this.
But 65.1, nobody has appeared.
We'll see when 65 is called.
Yes.
Serial number 34. Nagarish DS.
So Nagarish.
Non-maintained, my lord, summons we have issued under FEMA, that is challenged, my lords.
There's an interim order.
There is no interim order.
It is granted on 18/12. There's an interim.
It's not extended, my lord. Interim order is not.
Till the next date of hearing, nobody has come after that. Ms. Anupurna Bardola has entered appearance for response. She direct delete name of Sri Madhukar M. Deshpande as that appearing for response. None appears for the petitioner. If none were to appear for the petitioner on the next date of hearing, dismissal for non-prosecution. We list on 30th July.
35. Venkatesh Sarvati.
Kindly pass over the matter.
Pass over.
36.
2:30, I have some difficulty minutes, sir.
Matter urgency. ಮಧ್ಯಾಹ್ನ ಆಗ್ಲಿಲ್ಲ ಅಂತ ಬೇಕಾದ್ರೆ
I'll wait, man. I'll be here.
Better start getting ready. Please. ಅವ್ರ ಮೇಲೆ ಎಲ್ಲ ಹಾಕಕ್ಕಾಗಲ್ಲ ನೀವು.
Yes.
ಎಷ್ಟು ದಿನ ಅಂತ ಹಾಕ್ತೀರಾ?
I see.
ಎಷ್ಟು ದಿನ ಅಂತ ಹಾಕ್ತೀರಾ?
Please, I
ಹ್ಯಾಂಡ್ ಹೋಲ್ಡಿಂಗ್ ಮಾಡಿ
Yes. Please, ma'am.
36. SB total.
Respondents 24 million. Not against the order passed under section 16 application.
ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕಾ ಅವ್ರು ಮಾಡ್ಬೇಕಾ?
Let them.
Yes.
The petitioner made an application under 16(2) of the Arbitration and Cancellation Act, questioning the jurisdiction of the arbitrator. The arbitrator rejected the application, Malots. There are 16(2), Malots. Yes, Malots, I do agree, Malots. But the thing is, my lords, there are several litigations pending. There are two suits pending with respect to the same property which has entered into a joint development agreement. And the vendor of this respondent, my lords, they have created two sale deeds with respect to the same property.
Aitu. No appeal shall also lie to a court from an order of the arbitral tribunal accepting the plea referred to subsection 2 or subsection 3 of section 16. You will have to wait till the culmination of the arbitral proceedings and then raise it under 34.
But there are several litigations pending, my lords, which were not disclosed to me.
But the statute is very clear, Mr. Thotter.
But I have raised the ground in the written statement, my lords, stating that the arbitrator has no jurisdiction.
You can raise all of it. Now it has been rejected.
My lords, but the provision says before filing the written statement that, my lords, may go through, my lords, a plea that the arbitral tribunal does not have jurisdiction shall be, a party shall not be precluded from raising such a plea merely because that he has appointed or participated in the appointment of an arbitrator. My lords, in the statement of objections which I have
raised it.
I have raised the.
After that, what happened?
After that, my lords, I made an application, my lords. And that application came to be rejected.
Rejected. Clause 5 says the arbitral tribunal shall decide on the plea referred to on 2 and 3, where the arbitral tribunal takes a decision rejecting the plea, continue with the arbitral proceeding and make an arbitral award. You can't raise it now. Only if it was allowed can a 37 appeal be filed, not otherwise.
But not even a single word regarding the pending litigations, my lords, and even in the claim petition, he has not stated.
Writ jurisdiction cannot be exercised in arbitral proceedings. You know that.
Covered by your lordship decision in the case
My
of
lords,
G. Sridevi and others. Same.
And there are two sale dates, my lords, where the respondents went.
That's all on merits.
Please, my lords.
And moreover,
you lead evidence on it.
Yes, my lords.
Moreover, they filed a counterclaim, my lord. Counterclaim filed. Please look at page 48.
Yes, my lords, I filed the
Counterclaim. Once the counterclaim filed, my lord, even the CMP will not allowed.
We won't make any observation on that.
My lords, one thing. Let an issue be raised with the point of jurisdiction, my lords, and they have not made as a parties who are party to the litigants.
All that you have raised, issues will be framed.
The
evidence already commenced.
My lords, with respect to that additional issues,
We cannot tell the arbitrator what issues to raise. It's for the arbitrator to raise it. In arbitration, there's absolutely no interference.
Let the liberty be raised, my lord, so that I can raise additional issues.
You raise all the things. Petitioner is before this court seeking for the following reliefs. An arbitral proceedings have been initiated by the respondent. The petitioner being the respondent in those arbitral proceedings had raised an objection as written statement as regards the maintainability of the arbitral proceedings. Subsequently, the same was followed by an application having been filed under Section 16 of the Arbitration and Cancellation Act to dismiss the claim petition on the ground that the arbitrator did not have jurisdiction to decide on the matter. The said application came to be rejected via order dated 14/3/25. It is challenging the said order of rejection that the petitioner is before this court. This court has dealt with the aspect of maintainability of a writ petition on an application under Section 16 of the Arbitration and Cancellation Act 1996 being rejected, while its order dated 10 June 2026 in WP number 10641 of 2026. And this court has categorically come to a conclusion that on a conjoint reading of Section 16, 34 and 37 of the Arbitration and Cancellation Act makes it abundantly clear that an order rejecting a jurisdiction plea under Section 16 is not intended to be independently challenged during the pendency of the arbitral proceedings. Para 28. Hence, the present writ petition, not being maintainable, is disposed of in the following terms. Liberty is reserved to the petitioner to raise all its disputes in the pending arbitral proceedings. All such disputes shall be considered by the arbitrator before an award is passed. Liberty is reserved to the petitioner to challenge the order passed under Section 16 in a proceedings under Section 34, if and so filed by the petitioner.
A disposal had some direction, time frame you have to sign.
We can't. That is already there in the Act. Yes,
Previous matter was
35.
34.
Previous to previous one. Yes. You adjourned it because you are not there. 30th. No?
30th.
30th. Huh?
Yes. Serial number 37. N.R. Nayak.
Mr. Naik.
37 by my Lordship's order dated 1/6/2026. Directed to secure instructions as to what had happened to the application filed by the petitioner at Annexure G.
But this is that alternate medicine.
Yes. His application was rejected, saying he didn't have proper qualification.
When was it rejected?
My Lord, it was rejected in 2022 itself. Sorry, in 2018. 2018, and he gives an undertaking in 2019 that he will not practice on a stamp paper.
None appears for the petitioner.
Next.
In compliance with the order dated 1/6/26, and AG submits that the application filed by the petitioner was rejected, while order dated
Deputy Commissioner, my Lord, rejected it. Thereafter, my Lord, he approaches the board.
What is it?
Board is rejected on 39/2025.
On 7/2/20. No, this not this. Where is the undertaking?
Undertaking, my Lord, is the last 4 lines of the first page.
Had been rejected way back on 28/1/2018, and subsequently undertaking had been furnished by the petitioner that he would not practice in that particular field, while an affidavit dated 31/1/2019. His submission is placed on record. If none were to appear for the petitioner on the next date of hearing, dismissal will be released on 30th July.
Great.
38. Nandish Patil.
Respondents, my lord.
Mr. Nandish Patil.
The writ of mandamus to consider the representation, my lord. We have considered, my lord, and issued a response.
You are considered. Idallama.
At annexure,
17308.
My lord, a small submission.
Yes.
The name of Rakshita DJ may kindly be deleted, my lord.
This Amrita Varshini MC has appeared for respond number 224. Delete Rakshita DJ as that appearing for respond number 224. You have considered the representation.
please, my lord. Annexure R1 at page 14, my lord, of my statement of objection. The representations, my lord, were basically asking for release of payment of outstanding dues and return of bank guarantee, my lords. Insofar as the outstanding dues, it is our statement that we have already cleared the dues. Insofar as the bank guarantee is concerned, my lords, we have stated that there's another writ petition which is pending, and that would be contingent on the outcome of the writ petition because there is a blacklisting order, my lord. And my lord, contractually, I am entitled.
So your basic submission has been considered and order at annexure R1.
Please, my lords.
None appears for the petitioner. The counsel for respond number 224 submit that the representation submitted by the petitioners in L series and M series have been considered and order passed on 23rd December 25 as per annexure R1. Her submission is placed on record. If none were to appear for the petitioner on the next date of hearing. Dismissal for non-prosecution released on 30th July.
39.
It's petitioner is covered by judgment. my lord.
Covered by which judgment?
Please.
My lord,
There is a BCC.
quarterly updates, my lord. My lord, this is a judgment.
Quarterly
Quarterly updates.
So far as their request for
circular has been held to be arbitrary.
Yes, my lord.
Circular 3/9/2020.
My lord, I
This
passed
fi-
on the judgment.
This is final.
Yes.
Sorry. What is this?
That cover. That's
Same
the
order.
judgment. Yes, my
Same
lord,
order.
same order.
You keep it with the why
Yes,
waste.
my lord, I'll keep it.
Petitioner is before this court seeking for the following reliefs. Both the learned counsel for the
So
petitioner.
far as their representation, when they may give the representation for renewal, my lord, we'll consider that second prayer, my lord, as per the representation.
Learned counsel for the petitioner and the respondent submit that the list in the above matter is covered by a decision of the coordinate bench dated 19 September 25 in WP number 3379 of 24 and other connected matters. They submit that the said judgment is attained finality and there is no appeal which has been filed in relation thereto. This court, while the aforesaid order dated 19 September 25 in WP 3379 of 24 considered the virus of the circular dated 3/9/2020 at Annexure A and held that the same is arbitrary, illegal and void. The said order would be equally applicable to the present matter. Insofar as the renewal of the certificate is concerned, an application, you have filed an application?
File, my lord.
We could, otherwise we could impose the same penalty by taking steps under law, my lord.
Is concerned, learned counsel for the petitioner submit that an application for renewal would be filed within 15 days from today.
Please. my lord.
In that view of the matter, this court passes the following order. The circular having already been quashed, and the circular dated 3/9/2020 bearing so and so at Annexure A, having already been quashed, no further orders are required to be passed.
But we can impose the same, the quashment of the, will not come in the way of imposition in,
Of legislation,
or there is some clauses in the act, my lord, where we can
that is up to
issue
you.
notice and, yes, my lord. So we can still do it through,
Not under this circular.
not under this.
If an application for renewal is filed by the petitioner, the same shall be considered and disposed within a period of 30 days from the filing of such application for renewal.
Serial number 40. Mohammed Naziruddin.
Yes, Mr. Nasiruddin.
Petitioner.
Yes.
Regarding issue of death certificate, the petitioner before my lord is the father of the deceased, Guru Nanak. My lord, he married the fourth respondent.
Yes.
The deceased married the fourth respondent on 21/10/2009.
Yes.
And mutually they had decided to separate themselves without approaching the court. Because they are all educated people, they thought that they don't want to go to the court. Therefore, on 6/9/2016, they separated.
Yes.
Unfortunately, the son of the petitioner, he passed away on 22/1/2025. Your Honor. I have stated in para 6.
Yes.
Thereafter, he applied for death certificate. Your Lordship, kindly take at page 15. At column 5, my lord, they want to mention this. what the petitioner, who is the father of the deceased, he says that she is no more the wife of the deceased. The question of mentioning this will not arise. They say that there is a law to that, and my lord, the section 15 of the Birth and Registration Act clearly says that it can be done. Corrections can be done.
Corrections by removing the wife's name.
No, not wife's name. Why? What we are mentioning that she already divorced, and also my lord kindly appreciate.
There's no divorce. They are separated, is what you say.
Yes, separated, and
Separation is not
and
divorce.
no, separated in the sense they had decided to put an end, and even she has not attended the funeral.
Mr. Nasiruddin, whatever that may be, whatever the disputes may be, they may be fighting 100 litigations,
Yes.
but the marriage would subsist.
No, even that's why I made the fourth respondent
The
also.
100 litigations happen because of divorce to be granted.
Yeah, that is there.
So whether
Well,
she comes for the funeral, doesn't come for the funeral,
No,
the
she has not
relationship is
attended.
good or not, unless you show, unless you are able to place on record a decree of divorce granted by a competent court.
They have not approached the court, my lord. To be frank, they have not approached the court. The only thing is, from as I submitted to my lord, that from 2016, they are living separately, and also she has not attended the funeral.
Her name cannot be deleted on that.
And, what we are mentioning is that they are living separately. That is to be mentioned.
They are no authority to mention all those things.
And
they cannot mention any of, nor can we, unless there's a factual finding.
But they have kindly see the police what they have mentioned, my lord.
All these would arise only if she makes a claim.
No, she is not making any claim.
Then why are you worried?
And the only point is, since she has the father of the deceased, he said, who is the petitioner before my lord, his grievance is that in spite of her informing, she has neither her parents nor she attended the funeral.
It's an emotional issue.
Emotional issue, that's true.
Which turns into an ego issue. But that cannot be a reason for deleting the name.
What we are mentioned, we have requested the corporation authorities that in that column, if you are mentioning the name of the wife, that they are living separately, that kindly be mentioned.
Can't be that.
And also she has been made a party to the proceedings.
She has not come.
She has not come, my lord.
That's fine. That doesn't mean an order can be passed against her. Because if you are able to show us, which you said very frankly,
there is no decree of the court. There is no decree of the court. My only request to my lord is that they are living separately. After decided what they had done, my lord, all the family members, so they sat together and they had decided, to have a divorce of the.
We don't need to tell you.
Earlier
that's
in
not
village side, it was happening, my lord. My lord is well aware in village side how it was happening.
But these are all educated people staying in Bangalore, not in village side.
Nowadays, it is there are rulings that there must be a decree of the divorce.
Petitioner is before this court seeking for the following relief. Petitioner is the father of one Sri K.S. Gurunath Murthy, who expired on 22/1/25. The said Gurunath Murthy had been married to respondent number 4 on 21/10/2009 as per Hindu customs and usages. They led their lives together as husband and wife initially, but however, there being difference of opinion between them, on and from 6/9/2016, it is contended that the relationship between the deceased Gurunath Murthy and respondent number 4 ceased and they started living separately. Unfortunately, Gurunath Murthy expired on 22/1/25 when an application was made by the petitioner father for grant of a death certificate. The official respondents insisted on adding the name of respondent number 4 in the application at CL number 5A, it is agreed by same that the petitioner is before this court. Shri Mohammad Nasiruddin, learned counsel for the petitioner, submission on this is twofold. Firstly, that the deceased Gurunath Murthy and respondent number 4 having separated voluntarily on 6/9/2016, that separation is akin to a divorce, and as such, the name of respondent number 4 who is separated from the deceased who is not required to be added in the application for the purpose of issuance of the death certificate. Secondly, he submits that even if her name were to be added, there could be an endorsement made in the certificate so issued that the deceased and respondent number 4 had separated from the year 2016. Neither of these requests having been either of these requests could have been accepted by a respondent, which would have resolved the grievance of the petitioner. Heard, peruse papers. The aspect of marriage between K.S. Gurunath Murthy and respondent number 4 on 21/10/2009, as per Hindu customs and usages, is pleaded by the petitioner himself in para 5. The marriage having been recognized to be valid and accepted to be valid by the petitioner. Subsequent to such a valid marriage, the petitioner, the deceased and respondent number 4 started living separately from 6/9/2016. Though they lived separately from the year 16 till the expiry of Sri Gurunath Murthy in the year 2025, the fact remains that there is no decree of divorce granted by a competent court of law in a manner known to law so as to be recognized by the official respondents.
1, 2, 3. Respondent number 1, 2, 3.
By the official respondents. When there is no such decree of divorce, for all legal purposes, though not for practical purposes, respondent number 4 would continue to be the legally wedded wife of Sri K.S. Gurunath Murthy. Column number 5A reflects the details of husband/wife's name to be added. Since she continues to be a legal wedded wife, there would be a requirement to provide all such details as are required under the said form. They could not, the rejection of the request made by the petitioner on this account does not suffer from any infirmity. Insofar as the second contention that the respondent number 4 has started living separately from 6/9/2016 to be added in the said column, the official respondents are not judicial authorities but are administrative authorities who have to only fill in the details as are required in terms of the applicable form. No additional details as that sought for by the petitioner are contemplated, nor could they be added in the said application for the purpose of processing. The above discussion of this court is only for the purpose of issuance of the death certificate and does not in any manner relate to or decide any right of respondent number 4 and or any defense that the petitioner may have as regard the said defense. This being more so since respondent number 4, though served, has chosen not to appear in these proceedings. In the above circumstances, no grounds being made out, the petition stands disposed, directing the respondents to consider the application with the details as furnished and issue necessary death certificate within a period of 30 days from the date of receipt of a copy of this order.
Forty-one. Syed Khalil Pasha.
Madam, he has questioned that one notice, annexure A, but that stage is over. They have
Subsequent to this honorable court order, they held a spot inspection and
The petitioner owned, my lord, 13 into 13 feet of land, my lord, next to a temple. Was
We
this
cannot
contention?
consider it on merits, but what certiorari has
Yes.
asked.
notice annexure
Challenging
A,
that notice is exhausted, my lord. We've already taken possession.
because this court
But I'll
has,
just pass on.
this court
Delivered a
said,
notice.
equally, this court has said
None
that
appears for the petitioner.
to hold, to conduct
But
inquiry on
the
27,
AGA has also
25,
the
7,
counsel
25.
for respond number 5 submit that what is being challenged is only a show cause notice.
Appear for the petitioner, my lord. Sorry, my lord. Appear for the petitioner.
Yes, please. The show cause notice subsequently has been acted upon and possession taken on 7/4/26.
Photographs are also.
No, my lord. As per the order, your lordship, please kindly see. As per the order passed by this honorable court dated 24/7/25. The
That is subsequent to
24/7/25, my lord.
24.
The
What is the
7/25,
date?
my lord.
25/7.
25/7.
Yes, 25.
2025. This honorable court directed the respondents, my lord, to inspect and collect the document and measure the property in question, my lord. Accordingly, my
Yes.
lord, they have not complied the direction issued by this honorable court.
This direction has not been complied till now.
Not complied, my lord. Last occasion, Deputy Tehsildar is appeared through VC, my lord, but he submitted, my lord, before your lordship that he has handed over all the document before the respondent state, my lord.
I have, my lord, now placed the report before your lordships, my lord. That is the report which I have now filed.
As per the order, detailed order passed by this honorable court, it is not complied, my lord. Only as per their whim and fashion, they have went and measured and furnished the report, my lord. I will
There are
file my objection with regard.
There are photographs, my lord, which show that we have demolished the encroachment already, taken possession of that property and handed over back to the Mujrai, my lord. It belongs to a temple.
The order which had been passed on 24/7 by the coordinate bench
Yes,
is that
yes, my lord.
measurement of the site, fixing of the boundaries, and encroachment would be done on 25/7/25 at 11 a.m.
Yes, my lord.
Has that been done?
That's been done.
Where is the report for that? Where is the sketch for measurement?
Lord, the
fixing
Mahazar is not
boundaries?
produced, my lord. I'll place that.
Place that on record.
Place that.
Madam, your lordship, please kindly see several dates they have taken, my lord, and another one date is another order is also passed, my lord, by this court. In spite of that, my lord, they have not furnished the report, my lord. Last occasion, this honorable court directed Tehsildar to appear before the court. In spite of the direction, Tehsildar has not appeared and submitted the document, my lord, before this honorable court.
The last date, my lord, the Deputy Tehsildar appeared.
He appeared through
Yes,
VC and
VC
submitted that
yes.
he's handed over the papers.
Papers,
So if he's handed over, why are you not?
That is the report, my lord, that they have submitted
Not
to
the
me, which
report.
is not sufficient. I'll, my lord, get it.
Then we'll have to again request the Tehsildar to come.
I'll have it next week.
Yes,
I'll
my lord,
verify whether they've done a proper job. If they haven't, my
When
lord,
he made the submission on VC, we accepted the submission.
yes, my lord.
All
I'll
in
report it.
compliance with the order. But if he has not handed over, it's not in compliance.
Please.
And it's been 1 year.
I understand.
And now you say you're taken possession. But despite the order
In
having been
spite
passed
of
by.
my lord, oral order is passed by this honorable court, my lord, not to demolish the property in question. In spite of the oral direction, my lord, they purposely intentionally demolish the property in question, my lord.
There is no
Without
interim order.
inspection, the property in question.
We can't go by any oral order.
There is
We'll
no
go
interim
only by
order,
what is there on record. The record only indicates that there was an inspection.
Mahazar had to be conducted. That's it.
Wide order date 24/7/25. The coordinate bench of this court had directed the measurement at the site, fixation of boundaries.
My lord, sorry, my lord, sorry, my lord, interpretation, my.
Yes.
One more order is there, my lord. After this order, also one more order is passed by this court.
Yes, we are going to refer
That
to
is-
all of them.
Only, okay, okay.
Or in the presence of the petitioner on 25/7/2025 and directed the petitioner to be present at the property. Subsequently, the matter was adjourned on several occasions when it was taken up on 9/2/26, another coordinate bench of this court observing the submission, taking into account the submission made by the counsel for respondent that the property had been surveyed, demarcated, and encroached area demolished, and observing that the order dated 24/7/25 had not been complied with, directed the Tahsildar to place on record copies of the survey and demolition proceedings pursuant to the court's order dated 24/7/25. Thereafter, again, several adjournments were granted. This court on 9/6/26, observing that the order dated 24/7/25 and 9/2/26 has not been complied, directed the jurisdiction Tahsildar to be personally present before this court. Though the jurisdiction Tahsildar was not personally present, he appeared through video conferencing on 29/6/26 and submitted that all the documents had been handed over to the learned AGA. Today, the learned AGA has placed on record, filed it along with a memo, a letter dated 13/8/25, which encloses certain other endorsement and photographs. The same ex facie is not in compliance with the order dated 24/7/25, inasmuch as there is no survey of the property conducted, nor are the measurements of the site made, let alone fixation of the boundaries. One final, though no opportunity is required to be extended, one final opportunity is granted to learned AGA to comply with the order dated 24/7/25, relist on 20. You not filed your objections. You are appearing for whom, madam? Respond number 2 is Union of India. Union of India. Respond number 1 is also Union of India. That's why we are asking you. 1, 2, and 3 are the Union of India. We will file for all 3 of them. Learned counsel for respond number 1, 2, 3 seeks for and is granted. Ms. Sumati has entered appearance for respond number 1, 2, 3. Delete the name of she and DSG has that appearance for respond number 1, 2, 3. Ms. Sumati has seeks for and is granted. 3 weeks. 3 weeks time to file a statement of objections. Objections, if any, to be filed on or before 4th August, failing which will be taken as not filed, matter proceeded with. You want to file any objections? Relist on 10th August.
45. P. Latif.
Mr. Latif.
There is no instruction, my lords. Kindly have it on next date, my lord. Any short date, maybe.
No instruction, tender matter, Lena.
Please, my
is
lord,
it
tender
pending
matter.
or what is it? It will survive. There is no interim order.
Matter pertains to minor and minerals, my lord.
Minor minerals.
Please, my lord, it has to go to Court Hall 1.
Can't be with us. Sandblocks.
And fresh tender is also called.
Papers indicates that the matter relates to e-tender relates to e-tender, which in turn relates to sand blocks, which is a minor mineral. Registry is directed to place the, but there's a tender.
But pertains to
block will
minor,
not go.
there is a notification, my lord, that all
10.
matters pertaining to minor, it has to go to
Section
court.
10.
Please, my lord.
Registry is directed to verify and place the matter before the appropriate bench.
Please.
46, Madhukar MD.
46 and 46.1 has become infructuous because already tender is given to KSCC.
46 petitioner is before this court seeking for the following leaves. Shri Venkataraman and counsel for the petitioner on instruction submit that the tender has already been allotted.
KSCCF.
Full form
Both
rendering the above petition infructuous.
Both 46 and 46.1 same department.
Separate orders. Placing the said submission on record, the above petition stands disposed. 46.1 same order. IA 2 of 25 stands disposed. What about 46.2?
46.2 is wrongly connected. Mr. Sarthi is appearing there.
Mr. Sarthi?
I'm appearing for the
Yes.
I need a time allowed. Any date may be fixed.
You need time.
Interim order may be fixed.
Interim order is there, 46.2.
Yes.
You filed your objections, madam?
I'll file, my lord.
Learned counsel for the petition seeks for a short accommodation. Learned AG also seeks for 2 weeks' time to file a statement of objection. Objections, if any, by 30th, released on 6th August.
47, yes, Rajshekar.
Survive now, my lords.
Tender condition.
This matter may not survive.
There was no interim order, my lord. Subsequently, work order has been issued. That has been challenged. To be tagged along.
A separate petition?
Separate.
That may be tagged along with.
Tagged in, other will consider separately. Why should it be
Subject
tagged?
matter, my lord, tender condition has been challenged.
No, if a tender has been allotted, those will be grounds to be separately considered in that matter, not in this
It may
matter.
be tagged along with and considered same. Along with same.
This may not survive.
Petitioner is before this court seeking for the following leaves. A work order having been issued, the said work order has been separately challenged, rendering the above petition dismissed. Insofar as challenge of the work order is concerned, the same would be considered separately.
48, Subbareddy.
Last occasion, lordships are directed to secure the records, my lords. Report to be filed. Lords, this is a matter where a crime was committed in 2024 December. No FIR was registered. After the directions from the Honorable High Court, my lords, FIR was registered. Then, my lords, they didn't file a charge sheet.
Final report has it been
Please,
filed?
please.
Lord, accused are not traceable, my lord. We have moved application. We are planning to move application before trial court for cancellation of the bail. Once the bail is cancelled, we'll secure them. The address given in the petition, they are not traceable in that address, my lord. We are filing the application before trial court for cancellation of the bail, and we'll trace the.
Said the terms of the.
Please, my lord. So no cooperation from the accused, my lord. We'll move application before trial court for cancellation of their bail.
That the accused not cooperating with the terms and conditions of the bail order issued.
May make one submission. There is an order passed by the criminal petition court where the accused have approached the criminal court. There, my lords, there's an order saying that not to precipitate the matter. Let the state move the matter, my lords.
They'll have to take action, then
Please,
only
please, my lords. We have filed a
investigation
vacating.
can happen.
We have also filed a vacating application to that order.
The response state has moved or is moving?
No, he's moving, my lord.
He is moving an application for cancellation of the bail, as also for necessary directions in the pending proceedings under section 482.
Please, my lords.
The submission of learned AGA is that once orders are passed, necessary investigation would continue and report be filed. If there's a stay, how can we grant this order?
No, there's no stay, my lords. What they have stated is only that there shall be no precipitative steps. I clarified before lordships, page 20, Annexure D, lordships could see that the order which was passed by the coordinate bench in the criminal matter, my lords, is that in the meanwhile, the respondent number 1 is directed not to take any coercive precipitative steps and not to arrest them. That was the only order. There was no stay against the investigation. Now, what I'm before your lordships is that to
in view of stay, move the proceedings, pending proceedings under section 482.
Please, my lords.
And thereafter complete the investigation. Relist on 18th August.
Please, please. Like,
49, because M.
Your Lordship, in this matter, only notice was issued only to respondent number 1 and 2 and asked them to produce the report, which they mentioned in page 110.
We have filed a statement of objection in this matter.
Notice to respond number 3 and 5 is deferred.
Yeah, after finding the report only, the court said it will be issued to others.
3 and 5 sought to defer the notice, my lord.
So the report has not been filed.
My lord, in this case, my lord.
The report is mentioned, they have conducted an inquiry at page 110, they have mentioned. That report is asked to be filed.
Yes. My lord, in this matter, my lord, they are asking for the compensation. Firstly, by invoking DPDP Act. If their case is that they are invoking the DPDP Act, my lord, there is an alternative remedy.
No,
My lord,
we are not asking for the DPDP Act. We are only relying on...
Let him make a submission.
I am permitted to submit, my lord. Yes. My lord, there is a alternative mechanism. If at all, if the bank violated the provisions of the DPDP Act, my lord, there is a DPB board is there. My lord, they have to go before the DPB board. My lord, I have enclosed I am permitted to place the documents, the circular.
The allegation is that the bank unauthorizedly furnished the bank statement.
Bank statement. If such being the case, my lord, if they are invoking the DPDP Act, my lord, when the alternative remedy has been provided under the Act, they have to go before the board, DPP board, and there is a appellate provision is also there. Firstly, secondly, my lord, without prejudice, my lord, their case is that I have saved the statement of account to the respondent number 4 and 5. My lord, in fact, my lord, in my statement of objection, I have very clearly stated that, my lord, I have received the instruction from the Mysore University to provide the statement of account. In turn, my lord, they directed by the Women Rights Commission to place the statement of account of the petitioner. My lord, by virtue of the communication of the Women Rights Commission, she approached the Women Rights Commission, my lord, alleging certain allegation against the respondent number 4 and 5. My lord, in turn, Women Rights Commission, my lord, wrote a letter to the Mysore University, conduct the inquiry with respect to the stipend given to the petitioner. My lord, Mysore University wrote a letter to us, give the statement of account of the petitioner. We have provided the statement of account to the Mysore University. My lord, in turn, Mysore University, whichever the statement which you have given to the Mysore University, the statement of account has been given to the Women Rights Commissions. My lord, we have requested them to, by way of letter, my lord, give the particulars where how this statement of account has gone into. Mysore University, in turn, they intimated to us whatever the statement of account which we have collected from you has been given to the Women Rights Commissions. My lord, they are telling that the respondent number 4 and 5 have filed their statement of account before the Lokayukta. Several disputes are going between the petitioner and the respondent number 4 and 5. My lord, the respondent number 4 and 5 filed the written statement before the Lokayukta, Karnataka Lokayukta. There they have enclosed the statement of account of the petitioner,
which was produced by the Mysore University.
We have given it to the Mysore University. I don't know how Mysore University has parted the statement of account to the respondent number 4 and 5. My lord, I have not given the statement of account to the respondent number 4 and 5. My lord, under such circumstances, my lord, putting the onus on the bank, stating that.
My lord, what the university asked them after the case was over, okay, final decision is over, and they asked only details about 5 entries.
Disputed questions of fact. There will have to be a trial and inquiry to be done.
No, well, let me.
That will have to be done by the board.
I only want to submit. My lord, 5 entries they were asking. They have given me all the 217 entries.
All of it is
the entire account.
All of it would have to be subject to trial.
No, there is no requirement, my lord. This is
who
a
gave
simple
for what
question.
reason
27,
and how
my
it came
lord.
to 4 and 5.
Yes, my lord.
And you are invoking the DPDP Act.
27, my lord, I permitted.
He could get a jurisdiction.
Yes, my lord.
I am not covered.
You are asking 1 crore from each of the
But my
respondents.
submission is I am not covered under the. They are making it. I am covered. I am covered by the judgment of the Honorable Supreme Court.
Show us the judgment.
Yes.
Show the judgment which will
Yes.
entitle you to come to the High
Yes,
Court for damages, compensation.
Yes.
First of all, this act has not in,
We will come back later.
into come into force. If at all, if the act is come into force, my lord.
Yes, Machinappa?
Sorry, Lord, I must apologize in advance. Move an urgent matter. It's
That-
that's why I'm troubling you.
Which one?
An urgent matter moving today afternoon if possible. The food safety officer issues a notice to Swiggy, my lord, with respect to its app called Toing. 7 days notice is given to us to respond. 2 days later, yesterday, my lord, he prohibits us from continuing with the app and issues the notice and issues an order of prohibition. But in the Food Safety Act, you can only prohibit an article of food, but he prohibits the app from continuing.
The app is the cause for the food.
I don't know if that can
If
work.
the app is not there, the food won't be supplied.
Not food, not general food, my lord. You must identify the food article and say this food article in this particular establishment.
Now your Swiggy app is suspended.
The Swiggy app, an app called Toing, which is associated with the Swiggy app. It's not for
The
students.
Swiggy app is continuing.
Toing is for students. And
Serve it on them. Let's see if
I
they
don't know
come.
who, my lord, it's the food
Who
safety
is
officer.
the standing counsel?
No standing council food
It
safety.
must be for FSSI.
It will be state government only, my lord. I'll serve the state government.
List one, serial number 20, it is passed over.
Where is Mr. Ravi Shankar?
He's on VC minutes.
Mr. Ravi Shankar? Where is he?
He's on VC.
He's not there.
Just informed me he's on VC. He'll be here at 2:30 minutes.
We are informing you he is not there.
My lord, apparently his wife is hospitalized. So he
Wife
will
is
be here
hospitalized.
at 2:30.
Mr. Ravi Shankar?
My lords, I am appearing for the, sorry, my lords.
You thought you are appearing.
I'll be there before lordships at 2:30, my lords.
Yes, please. We'll take the
Lordships.
You appear through VC in the hospital.
No, some
You don't need
procedures,
to
my
come here.
lords.
Please be
No, some procedures I am done with it, my lords. I'll be before lordships at 2:30.
We entirely leave it to you. You don't need to be here. You can come through VC.
Please, my lords.
Lords, one small submission. Moving memo for being spoken, my lords.
ಏನಕ್ಕಮ್ಮ?
Lords, yesterday the lordship was directed us to pay 25% of the tax payable in the education.
Service charge.
Please, my lord.
Yes.
That, my lords, the demand notice was not quashed. So even the demand notice has to be quashed, my lord.
So tomorrow.
Lord, one mentioning, my lord.
Yes, Mr.
38, my lord. I was not able to log in, my lord. Could it be taken up at 2:30, my lord?
ಇದು ಒಂದು ನಾಳೆಗಂತ ನೋಡಿ.
38.
Please,
It's
my
been
lord.
adjourned.
Could it be passed over, my lord, taken up at 2:30?
38. No, if the other side is here, then
Please.
38.
Oblige.
Fine.
Oblige.
ನಾಗರಾಜ್ ಇದೊಂದು ಫೈಲ್ ಕೊಡಿ. ಇವ್ರು ತಗೊಂಡಿದ್ದು ಫೈಲು 17306 ಇವ್ರದ್ದು ಫೈಲು ಅದಿದ್ರೆ ಕೊಡಿ ಪಾಸ್ ಅವರು.
58 Madam, 38.
38 ಸರ್ 17306.
Please, madam. Anjanadri Transport.
ಮಧ್ಯಾಹ್ನ ಫಾಸ್ಟ್ ಓವರ್ ಲೆಕ್ಕದಲ್ಲಿ ತಗೊಳ್ಳೋಣ ಸರ್ ಅದು.
Yes, madam. Thank you. Thank you.
ಇಲ್ಲ ಲಿಸ್ಟು ಫಸ್ಟ್ ಹೌದು ಲಿಸ್ಟು ಫಸ್ಟ್ ಆಮೇಲೆ ಬರುತ್ತೆ ಬಿಡಿ. ಇವಾಗ ಏನಕ್ಕೆ ಕೊಡ್ತೀರಾ? ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರು? ಮೆಮೋ ಎಲ್ಲ ಹೋದ್ವು. 10:30 ಕೊಡ್ಬೇಕು. ಒಟ್ಟೊಟ್ಟಿಗೆ ಅವಾಗೆಲ್ಲ ಬರ್ದು ಕಳಿಸ್ತೀವಿ. 58 ಇದೆ. 10:30 ಕೊಡ್ಬೇಕು. ಈಗ ಯಾರು ಹೋಗಲ್ಲ. ಒಂದ್ಸತಿ ಹೋದ್ರೆ ಒಟ್ಟು 2 ಗಂಟೆ ಕಾಲ ಆಗುತ್ತೆ. 4 ಬ್ರಾಂಚ್ಗೆ ಹೋಗ್ಬೇಕು ಅವರು ಬೆಳಗ್ಗೆ ಹೊತ್ತು ಹೋದಾಗ. ಈ ಒಂದಕ್ಕೆ ಹೋಯ್ತು ಅಂತಂದ್ರೂ ಅಷ್ಟು ದೂರ ಹೋಗಿ ಬರ್ಬೇಕಾ? ಬೇಡ, ನನ್ನ ಹತ್ರ ಕೊಡೋದಲ್ಲ, ನಾನು ಬ್ರಾಂಚ್ ಕಳಿಸ್ತೀನಿ. ಬೇಡ ಬೇಡ ಬೇಡ, ನಾಳೆ ಕೊಡಿ. ಲಿಸ್ಟು ಸರ್, ಲಿಸ್ಟು ಆಮೇಲೆ ಫಾಸ್ಟ್ ಓವರ್ಸ್ ಕಂಟಿನ್ಯೂ ನೋಡೋಣ, ಗೊತ್ತಿಲ್ಲ, ನಾಳೆ ತಂದು ಕೊಡಿ. ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಆಮೇಲೆ ಪಾಸ್ಟ್ ಓವರ್ಸ್ ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ ಹೇಳಿ ಸರ್. ಇದೆ 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 ಅದು ಮಧ್ಯಾಹ್ನ the afternoon it will be taken. Afternoon not reach not adjourn also 58 is there. Second list first ಹೌದು ಎಲ್ಲ ರೀಚ್ ಆಗುತ್ತೆ ಕಾಯ್ಬೇಕಷ್ಟೇ. ಓಕೆ
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 37 ಏನಾಯ್ತು ಮೇಡಮ್?
ಸರ್ 37 30th ಜುಲೈ.
ಸರಿ, ಥ್ಯಾಂಕ್ ಯು.
Yes, where's Mr. Ravi Shankar? One is, told you 2:30 issued. Short accommodation, short passover. Short pass.
230 matters. Number 2. Serial number 1, Varun Japati.
Copy Kutra. May I please?
Where's Mr. Jaykumar Patil?
Sign ಮಾಡಿದ್ದೀರಾ?
You're filing your objections and we'll pass or let him come.
Please.
Pass.
Serial number 2, Suhas TN.
Appearing for the petitioner in the connected matter, my lord.
What all confusion you have created. Mr. Pavan Kumar. Pass over. Let him come. So we'll have to tell him which year, which plan they have to check. No, no. Which is the final plan which they have to verify from? So when did you file that plan, madam? 25/1/2025. Nine 1/2025. When they come, we'll tell them.
Happy for the fourth respondent.
Yes, Mr. Gilbert.
Serial number 3, Rakshita
Please.
DJ.
That's
3/11/25. Hmm.
There are 3 tender notifications and it's still A1 and A2. It's one submission before my learned friend starts. But it was at our request, my lords, vacating stay application was filed. We had requested, my lords gave it at 2:30. My lords, in the rejoinder, the petition is filed as against rejection of the technical bit of the petitioners. Now, insofar as that is concerned, we had filed our statement of objections. The document also is there. She has not availed the appellate remedy. They have not availed the appellate remedy. But in the rejoinder, my lords, they have taken up another contention now, stating that even if I'm technically qualified, there is only a single bidder left out. That is a new contention that has come up. Now, my lords, insofar as we are ready to address, my lords, the main issue, single bidder issue, in case because it is a second call. So the single bidder issue might not be. I'm also.
Whatever it is, address it all together, not in.
On the single bidder issue, what had happened? I checked the case law. Lords, there were 2 circulars. The single bidders, if it is, there are 2 contingencies, my lords.
You are ready today with everything.
No, lords, I am ready, but I just want to point out after hearing on that issue, my lords, we might have to file an affidavit because in the connect. Therefore, my lords, I didn't want to waste the time of the court. I know the.
That's very good.
Please, I just wanted to point it out
File
because
when will you file it?
Lords, since the urgency for us, I need only 1 or 2 days time, lords.
Learned Additional Advocate General submit that in view of the rejoinder file, an affidavit would the state would be filing an affidavit.
No, but the tender inviting authority.
Tender inviting authority would be filing an affidavit. Relist on 13th.
Please.
Who is appearing for?
I'm appearing for the tender.
Appearing for respond number 3. Pajwala Satyaprakash has entered appearance for respond number 3. Delete Arsha V as that appearing for respond number 3. and C. Ajit as that appearing for respond number 3.
Can it be on 14th?
14th we have 132
Then
matters
13th.
already.
I'll take it on 13th.
At 2:30 p.m.
Please.
Interim order earlier granted is extended till next date of hearing.
Please. Because in the case law that I'm relying upon on the single bid.
Rely everything on that.
No, my lords, there court had directed to file an affidavit. I didn't want to bring it to that.
Ruben will consider it on that day. No need to do
Please,
please. Please. Mr. Ravi Shankar is waiting for.
Sorry, my lords, I was just late
You
by
could
a
have-
minute.
You could have come by VC. Why?
Because I had taken my learned friend into confidence, I told him. Lords, I also advised, my lords, the Hockey Karnataka that let them not draw the ties for all the teams because the participation of the other team is not confirmed. So consciously they have drawn the ties only for today, and for the remaining teams the ties is not drawn so that the time can be accommodated, number one. Secondly, my lords, can I just I don't want to come in that way because I'm more keen and interested that players play. Because players are going to play at the same time the discipline is required to be maintained. That is the whole intention with this entire hierarchy is that Hockey India, Hockey Karnataka. So what I will do, is to be an order of the court, I'm making a statement that I will withdraw that portion of the order which prohibits them. But subject to giving up an undertaking that they will give an undertaking that they will not participate in any unsanctioned events. That's all what we are saying. Because we want them to play. That's essentially.
Without them, you are nothing.
That's what the associations are for the players, but the associations are meant to impart discipline in a manner that.
Correct.
But what happened 2 years back? There was an incident which happened 4 years back. One of the players who was a national player, he participated in an unsanctioned event. So happened that he suffered a cardiac, there was no medical facility in that event because and he died. We take care. The whole object is this. If they have an option, if they want to play unsanctioned events so that they can start earning money elsewhere, we have absolutely no problems. They need not be part of this association. But if they want to be part of this state games, national games, and the games at all levels organized by this Hockey Karnataka and Hockey India, they should adhere to the discipline. That's essentially, but this is there in every game. It is not only because in this, in every game where this hierarchy is maintained, Olympic Association, other federation, and state federations. This is the discipline consistently there in every game in this country. So they have to adhere to that. So they have some inhibitions to say that we don't want to do it. If you are also to ask us a part of the court orders, I think there also sometimes we can get a closure of. They are asking me to give an undertaking without hearing him. I should be given an opportunity to
Mr. Somaya, you are before this court. If we even give you an opportunity of that, there's nothing that you can say on it. Because you have participated in a non-sanctioned tournament. That is clear ex facie. Show us the sanction. We asked you thrice. You have not been able to place any document on record saying that it is sanctioned. Is it a part of the Hockey India sanction, part of Hockey Karnataka sanction? Either of them place it on record. We will consider that. Last 3 days, you have not been able to place anything. Now, what do you want to do? Are you acceptable to this proposal or no? What will we do with your undertaking? It is given to them. We don't need your undertaking.
He has done a wrong is an admitted fact. Let him not get into it. Now it's not fair.
Now we have only 2 options. Please understand. We have 2 options. If you are acceptable to that, we'll make an order. You can go give the undertaking today. Tomorrow you can be part of this one, or you can argue the matter. Either of these 2 you can do. You cannot have in between to say no, set it aside without even arguing. Argue the matter. It's your choice. This or that. For that you have to succeed. For that you have to succeed in the petition. Please argue. We had asked them to we had asked Mr. Ravi Shankar to use his good office to intervene so that you can play. Nobody is forcing you to do that. It's your option. If you don't want to do, don't do. You can argue now. Yes.
So let it be an order of the court, we request the court to pass an order that we are withdrawing this letter and let him go and give an undertaking to Karnataka that they will not participate in any unsanctioned event. All what we said. He also said that this is fair, but I don't know why. It's essentially where I just pass on one document.
If you want to argue the matter, please argue the entire thing. Please take this one. We can't do anything in between. Can we do anything in between? We have to pass orders as per the law.
Opportunity to go before them and give an undertaking.
That is why you.
I will argue.
If you are agreeable for that, then we'll make it an order. You give the undertaking. Tomorrow they'll be part of it.
That he's not at risk. He can also answer his claims that he's not at risk. It's an order of the court.
But
that's what I
if you
told
say,
him.
no, I'll decide whether to give an undertaking. Then again, you'll come back tomorrow. There's no point in that, right? Argue the whole thing. There's no point in last 3 days. It's been going back and forth like this. And we are taking your matter out of turn because of the games being already commenced. So argue the entire thing. Either you succeed or you don't succeed. We don't know because you haven't started as it. Yes.
That is good. Yeah, all right. The file manager, huh? This is already before.
Page 2, my lord.
Page 2 of what you are given now. Yes.
This is the Hockey India regulations relating to sanctions and unsanctioned R3. Reading, my lord.
Yes.
I read, my lord.
Yes, please.
Sanctioned and unsanctioned events, my lord. Any second point, any athlete or individual under Hockey India jurisdiction who is found to have participated in an unsanctioned event is automatically ineligible for 12 months thereafter to participate in any capacity in any international event. 1.2.2 my lord, may have disciplinary consequences imposed upon him or her under the Hockey India Dispute and Grievance Redressal Committee for such breach of clause B1.1, including if being ruled ineligible to participate in any capacity in sanctioned events for a period of up to 12 months or more. My lord, only if I participate in an international unsanctioned tournament, my lord, I will be automatically ineligible. My lord, otherwise there is, my lord, a dispute and grievance redressal committee, my lord, I have to go before this.
No, that is not a correct reading. Any athlete or other individual under Hockey India jurisdiction who is found to have participated in an unsanctioned event, full stop. That's it. He is automatically ineligible for 12 months thereafter to participate in any capacity in any international event. Yes.
Only in international events I am ineligible to participate. Because thereafter 1.2.2 may have disciplinary consequences imposed upon him or her under the Hockey India.
So you are drawing a distinction between international and domestic event.
May have disciplinary consequences imposed upon him or her under the Hockey India Disputes and Grievance Redressal Committee for such breach of clause B1.1, including if seen fit, being ruled eligible to participate in any capacity in sanctioned event for a period of up to 12 months. I'll have to go before the redressal committee because they'll have to issue a notice to me. I'll go before them, they'll conduct a disciplinary inquiry, and then they'll pass an order because if I participate in unsanctioned event, we'll have to conduct an inquiry. And that is through the redressal committee, the dispute and redressal grievance committee.
What is this clause B? What is this B 1.1?
Well, organizations or individuals.
No, such
including
breach of clause B 1.1, which is B 1.1,
Well, B is sanctioned and unsanctioned events.
and this is 1.1. Organized individuals.
Now, my lord, hockey India has adopted a new bylaw on 20th June 2026. May I point out few laws from that, my lord?
Yes.
ಅದಿದೆ ನಮ್ಮ ಹತ್ರ
My lord, may kindly have page 82, my lord.
82.
82.
Clause.
That is the ethics committee, my lord.
This is of
Adopted on June 2020.
this is of Hockey India or Hockey Karnataka?
Hockey India, my lord.
Hockey India Code of Ethics and Ethics Committee.
Yes.
Clause.
This law, this bylaw, my lord. My lord, was adopted in accordance with National Sports Governance Act 2025, which was passed recently, my lord.
Yes.
So page 82 is the ethics committee, my lord.
Hmm.
Thereafter, my lord, article 4, it is at page 85, my lord. Complaints and references.
Is it reading?
Yes.
Well, any complaint alleging violation of Hockey India Code of Ethics or related regulations may be filed before Hockey India in writing, physically or electronically, in such form and manner as may be prescribed. Every complaint shall contain the name and particulars of the complaint, particulars of the respondent, material facts and allegations, supporting documents or evidences where available, a declaration affirming the correctness of the complaint. Anonymous or pseudonymous complaints may be determined where the allegation discloses serious ethical violation or matters affecting the integrity of the sport. The President of Hockey India, the Executive Committee, or any competent authority may also refer any matter so motu to the Ethics Committee for inquiry or consideration. Thus, Hockey India may prescribe a reasonable complaint field, procedural requirements, or filing conditions subject to waiver of exemption in appropriate cases. Thus, thereafter, article procedure and inquiry. Upon receipt of a complaint or reference, the Ethics Committee shall undertake a preliminary examination to determine whether a prima facie case exists. If the committee is satisfied that the prima facie case exists, notice shall be issued to the respondent along with relevant materials and documents. The respondent shall ordinarily be granted a period of 2 weeks from the receipt of notice to file a written response or explanation. The committee may extend such period for sufficient cause recorded in writing. The Ethics Committee shall ensure compliance with the principles of natural justice and provide reasonable opportunity of hearing to all concerned parties.
Yes.
Because I should be given a reasonable opportunity to go for the appropriate.
You are a domestic player or an international player?
The event is a state event.
Event is a state event.
You may succeed for this event, but what will happen to your international event for next year? Even if we accept your submission is automatic disqualification is for international event for 1 year. Domestic, there is no automatic suspension. So even if we accept it, your clients will be disqualified for next 1 year. International. You are okay with it? You are not looking forward. You got instructions on it.
I've got instructions on that.
Fine. Yes. Yes, go ahead.
And then there is dispute redressal committee. May kindly have page 54, my lord. Article 20, my lord.
Yes.
Hockey India shall constitute a dispute resolution committee in accordance with these bylaws, rules and regulations framed for the purpose and applicable law. The constitution, composition, tenure, powers, functions, operations and procedures of the dispute resolution committee shall be governed by rules and regulations framed by Hockey India and applicable law. Preferably, the committee shall be chaired by a retired judge of High Court or eminent personality or legal practitioner. The dispute resolution committee shall function in a manner consistent with principles of natural justice and fairness as prescribed in the applicable bylaws. And then this Article 22 Grievance Redressal Committee, my lord, all these articles, my lord, gives an opportunity of being heard, my lord. Without hearing me, my lord, I cannot be convicted.
Yes.
But I should be given an opportunity for the appropriate authority, my lord. If I am found guilty, my lord, let them convict me, let them ban me for 12 months, my lord, I will accept the verdict. But without even giving me an opportunity Okay, my lord. They sent a letter, my lord. May I kindly have annexure 1A for a moment.
Annexure A.
Annexure A, my lord. My lord, page 25, my lord.
Yes.
My lord, this is, my lord, the invite that is sent to AGRC, my lord. My lord, petitioners are permanent employees of CAG, my lord. My lord, this is an invite sent to the department, the sports welfare officer, my lord. They sent an invite saying Hockey Karnataka will be conducting the subject league championship at the Field Marshal KM Karapa Hockey Arena, Shantinagar, Bengaluru from 6th June to 5th August 2026. My lord, below, my lord, the last paragraph, my lord. Further, it is to bring to your kind notice that the undermentioned players from your esteemed department are ineligible to participate in the said league championship as they have participated in the unsanctioned tournament conducted by Karnataka State Hockey Association, a body that stands unrecognized in the state of Karnataka. Well, in an invite, they have sent this letter to sports welfare officer.
This is not even addressed to you. This is not even addressed to you. You are also not been
Addressed
addressed.
to me, my lord. I have played a unsanctioned tournament. They should have issued a letter to me, a notice to me, my lord. I will go before them. If I found it, I will issue an undertaking. Or I will issue an apology, my lord. This is not the way to send a letter, my lord. To the sports welfare officer of the department, they can't do that, my lord. And under what provision of law, my lord, I am not sure, my lord. Hockey Karnataka, my lord, they do not have a bylaw also, my lord. There is the trustee which they are referring to, my lord, which is of their 2010, my lord. From 2018 onwards, my lord, I am not sure if it is a legitimate body or not, because, my lord, according to their bylaw, my lord, every 4 years once, my lord, they have to conduct an
If you want to get there, you want to play in their tournament. You want to play in their tournament. They are organizing it. You should know where. Yes. Yes. Because you are asking us to ask them to permit you. And if you say they don't exist, how do we ask them to do it? Yes, Mr. Vishen.
Lords, page 162 along with the papers which I have submitted, Lords.
You have submitted.
Yes.
162.
These are the list of events which are recognized as the sanctioned events which will be conducted under the aegis of Hockey Karnataka. It is a state level event. So whatever events are being conducted is already, my lords, enlisted and it is there. My lords, everything goes by means of an invite.
Yes.
So now these are the events which are the sanctioned events. Now, Lords, may kindly have a look at page number 95, 96. This is the bylaws or the memorandum of association of Hockey Karnataka.
Yes.
Lords, in that main objectives, clause 3 and clause 4 at page 97. To affiliate the institution with Hockey India, the Karnataka Olympic Association, and to bring within the purview of their rules, the bylaws and regulations, and to comply with them and be bound by them. To support and follow the values and objectives of Karnataka Olympic Association and Hockey India. This is the main object with which this is constituted. Page 98, Millers, clause 8. To select and control players from hockey team for participating in tournaments organized participated by Hockey India, IA, AHF, FIH, institutions in India, abroad and at state, South Zone National Sports Meet and other sports meet. The object itself is this, that we are selecting as also controlling the players who are required to participate. That's essentially what is the, just before that I want to tell this, they are all now occupied in governmental posts under sports category. The requisite for a person to get into the governmental institution under the sports category is having participated in the state level or the national level events at various levels, which is recognized only by Hockey Karnataka and Hockey India. If they are through hockey, if they are claiming their sports quota for hockey, unless they have participated in the events through Hockey Karnataka and Hockey India, they are not eligible to get the sports quota employment. Everything they get because they are the members of Hockey Karnataka. Now they are employed in AGORC because they were the members of Hockey Karnataka. They were the members
who participated as sponsored by Hockey Karnataka and played even the international events because they were selected in Hockey India. This is essentially how it is. Now, after this, they want to make a volte-face. Now, this is the whole object with which Hockey Karnataka, my lords, is constituted. Now, your lords may kindly come to page number 100.
Yes.
To take disciplinary action against district hockey organizations, institutions, units indulging in antisocial activities, showing inappropriate acts, indulging in any act bringing bad name, ignominy, defame to state and to the hockey game. But this is basically for these persons, organizations, institutions, or the units. If they go by themselves as a unit, we have got the powers to take even disciplinary action against an entire club. But now AGORC is a club by itself because we recognize them as a team. Now, the question, my lords, is as to whether we have the powers to take disciplinary proceedings or not. One thing which I have read to your lordships, I'll again read to your lordships. Whatever rules and regulations are framed by Hockey India, ipso facto becomes the rules and regulations which we are required to follow. Every member who is a member of a Hockey Karnataka is required and bound to follow these regulations. If they don't follow the regulations which has been prescribed, what is to happen is what I'll have to bring to your lordships notice. May just before that, can I persuade your lords, may kindly have a look at page number 105. Lords, the recognition, if your lordships were to see, player, its meaning persons participating in any activities or units accepted and controlled by Hockey India and its members. Hockey Karnataka is also a member, my lords. Not a person who wants to be recognized as a player should be a person who will participate in only these activities. I will also take your lordships to that unsanctioned events because there is a definition to sanction an unsanctioned event.
Yes.
Then hockey rules at page 107, my lords, which will be clause 116 at page 107. Hockey rules means rules framed and practiced by Hockey India and Hockey India Federation. Now, my lords, the executive committee is at clause 5, which commences at page 116. Authority, duty and responsibility. 5.1 is general meeting and 5.2 is executive committee, which is at page 119. Number 1, to implement the objectives detailed in the organization pledge. That's what I read to your lordships. This is the prime object of the executive committee, but what your lordships may have to consider is page 120, clause 5.
Yes.
To take a decision on the indiscipline, misconduct, agitation, cases of violation of rules and to impose fine or penalty so that it will supplement such a person to make a plea to the general body. Not just pausing here, we have this structure where all the national events and the participation in the international events will be regulated by Hockey India. Up to the stage of participation in the national event and the state events will be regulated by the Hockey Karnataka. This is essentially, my lords, how the structure has been there. Now, wherever we are conducting state events, it is expected of them to have adhered to the rules and regulations that they will not participate in any unsanctioned event of Hockey Karnataka. Yes. I'll also take your lordships to that unsanctioned event. Now, we have the powers to have this disciplinary proceedings against any person.
Essentially, to cut it short, essentially the distinction that Mr. Soma is drawing is insofar as international
that's the reason why, my lords,
it is automatic.
No.
For
Lords, there,
domestic is not automatic.
No, the reason why we are submitting this is we have the authority to take disciplinary action.
Yeah, the authority.
We have only said that for this event we are not permitting you to participate because I will also refer to the letter, my lords. It is not that the annexure A is the solitary letter. There is another letter which was sent to them saying that this is what has happened and this is the reason. It is not a disputed fact that they have participated in an event which is not there in the list and it's an unsanctioned event. You know, sanctioned and unsanctioned is a very simple proposition. If the event is sponsored or is under the aegis or banner of Hockey Karnataka, that's a national level, that's a state level or a district level event, it's a sanctioned event. If it is not sponsored or under the aegis of Hockey Karnataka, it's an unsanctioned event. I'll take your lordships to that definition.
Even if we have to admit that, even if they were to admit that, the simple argument that Ms. Soma is urging is Hockey India, that particular clause says insofar as international events, it is automatic.
Yes.
Domestic is not covered as
No,
automatic.
it's domestic. That's the reason, my lord. So far as that's the national events.
So do you have any clause in hockey Karnataka?
Yes, my lord.
Saying that it is automatic?
Lords, we don't have a clause which says it is automatic. That is the reason why I said, my lords, mutatis mutandis, we have the structure, the rules of Hockey India adopted to the bylaws of Hockey Karnataka. That's what I read to your
clause
lordships.
of automatic, then you'll have to issue notice.
Lords,
You'll
we
have to
have,
hear them.
lords, that's
You
the
may
reason.
pass, you may impose fine, penalty, whatever you want to do, you may
Yes.
do. That is there. But
Lords,
that is
now
only after national
the power
justice.
of taking disciplinary action includes power of suspension. Now we are only suspending the participation in this event, nothing more. We are not dismissing him. We have not imposed a penalty. This is eventuality has not yet occurred. We are only saying for this event, because they have participated in an unsanctioned event, now you cannot participate. We'll conduct an inquiry. Lords, after this, we'll definitely issue notices to them and conduct an inquiry. Before the suspension, there is no question of issuance of any notice.
Where does it say that in your rules?
Lords,
that you can suspend pending
Lords,
inquiry?
Because the law that has
There is
been
no
developed,
inquiry
I'll just
also.
place that judgment, my lords, before your lordship rises, a power to take disciplinary action inheres the power of suspension within it, unless the bylaw or the law specifically excludes the power of suspension. That is the law.
Rely on, give it to us.
That I will give it, my lords. Just I don't think that's I'll just immediately I will give it, my lords. No difficulty. Immediately I'll give it. Lords, now this is essentially, my lords, the power which has been vested. Now your lordships will kindly see at the page 151 in the same paper book, my lords, because we are referring to that Hockey India regulations.
151.
This is sanctioned and unsanctioned events in particular.
Yes.
Lords, these regulations, can I just pursue it? Lords, may kindly take page 152, my lords, clause A.
Yes.
Hockey India has adopted these regulations to implement and give effect to the FIH regulations on sanctioned and unsanctioned events within Hockey India's jurisdiction. These regulations, therefore, establish a procedure for an event organizer to apply to Hockey India to sanction that event. My lords, I just pause here, my lords. Your lords, wherever is reading Hockey India, my lords, may read it as Hockey Karnataka, because Hockey India regulates national level and international level participation. At the local level, my lords, because we have adopted the bylaws as it stands from Hockey India, this is how we have read this the bylaws. So there is a requirement of sanction to be obtained by the organizer if they want to go and participate in that event. Next, prohibit athletes and organizations and individuals under the jurisdiction of Hockey India participating in unsanctioned events.
Yes.
This is an absolute bar. Now, establish a procedure for an athlete whose home national association is Hockey India to apply to Hockey India for a no objection certificate confirming that Hockey India has no objection to the athlete participating in an event organized or sanctioned by another national association. Prohibit an athlete whose national home association is Hockey India and participating in an event organized or sanctioned by another national association unless the athlete has obtained a no objection certificate. Prohibit the participation in an event organized or sanctioned by Hockey India by an athlete whose home national is not Hockey India unless the athlete is found not obtained a no objection. Lords, then lords may kindly see that is clause B. After that, lords, after 1, 2, 3, 4.
Yes.
Prohibition on participating in unsanctioned events. Organization or individuals, including athletes, technical officials, umpires, coaching or management staff under Hockey India jurisdiction may not participate in any manner in any unsanctioned event. This is an absolute bar. Next, any athlete or other individual who under Hockey India jurisdiction who is found to have participated in unsanctioned event, consequences automatically ineligible for international event, may have disciplinary consequences imposed upon him by Hockey India and grievance redressal committee for breach, so on and so forth. Then lords may kindly see clause 2. It speaks about how to apply for Hockey India for sanctioning of an event. This is essentially the procedure Hockey Karnataka follows, mutatis mutandis, for an event which will be organized in Hockey Karnataka.
Yes.
Then your lords may kindly see clause C at page number 155 deals with obtaining no objection certificates. I'll skip this and come to page 158.
Yes.
Lords, at page 157, first I'll refer to event, my lords, and then I'll go take your lords to appendix definitions and interpretation. Any indoor or outdoor hockey match, tournament, competition, or other event at whatever level played, whether international, continental, national, or local, including age groups, events such as master events. Then page 158.
Yes.
Any event organized or sanctioned by the relevant continental federations, national associations, and or FIH in accordance with the FIH regulations, and sanctioned and unsanctioned events including any event organized or sanctioned by Hockey India pursuant to clause B2. Then unsanctioned event means any event that is not a sanctioned event. Let's now it is a strict rule which is being followed. They cannot have a special treatment, or they cannot now set a precedent for the discipline in this game. That every person who has been a member of Hockey India and the Hockey Karnataka are bound by this dictate that they are required to participate only in the events which are the sanctioned events. If they are participating in the unsanctioned events, they are exercising their option that they don't want to be a part of Hockey Karnataka. That is how the rules are made. This itself is a part of a separate regulations by itself, because prior to 2019, Hockey India faced these problems, that the persons who are part of the team, national team or the local teams, they started organizing themselves, raising funds, or they participated. When they participate, there is something like this. If Virat Kohli says that I'm going to come and participate in an event, there will be sponsors which will flow. Similarly, when an international level player says, I am going to participate in this event, there will be sponsors which come, there will be money which will be raised. How they organize is a different matter. It is in order to ensure that these things, because players should also not become corrupt. Ultimately, the object is something else. It's not the manner in which I am telling it's a matter of money. It is because we want to keep the players
safe.
Yes, safe and disciplined. That's the access should not be there. There are a lot of other things which should be unspoken rather being spoken. This is the object, because in my discussion with that's what they said, that this is the whole object, that we want them into this so that they don't go beyond this parameters. Now, after this, if your lordships were to see, if lordships may kindly see the hockey bylaws of 2026, which my learned friend has passed on, my lords.
Bylaws of Hockey India.
Yes.
Yes.
Lords, before that, I'll finish this volume, my lords, so that I will not again trouble your lordships from this volume. At page number 160, page number 164.
Yes.
On 18th of June, my lords, a separate letter is communicated, my lords. This is to I just wanted to say this. Players by themselves have no right to participate in the event. It is the team. AGORC is the club or the organization which we are sending them the invite. So it is they who will have to send the team. Now, when they are sending the team, they are also the members of Hockey Karnataka. Now, kindly have a look at this letter dated at page 164, 18 June 26. It is hereby brought to your kind notice that few hockey players of the Auditor General's Office Recreation Club, Bangalore, are reported to have participated in unsanctioned hockey tournaments conducted in Bengaluru by State Hockey Association, a body that stands unrecognized in the state of Karnataka. Such participation appears to be in violation of the Hockey India conduct. Undermentioned players from the Auditor General's Office have participated in the KSHA B Division, A Division and Super Division League matches representing different private clubs, so and so. In accordance with the International Hockey Federation regulations relating to sanctioned unsanctioned events followed by Hockey India, governing body of the sports field hockey clearly mentions that organizations or individuals, including athletes, umpires, coaching or management under Hockey India jurisdiction may not participate in any unsanctioned event. Controller Auditor General team affiliated to Hockey India participates in all India tournaments conducted by Hockey India, and the players mentioned above also represents the CAG team in Hockey India, departmental national championships and all India tournaments. In this regard, you are requested to deny permission to the players for your organization to participate in any unsanctioned events. Further, all players registered with the Hockey India or Karnataka may be informed that participation in unsanctioned event is prohibited under the applicable rule of Hockey India and they should refrain from taking part in such events. Henceforth, any violation may attract action as per the rules and regulations of Hockey India. Please find enclosed the few newspaper clippings and the copy of the sanctioned and unsanctioned events regulations of the Hockey India for your reference. So we kept them informed that this is all what you are required to do. We said that please don't send them to this event. We are permitting you to participate. Now the players are before the court because they will have to come through this AGORC. Now your lots may also kindly have a look at. That's page 166 to say, my lord, that this KSHA is not affiliated. That's, of course, I don't think that they will. Page 167, petitioner number 1, he is also the member of Hockey India. He is also the member of Hockey Karnataka. Now, page 168, is the paper clippings which we have submitted to show that these people have participated. There is no dispute about the fact that they have participated in the unsanctioned events. In the same volume, my lords, if your lords were to kindly have a look at page number 7, which defines the event. Lords, what is relevant, my lords, is page number 9, clause 1.34. Sports person, athlete or player means any individual who participates or is eligible to participate in any hockey event, competition, match, league, trial, camp or programmed, organized, recognized, sanctioned or controlled by Hockey India or by any affiliated unit of Hockey India or under the aegis of FIH, AHF or IOA in accordance with this bylaws.
Yes.
Notice the Hockey India very specifically lays down that the players definition itself is the one who is entitled to participate or who will be eligible to participate in these meetings. The controlling or the persons, the entity which is entitled to say whether you can participate or not, which I read to your lords in the bylaws of the association, which is at clause number clause number 8 at page 98 to select and control players from Hockey Karnataka team for participating in tournaments organized by so on and so forth.
Yes.
So this is something which is required to be done by us. We are only doing our duty. We are not, if they had not participated, we had no reason. I should say this, there are 12 teams participating. Each team consists of about 16 players to 18 players. 12 teams have already come. 13th team is the present team, which we have said, we have sent the invite. We also want them to participate. We have nothing against any player. This is because of there is an act of indiscipline and this should be viewed very strictly because this is one game, for whatever reason, this is the national game. And we wanted to ensure that we are now showing a decline, because the players are though being trained, much has been invested. We are not in a position to accomplish, in the international events. Much is being done. So one of the steps which has been taken after 2019 was this, because prior to 2019, if your lords were to see, the trending in the game up to 2010, 2011, we were at the top, at least at the top 4 used to finish. Then there was a gradual decline. In one of the events, we did not even qualify in the qualifiers and thereafterwards we came out. This is the problem. 2019, therefore, this is something which we have done to ensure that the players, the sanctity of these players playing the tournament is kept sacrosanct. There is no way that we are going to take any breach as an acceptable. This is the first time these people are doing it. We are not saying that we want to debar them. So we had a discussion. I even told him that let's not get into it. You are aware you have participated in an unsanctioned event. It is not something which is a Euclid's theorem. You will have to derive at a conclusion as to whether it's a sanctioned or an unsanctioned event. You are aware it's an unsanctioned event. You have participated, don't repeat it. Let's take the game forward.
They are not willing to do that. Leave that aside.
No, the
We
reason
have-
why
last 3 days
yes,
it's been going on like this.
the reason why we said Milords is that for something which you know, this something like this, Milords, if it is a matter of some misconduct, some file notings is there, to find out whether there is any complicity in the file notings to bring about the disciplinary misconduct, I can understand. It's a situation where they were conscious, aware, they have not participated all these years.
If we look at it now, even if they were to participate in this tournament, if you call it that, the next 12 months you are out.
That's upon inquiry, my lords.
Upon
It has to be
inquiry. Upon inquiry, you are out everywhere.
Please, my lords.
You're already out of national. You'll
This
be out.
becomes an act of
Other this one.
Milords. It
And
will set a very bad precedent, Milords, for the organization. It will set a very bad precedent.
Let them ban me for 12 months, my lord. I will accept the verdict, my lord. My lords, 3 of the office bearers, my lords, from Hockey Karnataka have participated in the same tournament, my lords. My lords, my lords,
I just wanted to say this, Milords. Karnataka's men's hockey team
my lords, it is
has
not
won.
that, my lords,
I
have
just
committed
mentioned
a
this.
crime, my lords. I've just
Has won the
participated
gold.
in one of the tournament, my lords.
Has won the gold in the national event in 2025 and the gold in the 37 national games in Goa. None of these people participated. They were selected, Milords, as a part of the Karnataka Hockey Karnataka team. The reason why I am submitting all these things is, Milords, now I just wanted because it is ultimately the conduct. Lordship's discretion is on the conduct, Milords, as to whether now he makes a statement. It is perfectly all right. Because they have no stakes, there is no way that they are going to participate. They were not even selected in the team of. They may be selected. Selection is a very fair process. They may even be selected. But to take these disciplinary issues to a next level, it's a very simple issue. To take it to a next level, saying that all right, I am required to. This sets a wrong precedent, and a person who admittedly commits the misconduct says that notwithstanding that this is an admitted misconduct, you are required to tell me, issue a notice, and then find out as to whether or not I have committed any act of misconduct, because this is an admitted act of misconduct. In their entire petition, Milords, I have just gone through the contents of the petition. It is not their case that this is a sanctioned event. If they don't say it's a sanction.
Mr. Ravi Shankar, you are absolutely right in what you are saying. Mr. Somaya is also right in what he's saying. But the effect of what you are saying comes in after you follow the process. The effect will not be there for this tournament. This tournament, you may succeed to participate. You may have your ego placated by participating in this tournament. But you are looking at 12 months, which Mr. Ravi Shankar, using his good offices,
nothing
has said
vindictive, Milords.
we won't do.
There's rules regarding that as well.
Yeah, that rule is clear here.
Milords,
You are taking absolute. See, mistakes can happen by anybody.
Please, my lords.
We
I
often
have
say
not committed any mistake, my lords.
we often say we learn from mistakes.
Please, my lords, if I have committed a mistake.
Learning from mistakes is first to accept that you have committed a mistake.
That's upon a
If you
inquiry,
accept,
my lords,
if you don't accept you have committed a mistake, you will never learn.
Just before the appropriate authority, I will accept.
Yes, the appropriate authority will decide.
Please, my lords.
Then you won't get. You'll get 12 months. Please understand. Third.
My lords, I appear for Hockey India.
Hockey
Yes,
India,
Mr.
Milords,
Udit.
is also.
I just wanted to
Is
make.
there only one question we have for you, apart from what you may submit, is whether there is automatic disqualification for domestic matches?
My lords, this is precisely the clarification I actually wanted to give.
Yes, please.
My bylaws that were read out flow from the international body, which is the FIH, which is the Federation, the International Hockey. So it's an international federation that even Hockey India subscribes to. So the
Yes.
same way Hockey Karnataka subscribes to me, I subscribe to an international body. Therefore, my bylaws come in the very specific context of national and international events. My learned senior appearing for Hockey Karnataka is extremely right in saying that all of these state associations have to prescribe to the National Federation rules to an extent. We, however, don't sit and dictate how each state does it, because each state, some states may incorporate it individually in their associations. Some like the case of Hockey Karnataka is that they are saying it's deemed incorporated. but that is a decision left to the state bodies whether how they are incorporating it. My bylaws are for national events and international events. That is clarification number one. Second, a lot has been said about Hockey India. There are just two aspects I wish to clarify, and I wish to be this very neutral. One is that this, in our eyes, is an issue for the state. The state has to make good whether it's acting or not acting in regards to its own bylaws, because this is a state level tournament. That's point number one. Point number two, and I just wish to say this as it's because a lot has been said about Hockey India procedures. There is one aspect. We have a website, my lords, Hockey India. We also ask our state bodies to maintain a website. On our website, we keep an updated list of sanctioned events. So that is for, but I must clarify, that's for national level events. So we have an updated list. So for us, how we like to keep our athletes informed, because, you know, the learned senior is absolutely right. This is a completely strict rule of sanctioned versus unsanctioned. But we intend to keep a list on our websites that enables any athlete across the country to simply go and see whether event A or event B is recognized by Hockey India or not. So this is the factual position just that Hockey India wishes to place before my lords.
Yes, but unlike your rules, which provide for automatic disqualification for international events,
my lords,
you have no such rule for domestic events.
My lords, it's largely they have been catered around that. My instructions are that if I was to go for national level domestic events, I would come under the second part of the clause, where I would have to issue
that requires an action notice to be issued.
Yes, my instructions are that. But like I said, my lords, my bylaws are really drafted for players trying to go for international tournaments, because I prescribe to the FIH guidelines. That's the caveat I wish to really clarify over here.
And the state units are autonomous is your contention, is your submission.
Yes, yes, they are, and to the extent that they have to prescribe to certain standards, but how they go about it, how they do it, we leave it to them, because my lords, each state association be registered in a different state. Karnataka is registered in Karnataka, Maharashtra in Maharashtra, Goa in Goa. If they are executive bodies that to incorporate my bylaws in a different way, I don't want to be sitting. I sit in Delhi. I don't want to be sitting in Delhi and controlling them. They have to be given freedom on their own grounds about how they wish to incorporate my regulations. So that is to that extent, yes, they have to prescribe to certain standards, but they are also autonomous in their functioning.
Yes.
Third. Can I just make one statement, Minots? These are the games or the sports which can be reckoned or compared with that of the discipline which is required to be followed in the armed forces, because it's a matter of national pride. The sports is a matter of national pride. Any act of indiscipline, my lords, which is an admitted act of indiscipline, will be viewed very seriously.
To issue notice. We'll reserve your liberty.
The deemed what your lordships clarified from there, my lords. That is the reason why I said those regulations we have adopted as it is. Mutatis mutandis. That means I cannot say that for he participating in that's
why we asked you specifically.
Mutatis mutandis.
You should make a particular we are not.
I leave it at that.
We are not giving you any ideas.
Lordships have sufficiently.
We are not giving you any ideas, but when you made that submission the other day, we thought it was in their interest, but there seems to be a little.
I understand, my lords. No difficulty, my lords.
Lawyer's duty is not to just follow instructions; it is to advise. That we told Mr. Ravi Shankar, please advise your client. He advised. Many a time it is operation successful, patient dead. Here we have been trying to tell you this. You may succeed only for this tournament, but what will you do for 12 months? And why do you want that? We can't be saying, though we wanted to say a lot of things, but sitting here, we can't tell you those things. Just 12 months, that ignominy is not good. Mistakes happen. Everybody commits mistakes. We are all human. Anyway, you have earned instructions. We'll have to apply the law as is.
Please. Can I seek your lordship's
Yes,
excuse?
please. Petitioners are before this court seeking for the following leaves. Petitioners are permanent employees of the Accounts and Audit General Office, bracket AGORC Bengaluru, and are hockey players who have represented the AGORC in various interdepartmental, state, and national level tournaments. Petition number 1 and 2 are also stated to have represented India in various international hockey tournaments. Petition number 3 to 7 have represented the state of Karnataka in numerous state and national level tournaments. The petitioner aggrieved by a communication dated 18/6/26 addressed by Hockey Karnataka, by Secretary General of Hockey Karnataka to the Sports Welfare Officer AGORC, insofar as the statement made therein that the petitioners are ineligible to participate in the league championship to be organized by Hockey Karnataka. The letter dated 18 June 26 is incidentally a letter addressed by the Secretary General Hockey Karnataka to the Sports Welfare Officer AGORC, inviting the AGORC to participate in the league championship at Field Marshal KM Karyappa Hockey Arena, Shantinagar, Bengaluru from 6 July to 5th August 26. The purpose of which is selecting players for the forthcoming 97th All India MCC Murugappa Gold Cup Hockey Tournament 2026. The submission of Mr. Somaya, learned counsel for the petitioner, Somana, learned counsel for the, Somana, learned counsel for the petitioner, is that the alleged reason provided under the letter dated 18/6/2026 is that the petitioners have participated in an unsanctioned tournament conducted by Karnataka State Hockey Association, bracket KSHA, a body that is unrecognized in the state of Karnataka. In this regard, he relies upon the Hockey India regulations relating to sanctioned and unsanctioned events published in August 2019, more particularly clause capital B thereof, which is reproduced hereunder for easy reference. By referring to clause B 1.1, he submits that though there is a prohibition for athletes, technical officials, umpires, coaching or management staff under Hockey India jurisdiction to participate in from participating in any unsanctioned event, there is no automatic disqualification insofar as domestic events are concerned. By referring to clause 1.2.1, his submission is that the automatic ineligibility or disqualification for 12 months is only in respect of an international event. In other circumstances, it is clause 1.2.2, which would apply, which would require disciplinary proceedings to be initiated by the Hockey India Disputes and Grievance Redressal Committee for any breach or violation. His submission is that merely because allegedly because the petition, we are trying to safeguard your clients, that's all. Allegedly because there is a participation by the petitioners in an unsanctioned event, they cannot be automatically suspended or held ineligible to participate in domestic events. The said automatic ineligibility or disqualification would apply only to international events. Insofar as domestic and national events, unless there is a disciplinary proceeding which is initiated and completed, there is no question of the petitioners being held to be ineligible. In this regard, he relies on the bylaws of Hockey India, more particularly Article 20 thereof, which is reproduced hereunder for ease reference. By relying on Article 20, his submission is that there is a dispute resolution committee which is required to be constituted under the bylaws and it is this dispute resolution committee which will have to look into any dispute which has been raised. Apart from the dispute resolution committee, there is a grievance redressal committee contemplated in Article 22. Article 22 is reproduced hereunder for easy reference. By referring to Article 22, his submission is that whenever there is any grievance, the grievance committee shall address grievances raised by athletes, coaches, and other persons associated with Hockey India in a fair, timely, and transparent manner in accordance with the procedure prescribed under the applicable regulation. The grievance redressal committee is to, by the very, in terms of clause 22, Article 22.2, the word fair would include compliance with the principles of natural justice. By referring to clause 22.3, he submit that the redressal committee shall have to be chaired by a retired judge of the High Court or eminent personality or a legal practitioner, which would require that the petitioners are heard by the grievance redressal committee before any orders are passed. He refers to Hockey India Code of Ethics and Ethics Committee, which relates to Article 19 of Hockey India bylaws, and submits that even if there is any ethical violation on part of the petitioners, the same would have to be inquired into by the Ethics Committee. And in this regard, he relies on Article 1, Article 2, subclause 5. No, this is different. That won't apply. That won't apply. Article 4, which relates to complaints and references. Article 4 is reproduced hereunder for easy reference. By referring to Article 4, his submission is that if there is any complaint alleging violation of Hockey India Code of Ethics or related regulations, the said complaint would have to be filed before Hockey India in writing, physically or electronically. The contents of the complaint are as described under clause 2 thereof. The President of Hockey India, the Executive Committee, or any competent authority may also refer any matter suo motu to the Ethics Committee for inquiry or consideration. The procedure on a complaint being received or suo motu reference being made is that under Article 5, which is reproduced hereunder for easy reference. By referring to Article 5, his submission, that is, by referring to subclause 7 of Article 5, his submission is that to preserve integrity, fairness, safety, and confidentiality, interim recommendations could be granted, could be submitted. And in terms of Article 4, Article 7 is Article 5 reproduced. In terms of subclause 1 of Article 1, on receipt of the complaint, a preliminary examination is required to be conducted. And in terms of clause 2, if the committee is satisfied that a prima facie case exists, notice is to be issued to respondent along with relevant material. The respondent would be, in terms of clause 3, the respondent is required to be granted 2 weeks' time to file written response or explanation. Thereafter, the committee, by ensuring compliance with the principle of natural justice and providing reasonable opportunity of hearing of all concerned, could pass such orders, including interim directions. His submission is that even if there is a suo motu reference which has been made by Hockey Karnataka, there's no inquiry which has been held in terms of Article 5, without an inquiry being held and principles of natural justice being satisfied, the so-called ineligibility arrived at by Hockey Karnataka in respect to the petitioners is not sustainable and is required to be set aside. Sri D.R. Ravishankar, learned senior counsel appearing for Hockey India, would submit that the Hockey Karnataka would submit that the bylaws of Hockey India have been mutatis mutandis adopted by Hockey Karnataka, and all the bylaws as it were, as it are equally applicable to Hockey Karnataka. His submission is that the aspect of discipline is very important for any game, and more so for the national game of hockey. There being various issues which had arisen on account of indiscipline, the rules of 2019 as regards where is that? Sanctioned and unsanctioned events had been introduced. This was to ensure that the players participate only in sanctioned event and not in unsanctioned events, and their schedule is regulated in a proper manner. Apart therefrom, he submits that the classification of sanctioned and unsanctioned events is also with the interest to protect the interest of the players, so that they are not used or misused in other unsanctioned events. His submission is that an event is being specifically adverted to in bylaw in clause 14, 1.14 of Article 1 of the bylaws of Hockey India, which means any match, tournament, competition, league, trial, camp or program which is organized, recognized, sanctioned or controlled by Hockey India or by any affiliated unit of Hockey India acting in accordance with the bylaws or conducted under the aegis of FIH. FIH is just Federation of India International Hockey.
Yes, my lords. It's Federation de International Hockey. It's a French name.
Federation de International bracket FIH. What is AHF? Asian Hockey Foundation. AHF is Asian Hockey Federation.
My lords, HIF, I believe you, my lords, may have read in the bylaws of Karnataka. I believe that's
AHF.
Oh, that's the Asian Hockey Federation. It's a continental
Asian
federation.
Hockey Federation bracket AHF. Indian Olympic Association bracket IOA. Clause 1.14, page 7 is reproduced hereunder for easy reference. His submission is that there is a memorandum that Hockey Karnataka being registered in Karnataka, it has a memorandum of association. The main objectives is to affiliate Hockey Karnataka with Hockey India and Karnataka Olympic Association, and to bring within the purview of their rules, bylaws and regulation, and to comply with them and be bound by them. Thus he submits that there is no option but to incorporate the bylaws of Hockey India into Hockey Karnataka. By referring to clause Roman 16 of the main objectives, his submission is that Hockey Karnataka is required to take disciplinary action against district hockey organization, stroke institutions, stroke units indulging in antisocial activities, showing inappropriate acts, indulging in any act bringing bad name, stroke ignominy, defame to state and to the hockey game, page 100. his contention is that participation in unsanctioned events would come within the disciplinary powers of Hockey Karnataka. By referring to the rules and regulations of Hockey Karnataka, more particularly Roman 5 of Rule 1, which defines player, he submits that any person participating in any activities, stroke units accepted and controlled by Hockey India, stroke its members, would be a player. Clause Roman 5 of Article 1 and Bylaw 1 is reproduced here under page 105. His submission is that for any person to play in any tournament in the country at the hockey, there are three hierarchies, namely one at the district level, two is at the national level, and three is at the international level. Insofar as the district and national level are concerned, it is Hockey Karnataka which would govern the players. And insofar as international events are concerned, it would be Hockey India. On that basis, the submission is that insofar as tournaments within the country, it would be Hockey Karnataka which should have to cater to and govern them, including taking disciplinary proceedings. By referring to clause Roman 6, subclause Roman 6 of Arabic 1 of Rule 5, page 117, he submits that the Hockey Karnataka has a duty to impose fine penalty, is a right to impose fine penalty or to take disciplinary action for violation of the act and rules. And it is for that reason that action has been taken. To buttress this, he relies upon clause Roman 5 of Bylaw 2, page 119, to contend that even the executive committee has the power to take a decision on indiscipline, misconduct, etc. As regards sanctioned and unsanctioned events, his submission by relying on Hockey India regulations relating to sanctioned and unsanctioned events, August 2019, is that an event would be any indoor or outdoor hockey match, tournament, competition, or other event at whatever level played, whether international, continental, national, or local, and including age group events such as masters events. And a page 157. And a sanctioned event is one organized or sanctioned by the relevant continental federation, national association, and or the FIH in accordance with the FIH regulations on sanctioned and unsanctioned events, including any event organized or sanctioned by Hockey India pursuant to clause B.2. His submission is that an unsanctioned event is an event which is not a sanctioned event. Therefore, in any event which is not sanctioned, if any of the players were to participate, then that would be an unsanctioned event requiring the Hockey Karnataka to take necessary disciplinary action to maintain discipline and decorum in respect of this national game, in respect of the national game of hockey. By referring to a letter dated 25th February 2026 issued by Hockey Karnataka, his submission is that only the tournaments which have been listed in those in that letter are sanctioned tournaments. Any other tournament is not sanctioned, and therefore in the present case the tournament in which the petitioner admittedly have participated, being that conducted by KSHA, not being sanctioned by Hockey Karnataka, it remains an unsanctioned event requiring disciplinary action. Though there was no letter or notice issued to the petitioners, his submission is that a letter had been issued to the Senior Welfare Officer, Comptroller and Auditor General of India, clearly stating that the petitioners had participated in KSHA B division, A division, and Super Division league matches representing different private clubs which were not sanctioned, and as said, the petitioners would not be eligible to participate in the tournament to be held by the respondent, by Hockey Karnataka. He also relies on the newspaper clippings which have been produced at Annexure R11 to contend that there is no dispute as regard the petitioners participating in an unsanctioned event. Once there is no such dispute, the question of any inquiry would not arise, since there is an explicit bar on the petitioners participating in any unsanctioned events. There being the facts being clear, the only eventuality would be to take disciplinary action against the petitioner. Even the question of issuance of notice would all be perfunctory in nature, inasmuch as there cannot be any defense which can be placed on record by the petitioners. Therefore, he submits that the respondents have taken action to hold the petitioners ineligible, since they had admittedly participated in unsanctioned events. On that ground, he submits that even if the principles of natural justice have not been complied with by Hockey Karnataka, the same would not inure to the benefit of the petitioners, inasmuch as the petitioners cannot be said to have any defense in respect of the participation in an unsanctioned event. On that ground, he submits that the above petition is required to be dismissed. Heard, Shri Somana Learned Counsel for the petitioner, Shri D.R. Ravishankar, Shri Udit Dedia, Learned Counsel appearing for Hockey India.
Yes, my lord.
That, sorry?
I didn't mean to interject, sorry.
For Hockey India, would also support the submission of Shri D.R. Ravishankar, Learned Senior Counsel. He further submits that the responsibility of Hockey India to discipline its players is in respect of the national and international events. The respective state units would have to maintain discipline in respect of their respective state units. He also submits that players cannot participate in unsanctioned events. And in that regard, he submits that Hockey Karnataka has necessary powers to take action against any indiscipline by any particular player. Heard, Shri Somana KP Learned Counsel for the petitioner, Shri D.R. Ravishankar, Learned Senior Counsel for respond number 1, Shri Udit Dedia, Learned Counsel for respond number 3. The arguments which have been recorded above is for the sake of completeness, since all these arguments have been advanced. The issue that is relevant for the present matter is quite simple, inasmuch as whether there would be an automatic ineligibility or disqualification of a player on account of participation in an unsanctioned event. The regulations relating to sanctioned and unsanctioned events, August 2019, published by Hockey India, more particularly B bracket 1.2.1, only mandates that organizations or individuals bracket including athletes, technical officials, umpires, coaching or management staff bracket close is automatically ineligible for 12 months who is found to have participated in an unsanctioned event is automatically ineligible for 12 months thereafter to participate in any capacity in any international event. This automatic ineligibility is only restricted to an international event and not to any domestic event. Clause 1.2.2, B 1.2.2 provides that disciplinary consequences could be imposed on any person under any such athlete under the Hockey India Disputes and Grievance Redressal Committee for breach of clause B 1.1. This makes it very clear that if there is a default of any player participating in an unsanctioned event in a domestic or a national tournament, a domestic tournament, including district, national, etc., proceedings have to be taken up under by the grievance disputes and grievance redressal committee. There is no automatic ineligibility or disqualification in relation thereto. The procedure to be followed by the dispute and grievance redressal committee has been extracted here and above, which require that on a complaint being received or a suo motu reference being made, a notice would have to be issued to the respondent. 2 weeks' time has to be given to the respondent to reply to the said notice. Thereafter, on compliance with the principle of natural justice, orders could be passed by the committee. In the present case, no such action has been taken by the committee. In fact, from the records which are available, it does not even appear that any such suo motu reference has been made to the committee. When no such reference has been made, let alone an order being passed by the dispute and grievance redressal committee, the question of unilateral holding of the petitioners to be ineligible or disqualified to participate in a domestic tournament would not arise. It is but required that insofar as domestic tournaments are concerned, the procedure under clause 1.2.2 B 1.2.2 is required to be followed before coming to a conclusion that any player is ineligible. Whether the petitioners would have any defense or not to have participated in the said tournament cannot be a ground which can be considered by this court at this stage. That would have to be considered by the dispute and grievance redressal committee on appreciation of the defense which may be raised by the petitioners on issuance of a notice. The procedure being clearly specified, it is that procedure which is required to be followed. Without following such procedure, the Secretary General, by way of the impugned letter dated 18 June 2026, could not have held the petitioners to be ineligible to participate in the league championships. In that view of the matter, as again aforesaid, though there are several arguments which have been advanced, it would be for the grievance redressal committee to consider those arguments if and so placed before the committee. As such, this court passes the following order. Writ petition is partly allowed. A mandamus is issued directing the respondent number 1 to permit the petitioners to participate in the 10th Hockey Karnataka League Championship 2026. Liberty is reserved to respondent number 1 to initiate such disciplinary proceedings as may be permissible under the relevant rules and regulations.
My lords, one clarification, my lords.
Yes.
My lords, the submission of the learned senior was that they will adopt the bylaws, and wherever it reads Hockey India, it should be read as Hockey Karnataka.
Yes.
So my only one request, prayer for clarification, my lords, is that when my lord says the disputes redressal committee, my lords may of the state association, my lords may just clarify.
Yes.
Because
you are right. You are right. The dispute redressal committee of Hockey Karnataka.
Yes, yes, obliged, my lords, obliged.
We have directed you to be permitted to participate. Withdrawal will not be sufficient. What will withdrawal do? You want only withdrawal? We have directed you to participate.
My lords, I undertake to file wakalat for respondent number 3, Hockey India.
Okay. Fine. Yes.
Much obliged, my lords.
Matters.
The respondent shall act on the printout of the, you will act on the printout of the operative portion of the order without insisting on the entire order.
Passed over matters. List number 1, serial number 9.
Yes, madam. Shall not. Now, what does this order say? It only says that if an application is made, applications assailing or seeking the recall, suspension or modification of LOC. Assailing is challenging, seeking the recall is already issued, suspension of something already issued, modification of LOC. Here the magistrate has issued the LOC because you have violated the bail conditions. Correct.
So the directors have no any right because of this direction.
Yes, now you have violated the bail conditions.
But that bill is cancelled and the application is pending.
Huh.
Now LOC is still pending, it is there, and then he will not be able to.
Because you were absconding, they were right in issuing LOC. You abscond from this one, violate the bail and no LOC should be issued.
All the cases where there is NPW pending, they started issuing LOC and there are so many cases coming at the.
Yes, but earlier people were not going out of the country. They were all within the country. Now people are going out of the country. That is why LOC is required to be issued.
He has not gone, he has gone for employment.
Madam, you have violated the bail condition.
For that bail is cancelled.
So now you have been arrested. You will have to go before the court seized of the matter to get a fresh bail.
That I have filed.
Yes, once you get that bail, you will be released. Then
Because this order, but I have filed it there.
how is this petition maintainable?
This petition I am seeking a lifting of LOC so that he can go and resume.
Yes, petitioner is before this court seeking for the following reliefs. Proceedings have been initiated in crime number 76 of 2022 for offences under section 392, 397, 307 of the IPC against the petitioner are pending before the 6th Additional District and Session Judge Mangalore DK in SC number 141 of 2024. Another crime is also there.
No, that is
Only 141 is there.
7201. He has thrown the phone into water.
Yes. The petitioner was arrested in the said matter and enlarged on bail on 27/2023. A charge sheet having been filed in the proceedings, the petitioner having left the country without seeking permission from the court, apparently to secure a job and earn his livelihood in Oman, a LOC, a lookout circular, came to be issued by the respondents. A warrant also came to be issued by the trial court. When the petitioner landed in Calicut on 31/5/26, the LOC was executed. The petitioner was arrested and taken into custody. Pursuant thereto, the petitioner has filed an application for bail in SC number so and so, which came to be rejected on 15/6/26. The petitioner is before this court now contending that the LOC has to be lifted so as to permit the petitioner to travel to Oman to resume his duty there. In my considered opinion, in the considered opinion of this court, the above petition is completely misconceived, inasmuch as the reason why LOC was issued was on account of the petitioner not violating the terms of the bail and traveling out of the country without permission being taken from the concerned court. On the return of the petitioner has been arrested by executing the LOC. The LOC has in effect spent itself on his arrest. Thereafter, the petitioner having been taken into custody a bail application filed is also rejected by the trial court. When the bail application is rejected, you'll have to challenge that district court has rejected it. You'll have to come to the High Court seeking for the bail. We can't advise you what you have to do. Yes, do all that. You can't come like this.
No, that bail application is pending. This is for LOC only. If your lordship rejects-
LOC has spent itself, madam, because that warrant is done. LOC is spent itself.
Yes, but now if your lordship rejects it, you cannot go out of India and earn his livelihood.
LOC has spent itself. LOC was issued because you violated and a warrant was issued.
Unless there is a direction from this court.
That is what we'll observe. That is what we'll observe. LOC cannot be in perpetuity.
The trial courts will not maintain any application if you filed before them because of this judgment of this honorable court.
Yes. Yenama bantu. Rejected. The LOC having spent itself, it is for the concerned court to assess whether bail has to be granted to the petitioner on his violation, and if such bail is granted and permission to travel abroad is granted by the court, it is only then that the petitioner would be able to travel abroad. Without such permission from the trial court seized of the matter, the petitioner cannot, by filing the above writ petition, seek for a mandamus directing the respondent to permit the petitioner to leave the country and travel to Oman. No grounds being made out, petition stands dismissed with the above observation.
In case he filed for permission,
Which that the court will, that is what we said, the court will have to assess.
any application in this.
Then you come to the High Court on a bail, madam, not like this. Yes, madam. IA 1 of 26 is allowed. Yes, next.
17, RV Jayaprakash.
Mr. Jayaprakash. None appears for the petitioner, though called twice, once in the forenoon and once in the afternoon session. If none were to appear, dismissal relist on 30th.
Serial number 23. Ranganath MEA.
My lord, there are two freezing. One is 4,750, another one is 535. In all total 5,288. The amount lying in the account is 26,000.
Every money, every penny is important.
This amount is lien what?
Petitioner is before this court seeking for the following reliefs. The entire account of the petitioner having debit frozen, the petitioner had approached this court. Notice having been issued to the respondent bank, respondent Sri Francis Xavier, Learned Counsel, appearing for respondent number 3. Submit that there are two orders which have been received by respondent number 3.
One is at
an amount of rupees
4,750. 4,750.
4750 and the other for?
Another being 535. 535.
535? 5. Totally amounting to?
5,287.30. 88 round it up.
Point ಹೆಂಗ್ ಬಂತದು?
30 ಪೈಸಾ ಇದೆ.
4750
plus 536.
536 ಅಂದ್ರೆ it can't be point ಏನು ಬರಲ್ಲ. Round figure. Round number.
4,750 37 paise.
ಅದೇ.
Paise.
537.30 paisa.
537.30 paise. Totally amounting to rupees?
5,287.30 paisa.
287.30. If that be so, the respondent bank could not have debit frozen the entire account of the petitioner. The bank could have only marked a lien in respect of the orders which had been received by respondent number 3. Hence, this court passes the following order. Writ petition is partly allowed. The respondent number 3 bank is directed to defreeze the account of the petitioner and permit the petitioner to operate his account maintained with it, subject to marking of a lien on an amount of rupees 5,000 so and so.
Yes. Much.
Within a period of 7 days from the date of receipt of copy.
Much.
24, Kalyana.
Yes, Mr. Kalyan. Fresh matter. Yes. Your claim has been rejected. Did you file an appeal?
Appeal, now about case number 243. The petition is filed, it's pending consideration before this one.
243. What is that writ petition for?
That petition will challenge the tender notification. Where not the subject, the final, the suit would be subject to the outcome of the final decision of the country.
And AGA accepts notice for respond number.
Government is not
party,
a
yaar idu?
MESCOM.
Badri and Ashwin ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ. You have to give us a name.
Badri Vishal.
Badri Vishal. Shri Badri Vishal is directed to accept notice for respond number 1 and 2. Connect the above matter with WP number 6433 of 2026 and relist on 3rd August. 31st July. IA 1 of 26 is allowed.
25, Sridhar Prabhu.
Yes, madam. What is the amount?
Sir, I am for respondent 2. I bought the documents.
ಕೊಡಿ. ಎಷ್ಟು ಆರ್ಡರ್ಸ್ ಎಷ್ಟಕ್ಕೆ ಬಂದಿದೆ? What is the order for marking lien?
Just now they came in. 23rd, no, 2023.
They only they have directed the entire account to be debit frozen and documents furnished. That is not something that we can look in here. This is again outside Karnataka, is it? Yes, Ghaziabad. The Council for Respondent has filed a memo along with documents. On the basis of said document, she submits that a requisition has been received to debit freeze the account of the petitioner and provide details by the first respondent. The second respondent bank has acted in terms thereof. Released on 10th July. How can we grant the interim order, madam? There's a order passed by them. We'll get those details when on 10th we have the other matters.
Serial number 30, Pawan Chandra Shetty.
I appear for the respondent 6 in this matter. My lords, I've sought instructions.
We have sent the proposal.
So what is this?
My lords, this is a matter regarding the forest management plan.
Huh.
My lords, it has been put up for approval.
They have sent it.
Yes.
Okay.
It has been put up for approval.
Huh.
Your lordships may have it after 2 weeks, my lords.
What Ms. Nayantara BG has entered appearance for respondent
number 6.
6. Registry is direct delete the name of Sri Shanti Bhushan.
My name is already there, my lords.
We're now deleting Shanti Bhushan. The DSGI is that are paying for respondent number 6. On instructions, she submits that a proposal has been received.
Yes.
From the state government and will be considered.
Yes.
Given 2 weeks time. Relist on 28th July.
Very well.
It's a short date, 2023. I'm waiting.
Government of in 2 weeks, they'll take time.
Serial number 33, Vinay Kuttappa.
Yes. ಏನಾಯ್ತು?
It is typically not agreeable. 17 lakhs is the amount is there. They want to settle only for 10.
When will you get ready and address it?
Or alternately, I've also offered my learned senior, because now 3-bedroom flats are not available in our inventory. I said I can even give a 2-bedroom flat and the difference at the same rate would work out to only 9,000. That time she paid 7 or 8 and it was 30 lakhs. We did not challenge, it was ex parte. Now we are in execution.
Settlement is between both of you.
Well, we can,
whatever you agree upon.
yes, we can work it out, Manoj,
You
but
can have a few more cups of coffee and decide on it.
certainly.
If there is some in final, we can do something, we'll involve.
Certainly.
Otherwise, it's between both of you.
Even there was 2 years interest also not claiming. Further 2 interest also we are not claiming. We are claiming only.
We are not telling you what to do, what to accept.
Yes,
It's
ma'am.
between both of you.
Yes, ma'am.
If you're acceptable, we'll record the settlement. Otherwise, you argue the matter, we'll.
In fact, my learned senior asked me, is the flat still available? I said 3-bedroom is not available, 2-bedroom is available. If the client comes
Also
forward,
work out, if it's convenient for us, they are ready to pay that amount.
The requirement of the family, we don't know. So whatever you see.
yes.
Can it day after tomorrow, next week? Can it call day after tomorrow or next week?
We'll give you 10 days time, see if we can settle.
Please,
If you don't, then argue the matter.
Please, ma'am.
Both the councils submit that they have explored settlement. The council for respond number 2 would however submit that the terms are not agreeable for respond number 2. Terms proposed by the petitioner are not agreeable for respond number 2. Relist on 21st July. If compromise is not reported by then, both the councils are directed to get ready and address their arguments.
Please,
still then interim.
Interim order earlier granted is extended till next day.
Much obliged.
35, Venkatesh Sarbati.
Direction reached FIR. Annexure M is the complaint. Annexure Q is the reminder against the officials of MUDA. Lordship could direct that I can approach the jurisdictional magistrate court by filing private complaint.
All non-cognizable.
Illa, cognizable. Annexure M and Annexure Q. I've given Annexure M.
ಹೇಳಿದ್ರೆ ಗೊತ್ತಾಗಲ್ಲ ನಮಗೆ. Page number.
Page 130. But in relation to my properties, not the mahazar drawn by the Tahsildar is not a forged mahazar is my case. And thereafter, I've sought and got a report from the forensic lab. It's a private lab. It shows that the mahazar is forged. So I had filed this complaint, but the police has given an NCR. Your Lordship could dispose of this petition by reserving liberty to approach jurisdictional magistrate by filing private complaint.
Petitioner is before this court seeking for the following reliefs. On a complaint being filed by the petitioner.
Annexure M, page 130.
Dated
17/1/24.
17/1/24. A NCR came to be issued by the respondent. It is in that background that the petitioner has sought for the aforesaid relief. The petitioner can always approach the jurisdictional magistrate seeking for appropriate relief. Reserving liberty, the petition stands disposed.
38, Nandish Patil.
Milord, I appear for the petitioner, Milord.
Nandish?
Milord, it's a writ of mandamus, Milord.
The other side is not here. It was adjourned in the morning. Did you inform them?
I've informed them, Milord. The Lordship may have it next week.
It will be on the same date that we had given in the morning. No change.
49, Vikas M.
Your Lordship, I'm the petitioner mother.
Yes.
Your Lordship, the prayer in this petition is a declaration that the right to privacy is a fundamental right under 21. And therefore, my lord, there is no question of a disputed question of fact, my lord. It is declared by a 9-bench judge.
It is, Mr. Verghese, but who is responsible? You are asking for 1 crore as compensation.
Yes,
You will have to establish that you have had a damage of 1 crore.
yes, my lord. My lord, I will establish, let them produce the report. One
Instead of
kindly
1
see-
crore, you could have asked for 100 crores. Or you could have asked for 1 rupee.
No, that amount, my lord, I leave it to your lordship, my lord.
We can't decide on it without you establishing that damage is
We will
costly.
establish, my lord, let them produce that report, because kindly see page 112.
My lord, 28, my lord, DPDP Act.
112, my lord.
I have given the circular, Act.
112.
Yes.
Yes. Yes.
My lord, 111. Sorry. My lord, kindly see the last reply they gave me. Thanking you for contacting us, we regret the inconvenience caused. We communicated to you by the mail that the issue regarding the sharing of your account information has been taken up by the investigation for technical team. We shall inform further detail after generating report. Please be in touch with the branch mobile. Meanwhile, kindly share the details of the information disclosed to the third party to assist the investigation to identify the culprit. My lord, they had held this inquiry and got the report, my lord. That thereafter, your lordship was
But
not.
a writ petition is not maintainable for this, Mr. Verghese. These are, your contention is that there is an intermediary, the bank has given the information, and your violation is of the DPDP Act.
Yes, because after
DPDP Act has its own
no, my lord,
regulations.
that act, let me say, that act has never been implemented. They themselves say in their reply.
And now it's been implemented. DPDP.
No, now, my lord, not at the time when I filed it, my lord. My lord, then the
Then
second
the
is, my
DPDP
lord.
Act would not be applicable at that stage.
Yes, my lord, even that is still not fully implemented. It is
Correct. Some of
27.
them have been implemented.
Yes, my lord, kindly see they have their own policy on this. That is that page 122.
We cannot determine here how much money is to be paid to you on this kind of a matter. If
My lord, that
you have
is
to avail of,
that is discretionary, my lord. But we have to be paid some compensation once it is decided.
you are agreeable for whatever compensation we say.
My lord,
You are agreeable for whatever compensation we say. You won't be. They also
whatever
won't agree.
compensation your lordship will give, we are ready to accept.
They
my lord.
also won't agree. This is a disputed
We are
question.
ready, my lord. We have no problem.
How do we say anything, Mr. Verghese? Do we say
But
10,000? Do we say 10
quantify at
lakhs?
the time of hearing, let them produce the report. Who did it? Why are they doing?
What is
My lord,
the
they are
point?
asking 4 entries.
What is the point? You are asking for 1 crore from each of them. We cannot decide that on that basis. Can we decide it? There's not a roving inquiry to be conducted. You file a civil suit. We won't say what you have to do, what
My
you
lord,
have to
there
do.
cannot be a suit filed for a.
Whatever you want to do, you could do, but we cannot decide a compensation matter here. If the public duty, public authority like BBMP, something, we can decide, not this.
My lord, my respectful submission is, when a fundamental right is violated, no suit can be filed.
You are claiming compensation on account of your
Yes,
violation of
for
privacy.
violation of fundamental right, no suit can be filed, my lord.
You want to have a luxury litigation, you can wait here for however long you want. It's your wish.
Their case is that I have
We'll ask
committed
them to
fraud.
file their
My
objection.
lord, let them file.
File your objection.
We filed my objections, my lord.
File your objection.
My lord, their case is that
also the
I
report
may
your
permitted to
lordship
read
has-
para 8 of the government's.
You won't be asking them to file anything that they don't file. Don't ask us for that. This is not a rowing inquiry.
Your
Please
lordship has
understand
already directed them to file.
If you want to address arguments on the basis of the documents which are there, please address arguments. Don't
So let
ask
them
us to
file the
say.
objection, my lord.
We have filed objections.
Filed
Our copy to
objections.
No,
We have filed, given the copy. My lord, their case is that I have committed
Filed
fraud.
objection on 7/3/26.
Yes, my lord.
no, no, I'll file a rejoinder to that and let's.
Counsel for the petitioner, despite having been brought to notice that this court may not be in a position to assess the damages claimed by the petitioner, insists that this matter be taken up by this court, since a violation of fundamental right is alleged. He seeks for and is granted 2 weeks' time to file his rejoinder to the statement of objections filed, released on 5th August.
Their case is that I have committed fraud, cheating, misappropriation, breach of
But
trust.
can it be 4th August? There is another matter in this.
4th August.
Yeah. March of that.
First our matters, list number 2, serial number 1, Varun J. Patil.
So the
Now you are there,
petitioner-
Mr. The Kumar is not there.
There are two, this thing,
Professor Kumar.
dated 1/7,
Not in their absence. Not in
ಅಲ್ಲಲ್ಲ absence ಇದು ಅದು ಮೆರಿಟ್ ಇಂದಲ್ಲ 1/7 ಮತ್ತೊಂದು ಆರ್ಡರ್ ಮಾಡಿ 6 ತಿಂಗಳು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿದ್ದಾರೆ. ಸೊ ಐ ಆಮ್ ಮೇಕಿಂಗ್ ಎ ಫಾರ್ಮಲ್ ಅಪ್ಲಿಕೇಶನ್
for another amendment.
Another amendment to quash that. That is one.
But where is Professor?
Senior counsel is on the way.
On the way.
We have placed a statement of objection. We even served the copy.
You served a copy.
Yes, my lord.
Or copy serve ಮಾಡಿ ಅದರಲ್ಲಿ ಆರ್ಡರ್ ಕಾಪಿ
You can serve this
ಅಲ್ಲ
copy.
ಅದನ್ನು ಕೊಟ್ಟಿದ್ದೇವೆ.
ಬಂದ್ರಲ್ಲ.
Just a continuation of
Lord Counsel for the petitioner has filed an application for further amendment challenging the extension of the term of the appointment of the administrator. The same is taken on record. Any objections, Professor Kumar?
No objection. Maybe
The said application is allowed since it's only a continuation of the appointment of an administrator.
Please.
Counsel for the petitioner to carry out necessary amendment, file amended petition. Statement of objections have been filed by respondent number 5. The same is taken on record. Yes, Professor Kumar. Yes, please.
There are 4 orders now under challenge. All the 4 are issued under section 27 capital A. The first one was issued on 3 grounds. Number 1, he refused to cooperate with the inquiry.
Yes.
Number 2, the allegations made against him were very grave, and delaying the inquiry is not in public interest. Number 3, it is necessary to get the documents by appointing a administrator. These are the 3 reasons given, and the administrator came to be appointed. This happened on 30th September 2025. Now thereafterwards, as the inquiry was in progress, the second order came to be passed. Annexure N. First one is annexure M. Second order. This came to be passed on the ground that the inquiry is almost is concluded, and the inquiry report needs to be presented before the Honorable High Court, and to take necessary action on the basis of the report. That is the ground on which second order came to be passed. The third order dated 31/3.
Second order was, what was the date?
Date on 30/12/2025.
30/12/25. Third order?
Third order dated 31/3/2026.
Yes, please.
The fact that action by report has been presented was taken note of, and the fact that the grave allegations made against the petitioner were proved, and with proved misconduct,
proceedings have already been initiated for surcharge proceedings to recover a huge amount from the petitioner and his colleagues.
And his colleagues.
And his colleagues.
That you'll have to show us. Because the submission of Mr. Patil is only against the petitioner it's been initiated, not against others.
I'll demonstrate.
That
Yes,
document
yes,
will have to show.
I'll demonstrate. And last but not the least, that action is being contemplated in the light of the inquiry report to take disciplinary action under bylaw number 7 for proved misconduct. So these are the 3 orders which were initially passed, and the present order now passed on 1st July.
The 4th order passed on
1/7/2026.
Yes. This is to hold elections.
Yeah.
Extending up to 6 months.
It is just now.
Just to extend.
Yeah, just now allowed to be placed on record. Now this is
the 4th order is for what reason?
Yeah, 4th order. I'll give the reasons. ವಿಚಾರಣೆ ಪೂರ್ಣಗೊಂಡಿದ್ದು ವರದಿಯನ್ನು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಲಾಗಿದ್ದು ಕಲಂ 25ರ ವಿಚಾರಣಾ ವರದಿಯಲ್ಲಿನ ಅಂಶಗಳು ಸಾಬೀತುಗೊಂಡಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಕರ್ನಾಟಕ ಸಂಘ ಕಲಂ 26 ಅಡಿಯಲ್ಲಿ ಅಧಿಭಾರ ಪ್ರಕರಣ ಅಧಿಕಾರಿಗಳು ಸಮಕ್ಷಮದ ದಾಖಲಿಸಿರುವುದರಿಂದ ಕನ್ನಡ ಸಾಹಿತ್ಯ ಪರಿಷತ್ತಿನ ಬೈಲಾ 7879 ಅನ್ವಯ ಮಾಜಿ ಅಧ್ಯಕ್ಷರಿಗೆ ಕಾರಣ ಕೇಳುವ ನೋಟಿಸ್ ನೀಡಿ ವಿಚಾರಣೆ ನಡೆಸುತ್ತಿರುವುದರಿಂದ ಹಾಗೂ 25ರ ವಿಚಾರಣಾ ವರದಿಯ ಮೇಲೆ ಕ್ರಮಗಳು ಜರುಗುತ್ತಿರುವುದರಿಂದ ಸಂಘಗಳ ನೋಂದಣಿ ಕಾಯ್ದೆ 1960 27A ಅನ್ವಯ ಆಡಳಿತಾಧಿಕಾರಿಯನ್ನು ವಿಸ್ತರಿಸಲಾಗಿದೆ. And I may add to this the reason why he has already been placed under suspension, but this honorable court has injuncted the administrator from implementing it unless clearance is given from this one. So necessary application has already been made in that matter where there is an interim order preventing implementation of the punishment that is imposed against.
There's one other matter apart from this?
Yes. That's
yesterday. But this was filed later.
There an application has been made for permitting the imposition of the punishment, which has already been passed. So it is, it was not stated.
So got it connected. Both of them, if they are pending.
No, it was not connected. It was posted.
Other connected matters we have disposed.
It was not connected. It was posted yesterday before this honorable court, but it did not reach.
Okay. Then we'll have to connect and take it up together. Because if...
Of course, for disposal of present petition that may not come in the way, in any way. But I have no objection for that matter being taken up. But
same argument will be advanced twice over.
It would be independent. It may have to be considered independently because something about the administrator, he passed an order of dismissal. Then he withdrew it and now he has passed an order of suspension. Something which he has no authority as such, but that may not come in the way of this petition being there.
The fact is he is punished with, according to the bylaw, he is liable to be placed under suspension. He has been placed under suspension. And that was
both the matters to be taken up together or separate?
Together. It is because we'll be addressing the arguments will be almost common to.
Then we'll post it tomorrow with, connect with WP number. Write it down.
60.
So and so.
6086.
Tomorrow at 2:30 p.m.
Would it be on Friday?
Friday, 10th. Friday we have some parted matters and we have that.
Or Monday.
What do you call it? The debit freezing matter where lot of issues are happening with everybody's accounts.
Any
being
day
frozen.
convenient to the court.
Tomorrow you're not available?
Not tomorrow, there is.
Not there. So 13th at 2:30 p.m.
Serial number 2, Suhas TN.
Hello, Jim. We served a copy. I think he was here and.
He was here.
Please.
Now where is he gone?
The copy as well.
Pavan?
So,
He's not here online. You're filing objections to the report.
in fact, detailing exactly this, my lord.
The counsel for the petitioner has filed a report as objections to the report submitted by respondent number 7 and 8. Our submission is that, yes, Pavan. They are filing their objections, but what they are saying is you have considered the 96 plan, not 9/1/2025 plan.
My instruction is that as per the DP, the constructions are somewhere not proper. So as per the original DP by BDA.
Correct. Now you see the orders which have been passed over a period of
Yes,
time.
my lord. In the affidavit also
Water
they have.
has flown from that time. There were some violations. We have got that demolished. There are some corrections which have to be done. Those corrections have to be done. The only whatever your penal action is to be taken, you take that. Only reason why we are trying to save this building is that there are 1,000 families which are being there.
residing. Either my suggestion would be either they apply for modified DP.
Correct.
with GBA, then it can be, all things can be considered.
That way they have submitted a modified plan.
The modified plan is already on record.
Is it submitted to GBA?
To BDA, it's already been submitted.
PDA
my
and
lord.
it's
It's submitted
The
to
record has
GBA.
Now been transferred to you.
Yes, my lord. If they make a fresh move to.
Fresh yenakappa.
Because it's in BDA, my lords. We don't have that papers. with us.
BDA has transferred its jurisdiction to you.
Jurisdiction has come because of.
So
because of the
papers would
Greater
have to,
Bangalore Authority.
all the files would have to be transferred to you.
Also part of the records before, my lords.
You will have to take the transfer of files, otherwise you won't be able to assess anything.
We will call from it.
If
from
they
BDA,
file a
we will-
fresh application, on what basis will you assess it?
Yes, we will instruct them to get it from the BDA and.
The BBMP and BDA have not, BBMP though has come with you. BDA has not transferred the files.
I don't have instructions regarding that, my lords. Whether they have transferred it or not. But the power and jurisdiction has come up with us now.
So anything within that area, within that jurisdiction, all the files have to be transferred to you.
I will take instruction, either we will get the files from BDA.
The submission, the counsel for the petitioner has filed objections to the report submitted by respondent number 7 and 8. However, our submission is that the verification has been made in respect of a 1996 plan and not the modification plan submitted on 9/1/2025. The counsel for respondent number 7 and 8 seeks for and is granted 2 weeks' time to verify if all the documents have been handed over by the BDA to the GBA on the jurisdictional transfer, and thereafter carry out the, comply with the directions issued by this court and submit a report. Released on 5th August.
Then we permitted to file this in the counter?
Yes, we have told you. We have recorded that already.
230 mood matter. Ravindra Babu.
Yes. Mr. Ravindra Babu. Pending matter, why was it?
Leave India notice
Which is-
didn't reach yesterday.
How many times we tell them not to move pending matters? Yes.
Enough, please.
20087.
Please, my lord.
Pending matter you have moved.
Please, my lord, because today my visa is expired, my lord.
Today it's expired.
Not today,
it has
expired. Yesterday, 7/7, date is there, my lord. I have
Expired already.
annexed, my lord.
Already expired.
ಏನಿದೆ?
Ink page 108K is the leave-in. India notice is issued by my lord, respondent number 3, my lord. My lord, from 2005 to 25, almost 20 years, I was on business visa in Mysore, my lord. I applied for business visa extension as well also conversion of business visa to X visa, my lord, which came to be, my lord, without expressing any reasons. I have not supplied any materials, and this notice came to be issued, my lord. Pursuant to this, my lord, again on 3/7/26, my lord, one more OM is came to issue.
LOC,
Please,
LIN has been
please, man, within 14 days to permit.
issued. To leave. You
Lord,
can't be
I
here.
was there from 20 years, as I have
It doesn't
located
give you
my.
a vested right.
Yes,
It
please, I
doesn't give you a
understand, my
vested
lord.
right.
Some
The visa
breathing
is
space to
expired,
be,
they've issued a
to
LIN.
shift my business, my lord, and some breathing space has to be located.
This is not an equitable jurisdiction.
I
or
totally understand,
discretion.
my lord. I am not on that point at all, my
Well,
lord.
we have no discretion. It is.
But all these are settled in Camolins.
No, please, I am not on any part.
We can't help you in this. Your pending visa, you can process it. And if
As
you,
on today, he has no visa.
No, my lord, I have
Yes,
already
he has
expired.
filed an
I am not-
application for X visa and
Has also
No,
been denied.
that-
That has
Lord,
been
he is
denied.
not entitled for the X visa because he does not have a living spouse.
correct.
that
Yes,
Lord,
this
he,
is
Lord, he is a Britisher. He came to India to do some training. He illegally started some homestay business in Mysore. So there were visa violations, and he got married to an Indian, and that marriage subsisted only for 6 months. And later she died. The Indian spouse died. So he was never entitled for that. During the course of the marriage, we had issued.
No, he had not issued the
Because he
externment
had not
order.
complete, he had not completed 2 years.
Widower is not entitled.
No, my lord, widower is not entitled to X1. There should be a living spouse, and that marriage should have completed 2 years. He did not meet both the criteria. There is no living spouse.
For academic knowledge, if marriage is completed 2 years and a widower would be entitled.
No, my lords. Even after
Widower is not
Yes.
entitled. Is dated 2/6/26, issued by respondent number 3 and 5 at Annexure K. The submission of learned counsel for the petitioner is that the petitioner has been living in India for last 20 years and as such ought to be permitted to continue to live in India.
That is also wrong.
Admittedly, the petitioner has been in India only on a visa, going back and forth between India and England
Business and
Business
tourist
session.
visa. Business and tourist visa. He used to
on
Avail
sometimes
only
on
those
business
two.
visa, sometimes on tourist visa. There's no vested right for any foreign national to be resident of India or to seek for a visa to be issued and kept operational by the Republic of India. This aspect has been dealt with in detail by this court in so at para
But I have attached only the relevant
17.
part.
At para 17.17 to 17.23, which are reproduced here under for easy reference. The right to visa and entry into the country, I mean, considered in Christopher Charles Camolin's. There's no vested right in any individual to continue to stay in the country. The FRRO has the necessary powers to issue a Leave India notice. Once such notice is issued, it is but required for the noticee to comply with the same. No grounds being made out, the petition stands dismissed. Liberty would always be available to the petitioner to file for such applications as may be permissible.
But he has to leave now because direction may be given to leave it.
If anything
He
else.
has to leave now.
He has to be-
14 days from the 3, the 17th.
Visa has already expired.
In his no-
When will you leave?
My lord, he is in Mysore. I will.
14 days you leave.
2 weeks, my lord.
The submission of the petitioner that petitioner will voluntarily leave the country in 14 days time from now, that is on or before 25th July,
I'm grateful.
is placed on record.
1 month is one voluntarily bad. I not have any instructions, my lord.
ಮತ್ತೆ ಇನ್ನೇನ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ಬೇಕು? If you say that, we can ask them not to take action. If you
1 month, I will ask him, please, my lord, because he has to.
Been issued on 2nd of June.
He's 70-year-old.
2nd of June.
My lord, it is come.
Just to wind up.
My lord, and he's a pension 70-year-old.
Oh, fine. In fact, some of the activities, my lord, that we have, the report that I got.
I understand, but he has bought some property, he has to sell the property, he has to do all of it.
And 70-year-old.
Be on a human basis.
The reports, my lord, what we have got against him, Lord.
Your Lordship may kindly have a look.
Please have a look.
Please
at,
have a look, Your Lordship.
He should leave the country immediately.
Field reports, anonymous letters, field inquiry reports.
These are in that Mysore house.
And we doing these kind of things. This is, India is not for doing these kind of offenses. We don't have strict laws for this. That is the problem. Pedophile laws have to be stricter. We can't exercise any discretion in these matters. We leave immediately. I think.
Leave immediately.
234 matter.
Please.
Nikhilesh Rao.
In fact, we are grateful to your lordship for the Campbell's judgment. It's being widely quoted across the country now. It has become the jurisprudence on Lynn now. We are grateful to your lordship.
You are the one who argued the matter, so you are the one who has developed the jurisprudence.
Ever grateful.
It's the lawyers who bring about, like Mr. Chinnappa also will bring about something now.
Mine is a very simple matter.
Very simple matter.
Actually, very simple.
Most times it is not.
Sometimes I come with complications which I am also grappling with, but this is on the face of it wrong. I am a food business operator, my lord. I have an FSSAI license.
Food safety standards. You are appearing?
I think my learned friend Mr. Jaffer is a
FSSAI has their own council. There is one Mr. Doreraju who would appear for
Doreraj appears for FSS.
Lordship may recollect that in the Neolacta you would have.
We served my learned friend Mr. Jaffer.
Commissioner of Food Safety is different from FSSAI. FSSAI is...
Commissioner of Food Safety is under FSSAI itself.
But the notice is issued
by the designated
FSSAI
officer.
is a separate authority. FSSAI is a separate authority on Food Safety and Standards Act.
Yes.
Mr. Doreraj appears for them.
Yes.
Mention Madhav.
I'm
You
sorry,
will find out Anta.
I didn't know, my lord.
Your instructing council has to know. You'll have it tomorrow. You serve it on.
There's one small problem. There's a prohibition order.
Yes, wow.
Can I'll just show you. I'll not take more than 1 minute. Please see page 125. I produced the act itself, there itself. What can be done by the designated officer?
Yes.
36 not as designated officer. 36(3). Functions to be performed by designated officer shall be as follows, namely B, to prohibit the sale of any article of food which is in contravention of provisions of the act. And rules and regulations made therein. That's the only power.
Yes.
And the power can be exercised, my lord, under section 34. Please come back to page 124, my lord.
124.
124, the 2 pages before, previous page. If the designated officer is satisfied that the health risk condition is
134?
34, section 34.
If the designated officer.
If the designated officer is satisfied that the health risk condition exists with respect to any food business, he may, after a notice is served on the food business operator in this act referred to as emergency prohibition notice, apply to the Commissioner of Food Safety for imposing the prohibition. If the commissioner is satisfied on the application of such an officer, health risk condition exists with respect to any food business, he shall by an order impose the prohibition. Designated officer shall not apply for an emergency prohibition order unless at least 1 day before the date of the application, he has served notice on the food business operator of the business of his intention to apply for the order. And in my case, all he's saying is, you are Swiggy.
Where is the impugned order?
Yes, Lord. Please, page 64. Page 64, my Lord. 65, my Lord, you will see is a designated officer. He
Passed
passes
by a designated officer.
It's by the designated office itself, not by the Commissioner for Food Safety. And the allegation is not of any food article. It says toying is a new app you've started. It is, I don't see it on the FSCI license, for which my lord he's issued a notice on the 4th. On the 4th, he issues a notice giving me 7 days time. On 6th, my lord, he issues a prohibition order himself.
Now this is under
36, your lordship will see 64, my lord, 36 3B. Just under prohibition order, issued under section 36 3B for a food article. There's not a single food article referred to in this order.
now you are a platform.
I'm a platform aggregator.
The provision relating to platform in FSSI.
My lord, but we have to obtain a license as a food that not regulations. Your lordship will
You
kindly
have
come.
to apply and obtain for separate licenses.
No,
for
no,
each
not
and
required.
every app, or what is what
No,
is
my lord, the requirement is you have to have a unified license. It's called a central license for the entity. It is not for the app.
which is the provision?
Yes, my lord. Please come to page 205. I've produced that regulation as well.
205.
205. 2.1, my lord, at page 206. All food business operators in this country shall be registered or licensed in accordance with the procedure laid down. Then, Lord, may kindly come to 2.1.9 at 209.
Yes.
Food business operators shall ensure that the registering or licensing authority always has up-to-date information on the food business establishments, shall inform the relevant authority of any modification or addition or changes in product category, layout, expansion, closure, or any other material information based on which the license was granted. Such information shall be conveyed before the changes occur.
Where is the license?
The license, my lord, your lordship will find is at Annexure A, page 52.
No, where provision relating to license?
Section 31, my lord.
Food business.
Section 31, page 120. Section
For a
31.
platform.
But there is nothing separately for a platform in that sense. All that is there is a food business operator. Can I request Manoj to kindly see page 94? The definition is there of food business
94.
operator. My lord will see food business also.
Yes.
And food business operator. Food business undertaking whether profit or not, carrying out any of the activities related to any stage of manufacture, processing, packaging, storage, transportation.
There's no separate rules for.
No, nothing. The one I showed you, that's all. And the license, and it's only under that provision, Lord, now I'm operating. And in the notice, not the extract, what are the violations, so-called. Not the difficulties, I've been given 7 days to explain for the same thing. On the 4th, they give me 7 days to explain. On 6th, he issues this prohibition order.
How do you come in food business then if you don't have a license?
I have a license.
Where is your license?
Annexure A. No, my case is not that I have a license, don't have a license. I have a license. He says I have a license. He says for toying, you've not incorporated that brand name. That's the allegation. My lord may see Annexure A, page 52, my lord. Central license. Category of license. The central license for the entire country.
So for what purpose is this?
My lord, carry on food business, page 53. This license is issued only to commence or carry on food business and not for any other purpose. Now, can I humbly request my lord to look at page 61 for a minute, my lord? Please see the allegation against me. The only allegation is this. Para 2 of that notice is sent by email to us. The records further indicate that transactions are being undertaken through the toying platform. Despite the absence of any documentary evidence demonstrating said brand or trade name has been duly endorsed in the FSSAI license, or that the licensing authority has been informed of such change in business particular. That's the allegation, not of any food article.
There's no particular app mentioned in the license.
In the license, not there's a mention of Swiggy.
Swiggy Limited.
Limited is there.
The name of the company is there, but is the app is not mentioned.
This app is not mentioned.
No app is mentioned.
Once app, no, app, my lord, it says Swiggy.
Where is
Brand name Swiggy. There's only requirement of brand name. 55, my lord, website address and brand name. There's no requirement to mention anything specifically. As a matter of fact, my lord, it's like, my lord, one place getting a central license and opening 2 outlets. It's as simple as that.
You can't have like that.
Why not?
Brand name is Swiggy. Now your brand name is Toing.
No, it's an additional one.
Additional one, apply for it.
But that modification, we have also made a request.
Apply for it. Once you get it, then you operate it.
But the requirement is, let me explain it to them. Please see the show cause notice. The show cause, my lord, violation is 2 lakhs fine.
Admittedly, ex facie, you don't have a license.
No, I don't require. That's
for
my
Toing.
case.
That we'll consider after they file their objections. You can't be opening different apps without getting a permission from that.
My lord, but please, can they issue a prohibition order?
We are in fact, we are going out on a limb here. There's no e-commerce rules. How are you coming as a food operator?
This is how it is, my lord.
Surprising.
No,
That
my lord,
anyway, we are
every single one of us have the same thing.
Subject matter of this.
Lord, Zomato, Swiggy, everyone has the same thing.
Shri
Lord,
Devraj BH. Shri Doreraj BH is directed to accept notice for respond number 1. And AG accepts notice for respond number 2.
We know, yeah.
Counsel for the petitioner to serve 2 sets of the petition along with annexures on the aforesaid counsels. Relist on 9th July.
Lord, how about the prohibition order? How can the prohibition order sustain, Lord?
Only in respect of toying.
Beg your pardon, Lord?
Only in respect of toying.
Toying.
Swiggy, you can continue.
No, but prohibition order is illegal.
You don't even have any permission to do it.
Prohibition order can only be passed. My lord,
show us
am I not entitled to explain myself, my lord?
Yes,
why is the show cause notice issued with me then? Show cause notice is issued giving me 7 days time.
Show us a place where you got permission to operate toying.
My lord, toying, in my humble submission, it is not required. Please see the requirement of the license.
The license only as Swiggy.
My lord, please see this. Can I take 2 minutes, my lord?
Yes.
I would not have trouble your lordships, not if I thought there was no case.
Yes,
and I've come, my lord, before your lordships with absolutely nothing.
Yes, please.
My lord, please see the show cause notice for a minute.
And you started by saying simple case.
I thought, my lord, it was. I'm sorry.
Yes.
My minutes.
Yes.
My lord, please see what the complaint is. The complaint in the show cause notice, my lord, is that I have violated these provisions. Section 26. Please see the first line just above section 26. The above facts, if established, indicate a prima facie contravention of the provisions Food Safety and Standards Act.
For admitting that you are doing toying.
Yes, my lord, but my whole case is
you have nothing to say that you can do toying.
My whole case, my lord, is the requirement of a central license is for the entity. It is not for a particular brand name.
That is why we asked you.
That is why,
please it is there at page 55. Brand name is Swiggy.
Yes, Swiggy. Please grant me 1 minute. It is not a scenario of that kind. Please see what he says. It's my lord, the permissions of the licenses are not given for brand names. Permission is given to the entity to run a food business operating business. There is nowhere in the regulations or the rule or requirement that it has to be in only that brand name.
We'll verify from them as to what it is.
That is one
nothing
part
is
of
going
it.
to happen to you.
No, please see it. One part of it. There are different sets of customers, different restaurants, all of whom are onboarded on the toying app.
We'll consider it tomorrow. Once they come, we'll ask them.
Please permit me, Lord, 1 minute.
At present, we are not convinced on this. We are being given a license for Swiggy.
Lord, Swiggy is not. It's not a license for Swiggy.
Brand name.
It's not a license for Swiggy, my lord. It's a license for the entity.
So you want us to reject your order, the interim prayer
Lord,
now?
can I take 1 minute?
Yes.
Can the prohibition order sustain, Lord? Please see this. The prohibition order at page 64, can it sustain?
It can. You want us to give the reason for that?
On the basis of 36(3), my lord?
Yes. Because you don't even have a license. You won't. Toying is not a food operator. It has no license.
Toying is nobody. Toying is a brand name, even according to them. Please see what they say. Please see, my lord, what they say. They say it is toying is a trade name. It is not, my lord, the name of the business. The operation of food business under trade name. They're not saying it's a different entity. If it is a different entity, of course, my lord, I have to obtain license. There's no doubt about it. And I would have done so immediately. I'm doing it strictly, my lord, within the license that is granted to me, because license is granted to the entity, which is also called Swiggy. Therefore, my lord,
according to that, you can have 100 apps.
You can have apps so long as the license exists. My lord, what happens is the license is the license which enables the entity to run the business of food operator. It does not matter what the brand name is. Tomorrow it may be Swiggy. I may stop Swiggy and start toying.
Aren't convinced for now.
No, but that is one part of it. But please see the order. This order can't sustain, Lord. 36(3) order can't sustain. Lord, which they have issued a show cause notice to me, called upon me to explain. I will explain, Lord. If I explain, fine.
And continue business till then.
But Lord, how is the prohibition order then sustaining?
Tomorrow. Release tomorrow.
My lord, serial number 82. Lords. Kindly have it tomorrow, my lord.
Tomorrow, my lord. 73, my lord, because I'm sitting for madam.
Whatever it is, when it reaches, we'll take it up.
Yes.
3rd August.
Madam, urgency ಇದೆ. Urgency ಇದೆ. ನಾಳೆ.
3rd August 40% ಮಾತ್ರ ಇರಿ ಅಷ್ಟೇ.
Mandamus cognizance ಅಲ್ಲಿ FIR ಇದೆ. Madam, at least next week ಅಲ್ಲಿ ಒಂದು
ಯಾವ್ದು ರೀಚ್ ಆಗಲ್ಲ, ಹಿಂಗೆ ಅವತ್ತು ಕಾಯ್ತೀರಾ, ಅದಕ್ಕೆ ಎಲ್ಲ 3rd August. 3rd August.
ಸೀರಿಯಲ್ ನಂಬರ್ 72 ಸ್ವಲ್ಪ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಮೇಡಮ್.
ಎಕ್ಸ್ಟ್ರೀಮ್ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
ಸೀರಿಯಲ್ ನಂಬರ್ 61 ಲೋಡ್ ಅನ್ಸುತ್ತೆ.
ಇದೆಲ್ಲ 3rd August.
ಲಾಂಗ್ ಡೇಟ್ ಆಗುತ್ತೆ ಮೇಡಮ್. ಸ್ವಲ್ಪ
ನಿನ್ನೆ 31st ಕೊಟ್ಟಿದ್ದೆ, ಇವತ್ತು
ಅಲ್ಲಮ್ಮ ರಿಟರ್ನ್ ನಾಟ್ ಮೇಟಮ್ 94 ಅದನ್ನ ಫ್ರೈಡೆ
ಸೀರಿಯಲ್ ನಂಬರ್ 61 ಆಗಸ್ಟ್ ಗೆ ಪರ್ಮಿಟ್ ಕೊಡೋದು ತಪ್ಪಿಸ್ತಾರೆ.
3rd August.
ಅಲ್ಲ ಮೇಡಮ್, ನಾವು ಆಗಸ್ಟ್ ಅಂತ ವೇಟ್ ಮಾಡೋದಕ್ಕೆ ಆಗಲ್ಲ.
ಮೆಮೊ ಹಾಕೋಬಹುದು, ಇವತ್ತು ಬಂದಿದ್ದಲ್ಲ ಅನ್ಸುತ್ತೆ.
22
ಹಾ ಅದೇ ತರ ಹೌದು.
ಸೀರಿಯಲ್ ನಂಬರ್
ಮೇಡಮ್ ಮೆಮೊ ಹಾಕ್ಬೋದು, ಹೋಗ್ಲಿ ನಾಳೆ.
ಹೋಗ್ಬೇಕಾ?
ಸೀರಿಯಲ್ ನಂಬರ್
ನಾನ್ ಬರ್ಬೇಕಾ?
ಮೆಮೊ ಹಾಕೋಬೋದಾ ಮೇಡಮ್?
ನಮ್ಮ ಆ ಕಡೆ ಸರ್
ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅದಕ್ಕೆ.
ಅದೇ ಅದು ಅವ್ರು ಹೆಂಗ ಹಾಕ್ತಾರೆ ಹಂಗೆ ನೆಕ್ಸ್ಟ್ 3rd August
ಅಲ್ಲ
3rd August ಎಲ್ಲ 3rd August.
ಅಲ್ಲ ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಮೇಡಮ್,
ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ರು ಬರಲ್ಲ ಸರ್, ರೀಚ್ ಆಗಲ್ಲ. ನೀವು ಯಾರಾದ್ರೂ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ 2:30 ಗೆ. ತುಂಬಾ ಅರ್ಜೆನ್ಸಿ 14% ಮಾತ್ರ ಇರಿ ಅಷ್ಟೇ, ಮಿಕ್ದವರೆಲ್ಲ 3rd August.
ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ.
ಯಾವುದು 68 ನಿನ್ನೆ ಆಗಿತ್ತಲ್ವಾ ಡಿಸ್ಕಷನ್, ನಾಳೆನೂ ಹಿಂಗೆ ಆಗುತ್ತಪ್ಪ, ರೀಚ್ ಆಗಲ್ಲ. ನಾಳೆನೂ
ಮೇಡಮ್ ಸ್ವಲ್ಪ ನಾಳೆ ಏನಾರು ಆಗುತ್ತಾ ಮೇಡಮ್?
ಆಗೋಗಿತ್ತು, ದುಡ್ಡು ಬಂತು. ಅಲ್ಲ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಾ? ಎಲ್ಲ 3rd August.
ಮೇಡಮ್ ನಾಳೆ ಏನಾರು ರೀಚ್ ಆಗುತ್ತಾ ಮೇಡಮ್? ಸೀರಿಯಲ್ ನಂಬರ್ 70% ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಇದೆ.
ನಾಳೆ ಬೆಳಗ್ಗೆ ಬಂದು ಮೆಮೊ ಹಾಕೊಳ್ಳಿ, 2:30 ತಗೊಳ್ಳಿ, ಅವಾಗೆಲ್ಲ ರೀಚ್ ಆಗಿದೆ.
ಮೇಡಮ್ 59
3rd August
27
3rd August ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್
14%
14% ಮಾತ್ರ ಬಂದು.
ಸೀರಿಯಲ್ ನಂಬರ್ 99 ಮ್ಯಾಮ್.
3rd August
ಮೇಡಮ್
64 ಸೀರಿಯಲ್ ನಂಬರ್.
ಮ್ಯಾಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 99 ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದೆ ಮ್ಯಾಮ್.
ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಮೇಡಮ್ ಅದು.
ಥ್ಯಾಂಕ್ ಯು ಮ್ಯಾಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 70 ಸೀರಿಯಲ್ 70
ಎಲ್ಲ 3rd August.
ಸೀರಿಯಲ್ 70 3rd August ಸೀರಿಯಲ್ 70 ಮೇಡಮ್ ಸೀರಿಯಲ್ 70 ಸೀರಿಯಲ್ 3rd August
ಪಟ್ಟ ಕೊಡ್ತಾರೆ ಡೇಟ್.
ಇಲ್ಲ ನನಗೆ ಹೇಳಿರೋ ಡೇಟ್ಸ್ ಅದೇನೆ, ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ನಾನು ಅದನ್ನೇ
ಮೇಡಮ್ ಸೀರಿಯಲ್ 70 is 3rd August
ಡೈರೆಕ್ಷನ್ ಇದೆ.
ಮೇಡಮ್ can you hear me madam?
3rd August
ಸೀರಿಯಲ್ 70
3rd August ಬರುತ್ತೆ ಸರ್.
3rd August ಅರ್ಜೆಂಟ್ ಇದ್ರೆ ಮೆಮೊ ಹಾಕೊಳ್ಳಿ ಸರ್ ನಾಳೆ.
ನಾಳೆ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್. ಅದೇ ಗೊತ್ತಿಲ್ಲ, ಅದಕ್ಕೆ ನಾನು ಹೇಳೋ ಡೇಟ್ ತಗೊಂಡ್ರೆ ರೀಚ್
ಆಗುತ್ತೆ ಅಷ್ಟೇ.
ಈಗ ನಾನು ಕೊಡ್ತೀನಲ್ಲ ಆ ಡೇಟ್ ಒಂದೊಂದ್ ದಿನ ಹಂಗಾಗುತ್ತೆ.